one application. Yes, may I get leave to move one?
Today there is
Lordship,
there is no date of mentioning.
Lordship,
today-
there is urgency. There is urgency, Lordship.
Come tomorrow.
My lord,
Day of mentioning. Mentioning is only Monday and Thursday.
My
my
point
lord,
going to be taken on 31st January, Lordship.
What?
By RDBI under RDBI Act
Ah,
by bank.
ah.
This is why this is the urgency, Lordship.
When the notice was issued.
Notice was issued, the Lordship. On time settlement take place.
When the notice was issued.
G12/2020.
Then
Lordship, after that I make payment under one time settlement.
so what relief you are praying for?
I'm praying for stay of the proceeding.
No.
Yes.
I'm not making a new mentioning, my
Lordship.
lord. My lord, I mentioned this matter last Thursday. Your lordship had directed the matter to appear today, my lord. The batch of writ petition challenging show cause notice issued under the RBI fraud circular, my lord. Mr. Ratnako Banerjee was dealing in the matter. Your lordship had reserved the judgment, my lord. The day after the judgment was reserved, my lord, a fresh show cause notice was issued, my lord. We had filed a can, my lord. Your lordship had granted leave on Thursday. The matter was to come today, my lord. It's not appearing in the list.
Why?
May I make over?
कल के खोली
This is the number, sir. Your lordship had granted
under the heading application.
Lordship, may I please permitted to mention, grant me leave so that the matter can be heard. This is a tender matter, Lordship. Birbhum Jalo Parishad floated the tender without considering the memo. They input on their own whims. They put 3 clause, that is the in place of a 2% EMD, they demanded 10%. Time period of the time period is 1 year, Lordship. In place of that, they put it on 3 years. In this way, Lordship, they violated the 3 memo. And last day, coming date is 6 February, Lordship. Due to that reason, I am praying, Lordship.
6 February. You go, okay, you file it first. File it. If it is not listed, then you mention. Why the leave is required?
Lordship, leave is required because of that reason, Lordship. It is
last date of submission of tender when?
6 February,
6
Lordship.
February. Today we are on 29, 28.
28.
Correct.
Yes.
You file it.
So, Lordship, give the direction so that the matter is come under the heading of the urgent motion within the 10 matter, Lordship. Lordship, very urgent matter, Lordship. Kindly see, this is the authority concern is doing this.
Leave granted to file and be listed on 3rd February under the urgent motion. Huh? Withdrawal. The heading application to be mentioned for withdrawal tomorrow.
May I have your lordship's kind leave. In mentioning this matter, my lord, what I could gather from the Secretariat of the Honorable the Chief Justice, since Justice Shubhra Ghosh is not sitting, the determination has been given to your lordship, and that is what we have gathered from the Chief Secretariat. Well, this matter is extremely urgent, my lord. West Bengal Disaster Management and Defense Fighters Association, they are an organization, but they want to sit in for a sit-in demonstration. Now that was on and from 28. On the last occasion, police rejected our prayer. Now, humbly beseeching your lordship, this matter can be taken up today at 2.
When you made an application for permission for demonstration.
Because otherwise police would forcefully drag.
Correct. When you have made an application to the police for grant permission.
22nd January.
22nd January. When you intend to hold the demonstration.
The organization had declared from today to 11 February continuous sit-in demonstration. Police rejected it in the last moment, saying that we will not grant permission. Verbal assurance were given. Okay, you can sit. They were bargaining with the dates. Not so many days, we'll give some lesser dates.
So where you want to hold the demonstration?
It is announced program that it will take place from today till 11.
Where? Which place?
At College Street. There is the construction.
College Street.
But if it can be taken up today at 2 minutes, because the program is announced, all members from all over West Bengal have already come to.
It is not come tomorrow.
I'll serve because only the state has to be served. May I kindly.
How it is possible today? Why you are not moved yesterday?
The person concerned, the secretary, he resides at North Bengal. He on 26th rejection immediately.
When you receive the rejection, 26.
Yes.
So why you are not?
Via email. That night via email, my lord, subsequently had to come all the way from North Bengal, but that was
today it is not possible.
The program is already announced for persons to all.
I can accommodate you till tomorrow. Tomorrow at the first matter it can be taken. If not this court, the regular court. Second half, my total diary is packed.
take my 10 minutes.
I don't think it will, the state will come and they will run, they will.
Kindly, my lord, if you lordship grants the ballot, let me take a chance to pay lordship, my lord, kindly.
Leave is granted to file and move the matter at 2 p.m.
Lordship,
I'll give the-
Lordship kindly.
My lord,
consider-
may I be permitted?
I wouldn't have
Yes,
trouble your lordship. Yesterday I sought for leave. Lordship has asked me that either a petition was filed before the learned court below. Yes, my lord, it was filed and it was rejected. My lord, we received a notification on 23rd January stating that to visit in Dubai for the smooth running of the business. My lord, I need to go there and visit physically, my lord. Only for that, my lord, kindly grants me a leave and move it urgently.
Leave is granted,
Lordship kindly consider.
leave is granted
Lordship kindly consider.
to move the application, leave is granted to file, list the matter on second February.
Lordship kindly
Bless
consider.
my lord.
As urgent motion, huh?
Kindly consider my position will be gone. Position will be gone on 31st January. Lordship. I made part payment. Lordship.
What you have prayed for? You have prayed for costing, you have partly you have complied with.
Balance amount. Payment of payment. Balance amount.
When the last date of payment?
কালকের মামলাগুলো কবে রাখলো? ফেব্রুয়ারি 24 না কবে?
22
না কিন্তু আমাদের না
So thereafter why you not come to the court and the last hour,
ওদের তো ফার্স্টে রিপোর্ট করতে
how- when the matter will be listed, tell me,
ওই তো আমরা তাই বলে দেবো।
Bank will take possession.
when?
After 31st January.
After 31st January. So today is 28. Tomorrow 29. How it can tomorrow? Listed on 30th at that time.
আচ্ছা
My lord,
Move
my
on.
lord, may I be? My lord, may I be?
2nd February. Yes, I already passed an order to registrar of assurance to appear before this court. That is the problem. See, today is not a mentioning date. All are coming before this court. And when the matter is listed, you sit today court and take the note how much matters the advocates will appear. Yesterday, 33 matters have been called. Only 3 advocates are appeared. All matters have been adjourned. You all are only interested. The matter will come on the list to show your client. Yes, my letter is matter, and the matter is listed. Nobody is interested to come before this court and make a submission. Yesterday, only 3 matters out of 2. Only it was disposed of. None has appeared. Already, I passed an order. I think it is uploaded.
Lord may be permitted to mention one matter, my lord.
30 को to be mentioned मेरे को. You should notice
Well-
to the other side.
My lord may
30 को to be mentioned.
my lord,
No. Yes, call the list.
my lord, I am mentioning this
My
matter
lord,
on direction
my
of your
lord, may I be?
lordship.
When the matter was called, Lordship, I tender my unconditional apology for not being appearing in the matter yesterday, Lordship. So it was rendered to appear in the April monthly list. But the only difficulty is, Lordship, this matter was a criminal matter. And Lordship list specifically states that criminal matter will be taken on Friday. Since it was not taken on last Wednesday, Thursday, Lordship, that was under the impression, Lordship, I could not appear yesterday.
But it is as per your submission, it was brought under the urgent motion.
No, Lordship, it was not under the urgent motion.
No, it was urgent motion. Yesterday it was urgent motion.
No, Lordship, it was item number 7. It was under the heading application, Lordship. Yes.
Maybe application, but so it is the.
It was a criminal matter, Lordship. That was the only reason, Lordship. If it could be taken up any day as per your Lordship's convenience.
Why it is mentioned?
Lordship, because the Lordship had asked that the matter should appear in the monthly list of April.
Correct, because you are not appeared
So that
when
was
the matter is called.
Lordship, it could be taken up any day, Lordship.
My lord, may I be permitted to mention one matter, my lord?
Fourth को रखो to be mentioned मेरे को.
My lord,
My lord, may I be
Yes.
my lord,
my lord, I have mentioned this matter yesterday, my lord. This is in pardons to my lord the non-payment in the MG NREGA scheme, my lord. Item number 4 of yesterday's list, my lord. My lord passed an order in those matters. My matter is, my lord, came from the North Bengal Circuit Bench through court number 1, my lord. That has been came before your lordship. Now, my lord, the same order can be passed in my matter also.
What order has passed?
My lord, we are also the suppliers, my lord. The materials has been supplied, my lord, under the MG NREGA scheme, my lord. The payment has not been.
That's why yesterday I asked, give the list, it will be listed in the matter. Give
No,
the
my
list,
lord,
how
that-
many matters are there?
My lord, mine is 10, my lord.
जलपाईगुड़ी matters.
Yes, my lord.
एक काम करो लो, जलपाईगुड़ी matters करके कल का पर मंडे का लिस्ट में डाल दीजिए.
My lord,
My lord,
may I be permitted to mention my
my
lord
lord, my lord,
virtually?
can it,
All the list.
my lord, can it
My
be?
lord, I am waiting for
All
my
the
lord, at the
list.
past sitting. My
Monday, my lord.
Call the list.
ছেড়ে দে,
Yes.
Yesterday, this was pass an order and fix the matter for 30.
এখনো নিচ্ছেন উনি।
Yes, 30th March it is fixed.
Kind enough to modify the date, will they be taken up on 25th April or 7th, after 7th?
Which was the other side?
Or after.
Which was the other?
You have still-
2 तारीख।
My lord, ये फाइल नहीं है इसकी?
Yesterday,
फाइल नहीं.
file is there.
my lord,
Yesterday already passed an order. Yes. Yesterday already passed an order.
Yes, but only the date, because for
But
30th.
file is not here. I cannot
What
pass.
is the file? The order.
Kindly see the call list. I don't know.
my lord, my lord, I am waiting, my lord, virtually, my lord, to mention, my lord.
March.
My lord, I am waiting to
I'm in some-
mention, my lord, virtually, my lord.
I
Kindly allow me to mention, my lord.
25th March or sometimes in April.
It was fixed in your presence, madam.
My learned junior was there, but I was not there in the court
That is the-
yesterday.
So file is not there where the order can be.
The order has been passed, the order is uploaded also.
Correct.
So only that the date we changed, my learned friend on the other side is there. In his presence, I'm only seeking. But it will be very convenient and wrong on my part to come on that day and seek an
Senate
adjournment.
Council for the petition submitted this court by an order dated 27th of January 2026 has fixed the matter on
30th of March.
30th of March 2026 at
Date we fixed
2
on
p.m. as a specially fixed matter, but she submitted she is having some personal difficulties and paid for fixing the matter on.
either 25th March or after 8th April, whenever my lords commences.
देखो 8th April खाली है देखो. 8th April, on 8th April
Completely obliged.
2026.
So the
And
My lord,
informal till further order. There is
Accordingly,
no difficulty.
accordingly, 8th April, let the matter appear on 8th April 2026 as a specially fixed matter instead of 30th April, 30th March 2026. On diary note kori then.
No, the
my lord, my
Send
lord, from
Not extended till the next date of hearing.
deeply obliged.
my lord, my lord, I may be allowed to, my lord, mention virtually, my lord. I am waiting for, my lord, since my lord has seat, my lord. But the urgency is, my lord, there, my lord. Although, my lord, may I be permitted to mention, my lord?
Call the next matter.
My lord,
It's for extension of interim order. The issue was as to whether the subdivisional officer can cancel a certificate, tribal certificate. That matter is pending before the division bench. And the order is, my lord, is pending, my lord, for the.
Not disposal.
Not decided as yet. I am only praying the matter may be, my lord, listed on 30th of March, subject to, my lord, lordship consent. And interim order be 31st of March.
Lordship, everything is over. Lordship takes the matter with that, with that matter, tax Lordship
No,
our
division-
matter. I beseech
That's a
Lordship.
division bench has not yet disposed of the matter. No?
Let that this matter be tagged with the division.
Tax
how
the
can
division bench matter.
You mentioned that if the division bench will say, then how I can
We are for the
send to the
response,
division
Lordship,
bench?
every time that they're extending that only on that lame excuse that it's tagged.
You
Not
do
the
one
first day or
correct. You
hearing.
do one thing. You mention before the honorable division bench. If the division bench will say the matter be tagged, this matter will be released. How this court can say that the matter be taken by the division bench?
Lordship directs the petitioner's Lordship to mention the matter before that.
Correct. Now you are facing difficulty. You mention the petition joined the
We
interim
are only
order.
beseeching Lordship
Eh.
because everything is over, Lordship.
It is submitted by the Senate Council for the party. The similar matter is pending before the honorable division bench for consideration. Accordingly, case is adjourned
Till 31st of March, my lord, matter
Till-
is fixed on 30th of March.
till 30th March 2026. List the matter on 30th March under the same heading. Interim order is extended till 31st of March 2026 or until further order, whichever is earlier.
Grateful, deeply obliged to.
Once, Next. I don't know. Going application? Why it has come? Why it has come as an application? Should four. Call the four.
That's it, 2 days for restoration.
Yes,
The matter was called for
I can't hear you. Switch on your.
2 days for restoration.
Huh?
Restoration this application.
Restoration application.
Uh,
When it was dismissed.
Second
Huh?
2nd May 2025.
2nd May. See the order. What is the date of the order?
Oh, sorry.
Which order? What is the date of the order?
8
Huh?
8
8
May
May.
8 May
So
2025.
where you got the 2nd May? Why you not appeared?
Lordship, in this matter already 2 advocate was changed.
Huh?
2 advocate was changed in this matter.
What?
This is exchange brief.
Exchange brief.
Uh,
Then why you not appeared in this matter? What is the writ petition? What you are challenging the writ petition? Yes. What is the writ petition?
Lordship, come to the present
Kindly come
para
to the
number
page 16. Kindly come page 16. Order dated 28 March, 28th of August. Correct. That is the order.
Yes, Lordship.
And kindly come to the page 11. What is your prayer? Page 11. Prayer A. Correct, you want the direction? Now come to the page 18. You got this report. What further required? Kindly see the page 18.
Yes, Lordship. The instant I above this is to inform that membership number 29 is available.
So what further required?
Sheet number 29.
Details is in the computer's land record. You made an application in the computerized application. You will get the record. So what further direction is required?
This is also informing that
The petitioner has filed the present application. Application for recalling of the order dated 8th May 2025, wherein this court has dismissed the writ petition for default for non-appearance of the petitioner when the matter was called. Full stop. Counsel for the petitioner submit that the petitioner was not aware the writ petition was dismissed for default when the petitioner engaged the present counsel, and present counsel has verified from the website, it was found that the matter was dismissed, the writ petition was dismissed for default on 8th May 2025. Accordingly, the petitioner has filed the present writ application. Heard the land counsel for the petition, peruse the materials on record. This court find that sufficient cause has been shown for non-appearance of the petitioner. Accordingly, order dated 8th May 2025 is recalled. WPA number 3266 of 2024 is restored in its original file. Full stop. With the consent of the writ petition is taken off hearing. This court find that the petitioner has made a prayer for a direction upon the respondent number 2 for compliance of the order dated 28th August 2023 passed by the appellate authority in an appeal filed under the Right to Information Act. This court find that the appellate authority by an order dated 28/8/2023 directed the SPIO to furnish desired information to the petitioner, observing all formalities within 7 days from the receipt of this order. Full stop. The order was duly communicated by the petitioner to the SPIO, that is Officer in Charge, Town Survey Unit, Howrah. Full stop. On receipt of the said order and the communication made by the petitioner, the Officer in Charge, Town Survey Unit, Howrah, the respondent number 2 has forwarded the information to the petitioner, informing that LR plot number 125 of Shipur, sheet number 29 is available in the computerized land record, and directed the petitioner to procure the plot information of the LR plot number 125 of the Shipur, sheet number 29 through online application on payment of government dues. It was further informed to the petitioner that LR KH number 50 of Shipur, sheet number 29 does not exist in the exist in the computerized land record. Full stop. Consider the document available on record. This court find that the respondent number 2 already complied with the order passed by the appellate authority by an order dated 28/8/2023, and thus no order can be passed in the present writ application. Accordingly, writ petition is dismissed. Next.
9 to 13. Lord, I am for the petitioner.
Yes,
9 to 13, my lord, I am for the petitioner.
9 to 13.
Yes, my lord. The same issue.
Only
the
13
petitioner-
I am for the state.
Yes.
In item number 10, I am appearing on behalf of the state respondent, my lord.
The urgency, the matter was mentioned before your lords. My lord, lords pursuant to lordship's, my lord, permission. My lord, the writ petition was, my lord, listed on, my lord, 22. And my lord, again, my lord, I have mentioned before your lordship yesterday, because of urgency is, my lord, the,
Yes, what is that? But what is the prayer?
my lord. Prayer, my lord, I have challenged the tender notice. Specifically, kindly come to page 30 for imposition.
Page 30
Yes, 30, my lord.
and 90.
Yes, my lord.
Yes.
The kindly see the bottom credential certificate. Working experience of similar nature. Cook diet supply of work with minimum 200 bidder. Government hospital, government undertaking hospital. Only my lord, the specification for 2 years in last 5 years. This is only for challenge. Because of this issue was, my lord, decided with this honorable court in the year 2017. One writ petition was moved before this honorable court, and, my lord, this honorable court has, my lord, directed to consider. Pursuant to that, my lord, the government has issued a corrigendum and extended since 2011.
Working experience of similar nature.
Well,
Cook diet supply
yes,
of the work minimum 200 bedded government hospital, undertaking hospital for 2 years in last 5 years.
yes.
Only
Kindly see
challenge
that.
only this clause.
Huh?
3-9.
Yes.
3-12.
Let now I will
Only, my
continue.
lord, this is all. This is 2017 order I have given. My lord, kindly see the writ petition. 2017.
Which
That, my lord, 2017 writ petition. My lord, I have given at that order, my lord, 2017 writ petition. My lord, order. My lord, kindly see. My lord, I am reading first order, my lord. The petitioner assailed a memo number July 27, 2017 relating to terms and condition of tender process supply of cooked diet items. The learned senior counsel advocate for the petitioner referred clause 6 general condition of conduct of clause 3 therein which relates to eligible and qualified bidder. He submits that prior to 3 years specified in clause 3.1 is arbitrary and vague. He submits that the period of 3 years has to be calculated in reference to larger period as the period of time to have any reasonableness. Otherwise, the same is unreasonableness to irrational. The state represented, the learned advocate for the state submits that the period of 3 years specified clause 3.1 has to be read in context of introduction of the tender process for diet items, that is 2002. However, the state will issue necessary corrigendum for the such purpose if permitted by the court. Having heard the rival contention of the parties, the fact of this issue case, interest of justice would be subserved by permitting the state to issue a corrigendum specifying the period of time within which the period of 3 years specified clause 3.1 will be considered by the state as the eligibility condition. The state may issue such corrigendum and expeditiously as possible so that pursuit the eventually tender process of accordance with law. The corrigendum is required to be issued so that every intending tender is put on notice as to the item governing the tender. The direction is issued in view of the fact that the event of the state clarify the position of contended. The same will be addressed the issue unreasonableness and irrational as raised. Based on that, the corrigendum was issued, and corrigendum was issued that time period from 2011. Why, my lord, I am placing some of the tender which was issued earlier. Kindly come to page 53. This is a tender, the petitioner was participated. Details, some of the tender I have given 18 May 2023. Kindly come to page clause number 7. The
terms and condition of this tender, serial number 4, the line should be read to the bidder should have experience for supply of cooked diet to any government hospital with minimum bed strength 300. Otherwise, the bidder will be liable to rejected. Instead of bidder should have the experience of supply of cooked diet to any government hospital with minimum bed strength 400. Otherwise, the bid will be liable to rejected. Is the same is applicable annexure A, point 8, the checklist. The experience will be applicable any 3 years from April 2011 to up to the date as per High Court order dated such and such, which I have placed before your lordship. My lord, kindly see next, my lord, the page 55, the corrigendum. Column number 4. The intending lordship has got it.
Yes.
Page 55.
Yes.
Serial number 4. The intending tenders must have credential for the same work for continuous 3 years or more from April 2011 to till date as per verdict of the Honorable Supreme Court. Then this is 2023.
Verdict of the Supreme Court.
My lord. Perhaps it will be a High Court. Then, my lord, kindly come to page 57 in another tender also in the year 2023. My lord, page 58, credential certificate. My lord, participants should have at least continuous 5 years experience as per verdict of the
reading?
My lord, page 58, my lord. Credential certificate. The participant should have at least continuous 5 years experience as per verdict of the Honorable High Court order dated such and such. From April 2011 to till date, the supplying cooked diet in any government. So, my lord, this order also mentioned. Then, my lord, kindly come to page another tender also.
Okay, the like this it
Yes,
was
yes,
given. Yes. Now
Here,
this is only.
Here, only, my lord, here, the 2026 tender, it has been reduced. My humble submission, once the, my lord, the Honorable Court and the authority has consistently my lord, accepted, why, what is the reason to, my lord, reduce that?
Okay.
Otherwise, my lord, kindly see this issue, my lord, the Honorable Supreme Court has this, my lord, this my lord, imposition is violation of Article 19(1)(g).
Which case?
My lord, no, Reliance Energy Private Limited, my lord, 2007, volume 8. Just आपके सलाई करो.
এই 2017 একটা জাজ দেখলাম না।
I'm sorry, my lord, it has not been stitched, my lord.
Yes.
My lord, paragraph 36, 38, 39 and 40, my lord. I am placing.
কোনটা নিয়ে এটা তুমি তো দিলেই তো আমার
না আরেকটা দুটো জিনিস
তোর জাজমেন্টটা দেয় না ভাই কিটা আছে
তোর দিচ্ছি
আমি তো ইয়েতে পেলাম না না আমি পেলাম না ডাউনলোড
Yes. Next.
মানে following the same judgment, the another coordinate bench has passed an order for imposition of, my lord, years. My lord, may I, my lord, given it, though it has been, my lord, interim order.
Yes.
Here, my lord, paragraph 20, page, my lord, 12. 20, 21, 22 and, my lord, 25. 26 also, my lord.
Yes.
Immediately after issuance of tender, my lord, we have raised an objection and my lord, we made a representation relying on 2017 judgment and my lord, the issue where my lord, we have my lord, barred, my lord, restricted by in terms of my lord, violation of Article 19(1)(g).
Okay.
My lord, page 90.
Okay. Yes.
Sir, here is a report, my lord, filed by the state advocate.
What?
Report. Your lordship, kindly come to the last annexure, my lord. On the self-same issue, they have filed a writ petition, and your lordship, that was dismissed as withdrawn. Last annexure, last page, my lord. The
Yes.
report, my lord. Just January 2025, self-same issue, my lord, they have withdrawn this writ petition. Kindly see, my lord.
Yes. Yes.
And here is the report, my lord. This is the clause, my lord. They have not fulfilled the clause, my lord. That's why they have challenged this, my lord, clause, my lord. Your lordship, kindly come to the clause, my lord, page 30, my lord. Page 30, my lord. Clause 3, Roman 12, my lord.
Page 30.
Page 30, my lord.
Correct.
The notification, my lord. Clause 3, Roman 12.
Yes.
Credential certificate, working experience as similar nature, cook diets, supply of work with minimum of 200 bedded government hospital, government undertaking hospital for 2 years in the last 5 years. Mala, they have experience 2011 to 18. Last 5 years, they have no experience, my lord. They have admitted in their repetition, my lord. Last 5 years, they have no experience. 2011 to 2018, my lord. They have supplied the cooks, my lord, to some of the hospitals, my lord, not below the, my lord, not above the 200 bedded, my lord. That is why that criteria they have not fulfilled, and that's why they have challenged this, my lord, notification, my lord.
So what is the stage of the tender now?
My lord, tender now, my lord, that I will take instruction and that I will
Page 31, my lord. Last date of submission.
So my instruction in item 10, my lord, technical bid is yet to be opened, my lord. Tender process. I had a talk with the department.
I have participated. I have not participated. My lord, kindly see page 31. The last date of submission in 28.
Correct.
We could not my lord, submitted my tender because of I have challenged this my lord, the clause.
kindly.
My learned friend has submitted, my lord. I have.
Yes.
said-
What
My
about?
lord, previously also, my lord, they preferred a writ petition and they
What
withdraw
about?
the same, my lord, before your
What?
lordship.
My lord, they have, your lordship, can you come to the report, my lord? My lord, annexure B, my lord. Attendance sheet of the pre-bidding meeting in the respect of the tender engagement of the agency supply to that to the indoor patients of the ESI hospital Bajwaj under direction of the your lordship, can you come to annexure B? Well, last but one, my lord.
Yes. What do you want to show?
They are the participant, and my lord, I think, my lord, that Disha Enterprise will be the first tender. He will get the tender.
Disha Enterprises.
Disha Enterprise. My lord, annexure B, my lord.
But they are not the Disha Enterprises. The petition is not the Disha Enterprise.
No. He is not it.
So
That he is not
no,
fulfilling the criteria.
The only question here, the earlier occasion, the similar writ application was moved, and this court has passed before this court you accepted. Yes, it is to be taken the experience from 2011 onwards, and you have your corrigendum was issued subsequently all the tenders. So what is your answer on that?
Earlier, my lord, earlier tender, my lord, that was gone, my lord. This is the new tender, my lord.
Correct, but you
2025,
continuing
the clause was
2017
totally a
till
government decision, my lord. It's totally a government decision, my lord. The finance department issue all these things, my lord. This is a government decision. There, if the government is think, my lord, the new clause comes out, my lord, for the benefit of the patient, my lord. That's why they have added all these things, my lord. Well, they have challenged the issue on the same ground, but that was dismissed, my lord, before your lordship. Your lordship, see the order passed by your lordship, my lord. Well, now the second time, the same issue, well, they have come before your lordship.
that is dismissed, withdrawn. Yes.
This is about not liberty to
May I
file.
join the issue, my lord?
Not
Yes.
liberty to file a fresh.
Sir,
In
appearing
item
for
number, my lord,
You are appearing for?
for the state responding in item number 10, my lord. I have my instruction,
I
my
am
lord.
for 12, my lord. I am for 12.
Yes.
I think we both are having same instruction. If your lordship will come to third page of my instruction, that is annexure A, my lord. In C, your lordship will find tendered value beyond 5% and up to 10% above the amount put to tender. My lord, got that, my lord. 7th of June 2022, my lord. My lord, at the bottom, my lord, point number 6, my lord.
Oh, it
My
is.
lord, if your lordship will see accepting authority, it is head of the department executing the work with recommendation of departmental tender committee of the executing department.
So
So,
what
my
do you
lord,
want to say on that?
my lord, first of all, my lord, what my learned friend has submitted, my lord, this April 2011 is a misleading statement, my lord, because we have asked for the last 5-year experience, my lord. So that new companies, they can also attend this, they can also make their bid in this tender process, and we will get the best prices and the best services for the patient. Ultimately,
Yes,
we are serving
anything?
to the society, my lord.
Anything further?
My lord, only for my learned friend is showing that my lord, the earlier occasion the writ petition was withdrawn. That is different tender, not in this
No, my
issue.
lord, in the last page
Kindly
of
see
that
that.
instruction,
No, my
your
lord.
lordship will find
Where is
the
that writ
cost
petition?
title, my lord, the same cost title,
They have
in
not
same
annexed,
month.
my lord.
No, my lord.
Only I have annexed the order passed by your lordship on
My lord,
9th
kindly
of
see that
January
tender.
2026.
That is my lord tender.
Last order, my lord, last order.
Correct. Where is the writ
On 9th
petition?
of Jan, my lord.
Yes, they have filed. Their client
Yes, it is
filed.
the
They
same
have showed the
tender.
writ
No,
My
my lord,
lord.
different tender issue.
They have showed the writ petition, my lord.
Okay.
Same issue, my lord.
The
The-
same company.
The petitioner has filed the present writ application challenging clause 3 within bracket Roman 7 small of the tender notice dated 2nd January 2026, wherein the respondent authorities have mentioned the condition for the credential certificate as working experience of similar nature within bracket cooked diet supply bracket close of work with minimum 200 bedded government hospitals / government undertaking hospitals for 2 years in last 5 years. Inverted comma close. Learned counsel for the petitioner submits that the similar issue was raised before this court in WP number 21719 within bracket W of 2017 within bracket Noor Islam versus State of West Bengal and others, wherein the authorities have put the same conditions, and this court, and when the matter was taken up for hearing by this court, the respondent authorities have considered their lacuna and submitted before this court that they will issue a corrigendum, and accordingly this court has passed an order disposing of the writ application directing the authorities to issue corrigendum specify the period of time within which the period of 3 years is specified in clause 3.1 will be considered by the state as an eligibility condition. Full stop. Learned counsel for the petitioner submit that subsequent to the order dated 21st of August 2017, the respondent authorities, whenever issued the tender notice, have indicated the terms that the experience will be applicable any 3 years from 2011. But all of a sudden in the present tender process, the authorities have illegally and arbitrarily have put the condition that the working experience is 2 years in the last 5 years, which is to be modified, that the working experience is to be taken from the 2011, not only for the last 5 years. Then a counsel for the petitioner has relied upon the judgment in the case of Reliance Energy Limited and another versus Maharashtra State Road Development Corporation Limited and others, reported in 2007-8 SCC 1, and submits that and submit that if there is a vagueness of subjectivity in the norms, it may result in unequal and discriminatory treatment, and it may violate the doctrine of level playing field. Full stop. Learned counsel for the petition further relied upon the unreported judgment passed by the coordinate bench of this court in WPA number 23931 of 2025, dated 9th of October 2025, wherein the coordinate bench of this court has held that the court could interfere if there is involvement of public interest or if the process adopted or decision made by the authorities arbitrary or irrational. Full stop. Learned counsel, full stop. Per contra, learned counsel appearing for the authorities respondents submit that the writ petition filed by the petitioner is not maintainable. नहीं, appearing for the respondent has filed report. Filed report by disclosing the order dated 9th of January 2026 passed in WPA 29900 of 2025 within bracket the new supply syndicate versus state of West Bengal, and submit that the similar writ petition was filed by the petitioner, but subsequently the petitioner has withdrawn the said writ application, and accordingly this court has dismissed the said writ application as withdrawn. The petitioner, while withdrawing the said writ petition, has not paid for any liberty to file a press. Now the petitioner has filed a press writ application which is not maintainable. Learned counsel for the petitioner further submit that in terms of the tender notice issued by the authorities, there are altogether 10 firms have already participated in the said tender, and tomorrow and 30th January is the last date for opening of the for receipt of the tender, for opening of the technical bid. He further submitted that the authority are competent to put the tender conditions. Full stop. The authorities have found that for the said tender, an experience of the similar nature of the work with minimum 200 bedded government hospital / government undertaking hospital for 2 years is required for the last 5 years. The authority have taken a decision for taking into consideration that the authorities have to see whether the firm who will be awarded the tender will able to execute the work or not. He further submit that if it is taken, the experience is taken into 2011 onwards, and in between 5 years, if the firm has not executed any work, there are several changes for the type of execution of the work. Then the petitioner will not be able to execute the work properly, which would awarded to the firm who has only completed the 2 years from 2011 till the publication of the tender. Full stop. Learned counsel for the respondent submit that the petitioner has an experience only up to 2018. And as such, the petitioner has filed the present petition claiming that the experience is to be taken into consideration from 2011. And the petitioner the petitioner had the knowledge that the petitioner case will not be, tender will not be considered, that the petitioner is not having the certificate for the last 2 years within the 5 years from the date of publication of the tender. Had the learned counsel for the respective parties produce the materials on record. The respondent authorities have issued the tender notice from the bona fide registered eligible and resourceful agencies for supply of cooked diets to the indoor patient of ESI Hospital, Bajwaj. Full stop. As per the credential certificate, the working experience of the similar nature within bracket cooked diet supply of work with minimum 200 bedded government hospital oblique government undertaking hospital for 2 years in the last 5 years is required. The contention of the petitioner that on earlier occasion, the respondent authorities are taking the experience certificate from 2011 onwards. Now, all of a sudden, the authorities have changed the criteria and they are asking the working experience certificate only for the last 5 years, which only 5 years. This court find that it is the authority are the proper authority, the respondent authorities are the proper persons to decide the conditions of the contract. The court cannot sitting over the writ jurisdiction decide the tender condition. The firm who have been awarded the work has to execute the work in terms of the tender terms and conditions with the satisfaction of the authorities. In this case, the authorities has found that the experience certificate is required for 2 years for the last 5 years. This court did not find any arbitrary action on the part of the respondent authorities. The judgment relied by the petitioner is not applicable in the present case. The coordinate bench, the judgment relied by the petitioner with regard to the coordinate bench in the 2017, that order was passed on the ground that the respondent authorities have conceived that they will issue the corrigendum with mentioning the experience from 2011. This court has not decided the said matter on merit. Accordingly, the said order is not applicable in the present case. WPA number so and so dismissed.
Wait. Well, only item
Obliged,
number 5 filed
Highly
this,
obliged.
item number 12. Only item
All
number
are
12 I
identical.
filed this report.
Like 10 also my
report
report file.
file.
Line 10 also my
Okay.
report file.
Item number 13 also the report.
9, 10, 11, 12.
My report
9,
file
10,
in 10
12 all
my
same.
Up to 13 my lord.
Are
9 to
indicated.
13 my lord, same matter.
Up to 13.
13 my lord,
But the
same matter.
tender, malad, e-tender, malad, the number is different and date is different.
That will take care of.
I mean 13 my lord, shall I file the report my lord?
Huh?
In 13 my lord.
Obliged, highly obliged.
Great.
Same that. Same malad which we are. But I got the notification malad with regard to this.
Today the question of notification is irrelevant because as on today the determination is with your lordship.
No,
That cannot be,
that,
malad. This
that-
is
no, even though that is to be taken into
Yes, I'm giving you the
because it was filed before this court.
malad,
Yes, I'm fine.
determination is with
So
this
you
court.
follow
The court
fine.
has answered on this notification 3 times. They raised the same issue, malad.
Malad, the point has been taken by me. My learned friend can at least wait me to address the
But
court.
this should have not been raised.
What I have raised, what I should have, or what I should not have, he will have his turn to say.
Now let me just, I was, malad,
Point
this
was
is the
taken by
notification.
me.
This is the notification which my learned friend relies on, malad, which was told to this court yesterday, malad, dated 30th September. Malad, the argument which they are trying to canvass is that the central agency comes in police in action, malad. So therefore it has to go there. Now, malad, this has been answered by this court in the ED matter only. Twice, not only twice, but thrice, malad. Malad, I'll give the division bench judgment and the learned single judge judgment, malad. Malad may just have exact, this question was raised. My lord, the judgment of the division bench in Manka, my lord, Gambhir. My lord, this was a challenge by the ED under section 50, my lord, basically for the summons. My lord, may come to para 8, my lord. The first issue
is if the learned single judge had the jurisdiction to pass the order under appeal. If there is no such jurisdiction, then in terms of the judgment of the Honorable Supreme Court in so and so, the may come down, the order of the learned single judge become non-est. Undisputedly, on the date of the passing of the order, learned single judge had the determination to hear the matter, motion and hearing under 226 of the Constitution relating to residuary group 9, excluding matter relating to police inaction. The jurisdiction of the learned single judge has been questioned on the ground that the present matter falls under the category of police inaction, but such plea cannot be accepted in view of the fact that the Honorable Supreme Court in the matter of Vijay Madan Lal settled the process envisaged under 50 in the nature of inquiry against the proceeds of crime and is not an investigation. In strict sense of the terms of initiating prosecution and the authority under PMLA are not police officer as such. Thus, the contention of the applicant that the learned single judge has no jurisdiction to hear the writ cannot be accepted. My lord, may just see one more judgment, more detail, where this circular was referred on attachment only. My lord, may have the next judgment. My lord, may see one, my lord. An interesting yet embarrassing question has arisen for consideration before this court, whether the bench has determined to take the matter. Embarrassing because it concerns the determination of the bench, which itself decides on the issue. Interestingly, because it touches upon the question of law which no longer required to be answered in view of a particular circular dated 30th September 22. The matter pertained to inter alia provision attachment passed under 5 of the Prevention of Money Laundering. The circular dated 30th September issued by the then Honorable Chief Justice of this court, in clause 3, it is stipulated that the matter relating to CBI and central agencies in the writ petition under 226 of the Constitution of India are already included within the comprehensive reading of the subject category police in the appellant side rule. Therefore, there is no need to mention CBI and central agencies separately. My lord, may see the finding at para 7. The learned counsel appearing of the petitioner placed reliance on the judgment dated so and so passed by the division bench, which I have just shown. Yes. Interestingly, by the then Chief Justice, the order passed by the order was passed in MAT 1762 subsequent to the issue of circular in question and the interpretation of the circular. My lord, may see the ED's contention at para 12. The learned counsel appearing for the ED, while controverting the submission and arguing that this court does not have determination to hear the matter, relies on clause 3 of the relevant circular dated 30th September 22, which does not distinguish between CBI and central agency under PMLA or other act. Thus, it is argued that all central agency, including CBI, comes within the category of the police for the purpose of the present consideration. Lord, may see para 16 and 17 decides the issue. To decide the issue determination, what is to be interpreted first is the concerned circular of the then Chief Justice. The circular clearly enumerates in context of the police inaction matter that subcategory police in appellant side rule includes CBI and central agency. The term central agency cannot be stretched beyond the limit as connoted in the said expression in the circular, since otherwise any central agency governed by the Union of India would fall within the purview of the bench taking up police inaction matter, although not having even remote connection with the police inaction, which could not have been the intention of the then of the Honorable Chief Justice. For example, if Reserve Bank of India, which is an authority functioning under the aegis of the central government or any other agency not connected in the matter with investigation of law enforcement acting with the purview of the central government is deemed to be included in the central agency as per the circular, then no residuary matter against the union could probably come to this court, which could not be the intention of the then Honorable Chief Justice while bifurcating determination. And then, my lord, the court notes and the court says that this court will have a jurisdiction. So this will stand at rest. Now, my lord, with regard to the issue of the judgment, let me conclude my argument and then they can take over after this.
Lord, I have two similar writ petitions. My learned friend has started, not kindly permit him to conclude. I won't argue the same point. I have a separate point. I'll argue it after he finishes.
My lord. No, my lord, may just see, my lord, I was concluding, my lord. The
No,
act
he
I
has
was showing, my
concluded.
lord.
I was replying.
Yes, no, I wanted,
I
because
was
they
replying.
raised that issue, my lord, so let me conclude so that they can respond to every of them. They
Let
should
me
not be
complete.
taken by surprise.
Then you will not get further reply.
Yes, my lord,
You will not get chance
Lord,
for
if
the
there's
reply.
something,
Hmm.
please.
That's why let me complete. If
My
it,
lord, I only wanted to show two notifications, which is, my lord, not brought, and why, my lord, that is relevant. And my lord, I am only, my lord, we all espouse the cause of the clients, but I am trying to place the correct proposition of law so that my lord can decide that thing one or the other way, doesn't make a difference, and where we stand. My lord may just see for a minute, my lord, the notification. When the adjudicating authority was appointed, what was the intention at back then? My lord, the notification.
एक काम करो, जो पहले वाला जजमेंट ऑर्डर किया ना, 4 है ना, एक को तुम फेयर करके दे दो, फिर करेक्शन करेंगे देखिए, ठीक है? एक ही एक था इसमें डिक्टेशन नहीं। Yes,
My lord may see this notification.
July 23.
Yes, my lord.
Yes.
My lord may see. Sorry, my lord. I did not. No, it is not. I am good.
This is not that given to me.
Different. Two notifications I'm going to rely. I'm giving you.
To give a copy to them also this notification. July 2023.
My lord may see the first notification, my lord.
2005.
July 2005.
Yes.
My lord, this is the time when the adjudicating authority was made. 1st of July 2005. My lord may see the English portion. In exercise of the power of subsection 1 of 6 of the Prevention of Money Laundering Act, the central government hereby appoint adjudicating authority to exercise jurisdiction, power and authority conferred by under the act. Adjudicating authority shall consist of chairperson and 2 members and shall function within the Department of Revenue of the central government, headquarters, New Delhi. So word is shall, my lord, in this notification also. Now, my lord may see the notification of appointment of the, my lord, the person who is today acting. My lord, he calls himself as an active chairperson. My lord, I ask a question myself, my lord, to call somebody a chairperson, my lord, or a highest person of that authority, there has to be another notification. He cannot himself call himself. He was appointed as a member.
So that's why, because they are harping upon the notice issued as the chairperson of the tribunal. Correct.
But he is not appointed as a chairperson.
That's if it is not a chairperson as per your submission.
Yes, the notification says.
No, he has not been appointed by way of notification as the chairman.
Yes, ma'am. My lord may see this. So these points were never argued in any of the court. That's why I wanted to show, my lord. And then I'll come to the division bench, which is also pending in Supreme Court.
That I supposed to put the question to you, what you are argued.
My lord, I have an argument to that, my lord, direct.
Where is that notification?
Yes. My lord may just see the notification, my lord. My lord, it is at page number, my lord, 10.
Second notification.
690, my lord, at the top.
Second notification.
Second notification, my lord.
690.
690.
Yes.
My lord may see. The President of India is pleased to appoint Sri Pradeep Upadhyay, department, as a member in adjudicating authority under prevention of money laundering. So and so, my lord, for the year 5 years, date of assumption of charge or attaining 65 until further order, which is so and so. He is appointed as a member, my lord.
He is the Pradeep Upadhyaya.
Yes, my lord. My lord, he is a finance person, my lord, a single member sitting. Now today, my lord, he designates himself as a chairperson, acting chairperson, my lord. That is one, my lord, argument. Now, my lord, we will have to construct the act also harmoniously. My lord, 2 sections which I was reading, my lord. If my lord may see, the bench authority should be 3. There is no doubt about it. My lord, their argument is bench can be 1. But my lord, they also have to see the rules also, which is today challenged in Supreme Court.
No, his contention is that as per the rules, a member.
No, my lord, I will
and
show.
if it is found, it is to be heard by the other bench, consisting of the 2 benches or 3 members, then it will be taken.
My learned friend relies on section 6 only, not the rule. My lord may see section 6. The
I
section
have
6
not yet finished my argument. So my learned friend cannot assume what I am relying.
My lord may see section 6
Hey,
of the act.
PML मंगाया नहीं तुम?
Adjudicating authority is also defined under the Act.
नहीं है, नहीं है.
And why, my lord, I say that this requires consideration is because of this aspects only. My lord, nothing is changing. They have my properties are still with them. They cannot get a higher degree of attachment over this. And that's why, my lord, this is a boiling issue in the country, and all countries are waiting, my lord, for this only issue. My lord, may see. Section 2, my lord, for a minute. Adjudicating authority is, my lord, defined. Adjudicating authority is, my lord, 2A.
Yes.
Means an adjudicating authority appointed under 1 of 6. My lord, that means, my lord, the authority will composite of 3 members only.
Adjudicating means adjudicating authority appointed under 6(1).
Now, my lord, may see 6(1). 6(1) says shall have 3 members.
Correct.
So first, my lord, argument is authority is, my lord, today incomplete. There is no 3 member is not there. Argument is divided in 2 parts. One, bench. Second is authority. Is the authority duly constituted? Answer is no, because 3 members are not there. My lord, I again ask a question to myself, my lord. Supposingly, my lord, the person feels conflicted or do not want to do a matter. Where will the matter go? Nowhere. Because there is no other person. One. And not 6(1) notification I have read.
No, then
Yes,
kindly come to 6.
Yes,
The
lord.
central government shall by notification appoint bracket an adjudicating authority bracket close to exercise jurisdiction power and authority conferred by. Then one, that is 21. Now come to the substituted by one or more adjudicating authorities. Prevention. So
Yes, lord.
now then 2 it has come, an adjudicating authority shall consist of chairperson and 2 members.
Yes, lord.
So your submission is that adjudicating authority cannot be a single, it should be a 3.
3. Rather, my lord,
Okay.
the constitution bench, my lord, who has challenged the wires and tested where it is challenged, Vijay Madan Lal Chaudhary, my lord.
That has been, yes,
My lord, Vijay Madan Lal quotes
Correct.
that it has to be 3 member only.
Yes.
My lord, that paragraph, if my lord may just note that of the Vijay Madan to conclude that whether it's to be 3. So one notification says it, the word is shall. Section 6(1) says shall. Adjudicating authority words use shall. Now, my lord, may see Vijay Madan Lal.
Yeah.
My lord, it is in my, if my lord can have
judgment का files रखा होगा.
my lord, if my lord, it is in my
Compilation.
petition. My lord, may I have my petition item 16, my lord, it is part. My lord, may see.
कल दिया ना compilation में देखो दो सेट होगा.
My lord, list of authorities I have given, my lord. My lord, because this is a new act, my lord, evolving, tested in multiple courts, and that's why the court, my lord, may have page number 41 of my judgment compilation, my lord.
Which one? First or 2? First or second?
First one, my lord.
Page
41. Para number 312.
Yes.
As aforesaid, section 17, my lord, it starts from the paragraph. My lord, may have in the middle. It starts further. Such reason recorded along with the material is required to be forwarded to a 3-member adjudicating authority appointed under section 6 of the Act, headed by a person qualified for an appointment of a district judge in a sealed cover to be preserved for a specific period. So, my lord, it is, my lord, at that point of time also was the court's conscious, and my lord, it is also in the parliamentary debate. I have placed, my lord, the parliamentary debates also, that 3-member committee is required, my lord. Tribunal is 3 members. And my lord may now see, which my learned friend, which my lord is the only argument, my lord, of the ED. May not say them because they still have to open. Section 6, my lord, again.
Yes.
My lord, I'll go slow and read section 6, 5, and 6, 7 are the only arguments. subject to the provision of this act. The jurisdiction of adjudicating authority may be exercised by benches thereof. A bench may be constituted by the chairperson of the authority with one or two member as the chairperson of the adjudicating authority deemed fit. So, my lord, chairperson can
Either two or three.
either 2 or 3. My lord, 7. My lord, they read this as having one. That is the problem. It says chairperson either 1 or 3. If at any stage of hearing, any case or matter, it appears to the chairperson or a member that the case or matter is of such nature that it is ought to be heard by the bench, consist of two member, the case or matter may be transferred by the chairperson, or as the case may be, rendered him to transfer to such bench as the chairperson. So, my lord, with limited knowledge, my lord, both the section does not say it can be a single member. The way ED reads, my lord, this is that chairperson alone can do it or a member alone can do it. It does not say, my lord. So one authority is not complete. Second, a bench has to be 2 people minimum. And that is why, my lord, they have issued a notification now to appoint.
So why the 7 has come? If any state.
Yes, my lord. So, my lord, because sometime what happens is, my lord, accountancy is the issue. Now, chairperson is sitting with, my lord, one is an administrative function.
That's why I ask whether any notification is there.
Nothing.
The single bench is required to be taken up this type of.
Nothing, my lord. Nothing. There is no notification, my lord, to that respect. And, my lord, this can happen, my lord, when the chairperson chooses, my lord, this is a difficult position, my lord, where some accountancy is there. That is why a financial person is there. But this is the same situation in Consumer Acts also, my lord, where technical member is there. Can a technical member independently, my lord, decide the matter? Answer is no. My lord, may just see how will he discharge functions under 11, my lord. Section 11. These are judicial functions. Today, my lord, ED argues in different court, we are not, AA is not a judicial. My lord, may see 11. Power regarding summon, production of document and evidence, my lord. My lord, before adjudicating authority, it's a civil court. Summoning, production, even cross-examination can happen. Correct. And my lord, may see 3. These are judicial functions. So, my lord, can it be done without being a judicial person on it, my lord? And that is why the first notification has come now, my lord, to appoint a judicial person. My lord, may then have, there is a consequence to it. 62. My lord.
Yes.
My lord, may see. 63 actually. Any person willfully or maliciously giving false information causing arrest or search under this act. There is a imprisonment, my lord. Search is before the AA, my lord. So, and 2, my lord, also. Even the search is found wrong. 63(2). Now, my lord, may see, we have to harmoniously construct the, my lord, act. My lord, may see the rules, my lord, for a minute. It says who will sign the order. My lord, may see the rules. After the act, my lord, it is there. Lord, I have given the rules yesterday. So it is part of the Bear Act also, my lord. My lord, Rule 26 at page number 21.
Yes, you have pointed out. Yes, I have taken note.
Order has to be signed by 2 people minimum.
Correct.
Now, my lord, show cause notice says on behalf of adjudicating authority. Authority is defined minimum 3 members.
But the so cause notice issued. So cause notice issued by the chairperson as per the document.
Yes, my lord.
Whether the notice is to be issued by the 2 members, 3 members, or 1
My lord,
person can be.
The order says to be issued on behalf of the adjudicating authority.
Correct.
Now, authority, my lord, is consisting as per the definition 3-member. Composition of authority is not complete. One.
That's correct, but there is no order issuing so cause notice. There is an order.
There is an order.
Where is order the issuing so cause notice?
I'll let you show. Which my lord may have my lord may have my item 16, my lord, if my lord. The file.
16, 17. Yes.
My lord may have
Page
413. At page 414. Acting, my lord, chief chairperson, my lord.
Correct. Adjudicate acting. So where is the order for issuance of the so cause notice? Directly it was issued and the proceeding was initiated.
My lord, the show cause notice is issued.
So it's a so cause notice.
Yes, my
The
lord.
so cause notice is issued there might be a proceeding. Then
There is a procedure, my lord. What happens is after attachment, ED has to file within 30 days an OA.
Correct.
After filing of the OA, the show cause notice is issued, my lord.
Yes, filing of the OA, then there will be an order.
There's an order, my lord.
There will be an order.
Yes, my lord. This is, my lord may see the order.
There will be no order,
The show cause notice is the order, my lord, only. There is no separate order, my lord, for it. And my lord, because section 8(1) does not use the word order, my lord. It was the use show cause notice.
No, if your rules.
Yes, my lord. The rules use the word order. Yes. So, my lord, I am only
Because
saying.
if the rules,
Yes.
every sheet of the order bear the signature of the chairperson members. But here, it has been issued by the chairperson,
Lord,
acting whatever it may be.
My lord, how will he pass the final order then? The final order will be an order.
Final
Can
order?
it be passed, my lord, in terms of rule 26, my lord, then? Can he himself signs it? Is the question one. Let us take it, my lord, that this may not be considered as an order. It's a show cause notice.
Correct.
But, my lord, it will still be because in the show cause notice 8(1) says he has to apply his mind, give a reason to believe, then pass the show cause notice. It's in the nature, my lord, I will still see that is the nature of an order. If my lord may feel for any reason, because they'll be hyper technical on these issues or words, my lord, the final order has to be in rule 26. How it can be passed?
No, final order what? So cause notice issued, report filed, AO has been initiated, OA has been initiated, then so cause notice. After the so cause, then you have to file the reply. Then the proceeding is started. If you want to document evidence,
My lord,
whatever it is.
In adjudicating authority, my lord, there is only one hearing. On the day of the show cause notice, this order, the first hearing comes, my lord, at the date of final hearing. My lord, I am doing some 100 matters. There is no hearing in between. There is no, I cannot even do anything, my lord. The last hearing comes on the day of the final hearing when these orders are passed. Please see, show cause notice says come on the final hearing. Timeline is set. It's like an arbitration. You set a timeline, fixed, and final hearing. In this matter also, there is never an hearing.
Yes.
It is now coming on 29. Now, my lord may see, just for a minute, my lord, and I will deal with the judgment of the division bench of this court also. My lord, one, I wanted to point out, my lord, there is only one, it is my respectful submission. Supreme Court, my lord, is dealing with the batch of matters exactly on this issue. My lord may just see my writ petition for a minute. And not only, my lord, various other high courts are relying on the judgment of the Calcutta High Court also. My lord may have, this is the Calcutta High Court judgment at page number 65 for a minute. Much water has flown in time, my lord, and these provisions are not read.
Of the first?
Of serial number 16, my lord. No, my paper book, my lord.
Paper book. Which, that writ petition?
Writ petition 16.
Page 60.
65.
Yes.
My lord may see this is the Calcutta High Court, my lord, an order of the court, interim order. This order deals with the division bench judgment, my lord. And I will show, my lord, that with as per the judgment of the Supreme Court, whether this order holds good today or not. My lord may see Ativo economic zone, my lord. My lord may I'll read only from my lord para page 66. Exact this issue was raised.
Yes.
June 2066, June 23, but instead of appointing any chairperson,
Where from you are reading?
look, it's page number 66, second line. But instead of appoint of any chairperson of adjudicating authority on the same day, Mr. P.K. Upadhyay
Yes.
has been appointed as a member of the said authority, statutory adjudicating authority. Mr. Datta has emphasized that such an appointment is the provision of law. To substantiate the argument, he has relied specifically on 16(2) of the said act to submit that an adjudicating authority shall consist of chairperson and 2 members. He has also put forward that accepting the forum being available consisting of person as examined in 6(2) of the act, adjudicating authority cannot be considered to have functional capacity in the eyes of law. He has stated that in place of the chairman, a chairman thereof can only be appointed and not a member. The appointment is illegal. We suggest that Mr. Datta has referred to the division bench order of this court to submit that other similar notices have been stayed by the division benches. Hence, according to him, the proceeding of the case present would not jeopardize any interest. My lord, then my lord may see the ED submission at page number 67. On the last paragraph, on the merit, she has submitted firstly that there have been several decisions of various constitutional court interpreting the law in the way that single member of the adjudicating authority would be competent to adjudicate any matter under the provision of the act. This proposition is relied by RP Infosys. Well, this is the judgment of the division bench, my lord, which is there. And then, my lord, court goes on and at the end passes the order, my lord, staying the proceedings. This is one. My lord, this judgment has also been, my lord, may just see my compilation for a minute. Page 71, my lord. Onward. Just one page where I want to show at page 115.
Which one?
In this one, paper book. My lord, there are orders of every court till 2025 December, my lord. I was appearing in those matters, my lord. But just to show, page 115, my lord.
Yes.
This is one of the Punjab Haryana High Court, my lord, which records at page 116 the exact issue pending in the batch matters in the Supreme Court. One of the SLP number at serial number 4 is RP, the division bench of the High Court, my lord. And the court said, let us await, my lord, hearing because attachment is with them. Nothing is going on. Then, my lord, may see at page number 133, my lord. Madhya Pradesh High Court relying on the Calcutta single judge, my lord, passing orders, my lord. And what these orders are consistent. Delhi batches are pending, my lord. Chandigarh, Bombay, Madhya Pradesh on this issue, my lord. Well, this is a core issue. And this is, my lord, may see now for a minute. My lord, there was only one judgment, my lord, of the Delhi High Court where it all started. Delhi High Court, my lord, said single member can do it, my lord. This was started in Delhi. ED themselves challenged that order, got an absolute stay on the judgment. My lord may see page 1 of the compilation.
Of this third compilation?
Yes. My lord may just see.
Yes.
My lord may just see at page number 1. My lord, this is the judgment of called J. Sekhar, challenged to the Supreme Court by the ED himself. Now, my lord, this is stayed in all totality. This is, my lord, relied by the Calcutta Division Bench, my lord, saying that J. Sekhar, Delhi High Court decides the issue. In spite of that fact, my lord, why, my lord, ED in every other court not able to proceed because of this fact? Now, my lord, may see for a minute, my lord, I have placed in my first compilation a judgment called Eastern, where a direction was given to the ED to make 3 people and all proceedings were stayed. My lord, may say Eastern.
Yes.
My lord, may just that one judgment, because that is a judgment which holds the field today. My lord, may have page 5.
Sikkim bench judgment.
First, my lord, first compilation. The
Is a
judgment
Sikkim-
is called
Sikkim-
Eastern.
Sikkim bench.
Yes, my lord. This is challenge to this, my lord. Page 5, para 19.
Yes, you have pointed out. I take
Now, my lord, this judgment is taken to the Supreme Court and has culminated into a batch. ED is not able to get a stay in that. My lord, may just see that the latest compilation I gave, my lord, in that this order is there. That's how the batch has been running. My lord, and we are fortunate being part of that batch, my lord, doing in Supreme Court. But my lord, may just see for a minute.
Which page?
Just one second. My lord, may have page number 97. This was challenged to the Supreme Court, my lord, by the ED. No stay. In this case, the High Court has passed an order directing Union of India to take step for further for appointment of the judicial member of the adjudicating authority under the provisions of prevention of money laundering. Petitioner applied for modification, clarification of the said order, which has been rejected by the High Court. Our attention has been invited to the fact that the issue of adjudicating one judicial member arise in 5 other cases. My lord, serial number 4 is that RP, and my lord, the court says club it. My lord, this is ripe for final argument coming up on 31st. So that is why everybody is waiting, my lord. One. That order is also, my lord, I have placed on record.
31st of January.
Yes, my lord. 30th of January is the order, my lord. I saw in one. Yes, my lord. 139. The whole batch is coming up, my lord. The written submissions are filed, my lord. Last page.
Yes.
The batch is coming up on 30th of January to be asked.
Yes.
Now, my lord, may just see the division bench judgment, my lord. And why, my lord, there was no stay on this order? Because by the time they went to Supreme Court, it's a year and a half. It was tagged to the batch of Eastern. Now, my lord, in this, the argument is exactly the same 2 sections. Neither Rule 26 was referred, nor notifications were referred, nor Rule 3 was referred. My lord, I have made a detailed chart, my lord, which portions are not being referred. The court relied on J. Sekhar, my lord, in this judgment and said, my lord, in that Supreme Court last compilation I gave, my lord, if my lord may just see page number 89, the order of the Supreme Court on this division bench judgment, my lord. Page number 89 of my last compilation of the Supreme Court order which I give. My lord, this Supreme Court petition was filed year and a half. By the time the proceedings were final, my lord, but they took the question up. 89. RP Infosys, my lord, it is also tagged to the same batch. My lord can see those numbers, my lord. Serial number 4, the number is. But my lord may see the date of this order. This order is dated, my lord.
18 March.
No, my lord. This order is dated.
Which order?
24. Supreme Court orders is 18th March 24.
Correct.
The division bench order, my lord, is of dated, my lord, 23.
August.
So, my lord,
18th August
yes.
23.
By that point of time, my lord, the adjudicating authority culminated the proceedings, so there could have not been a stay, which has been already there, but the question was taken up. Now, my lord, I understand my lord.
Whether this order was stayed by the Supreme Court.
It can't be, because the order was already passed by adjudicating authority. But Eastern, my lord, where the proceedings are stayed till today, ED is not able to take a stay on that. So today there is an order of Eastern which is not stayed, which is in the Supreme Court. Punjab, Delhi, all courts are, my lord, staying the proceedings on this issue. One, my lord, I can in advance preempt this, that they may say that the order passed by the court, the single judge court, even after the RP division bench, may not be binding effect to this court. That can be an argument raised by them. Just to satisfy that question, my lord, Supreme Court has this, my lord, as a committee of court, my lord.
Yes.
My lord may just have whether the orders which are passed not in limine and detailed orders of interim are passed will have a binding impact on this court or not. And if my lord wants to, my lord, with utmost humility, my lord, if my lord wants to differ from that opinion, the only option is a reference, my lord. My lord may just have this portion with regard to interim order. Consistency in rendering judgment or passing interim orders.
Which page you are?
My lord, first page, the judgment is called Pearl Enterprise.
Yes, yes.
Consistency in rendering judgment or passing interim order is an integral element of the judicial propriety and judicial discipline.
Legal propriety and
Legal propriety and judicial discipline. Judicial discipline is of the basis of integrity of the institution. We are even a stray aberration in such foundational values will affect the image of the institution as far as impartial. As far and impartial. Inconsistent order passed by a judicial officer in the same fact situation will undermine and shake the faith of the people in a judicial system and the rule of law, leaving an imprint in the mind of the litigant that he has been discriminated. The whole purpose of the protector institution is to prevent discrimination and arbitrariness. Hence, such institutions shall give not rise to even remotest feeling or situation of being inconsistent in their order, lest there should be an accused of partial. But in this also interim order was passed, which was taken up, some deposits for order. So one person in an interim order got an order of stay with deposit, other did not. Look, it went up to the Supreme Court. Court said no, both should be with deposit. Interim order. My lord, may just see the final findings, my lord. Para number 4, my lord. Interim order, no doubt, is at the discretion of the judicial forum. But that discretion is not arbitrary discretion. Discretion does not mean arbitrary fate of the person in a person passing the order. The decision has to be informed by reason. Objectivity, transparency, whims, and purpose are alien to the judicial process. Consistency in passing orders is a vital relevant factor. While exercising discretion in passing judicial order, let it should be misunderstood as an exercise of arbitrary power and attribution of motives. Exercise of arbitrary power is a pre-constitution concept and approach. This goes on and it goes on, that is interim. Only one thing, the judgment, my lord, is aware that if they want to espouse a cause, my lord, then the remedy is, my lord, is with again humility, my lord, will have to refer to a larger bench. This is the judgment of the Supreme Court, latest, my lord, on this issue. My lord, I am also on the second aspect. One is with regard to quorum, which goes to the root of the matter. The other is, my lord, whirlpool, which says, my lord, if things are, my lord, not in accordance with law, even a writ court can entertain this, my lord. In my case, my lord, 2 examples, I want to show only 2 pages. My lord, this judgment is on the reference point.
Copy not given.
My lord, two act I want to show. My lord, when they do a freezing order under 17.1, under 17.2, the ED has to immediately give all the material to the adjudicating authority. I have seen the whole OA, my lord. No document of that nature. Similarly, my lord, when an order under 20 is passed, as per 22, again, my lord, compliance has to be done. It has to be sent to the adjudicating authority forthwith. Not done. My lord, ED's cases, and my lord, in the other writ, my learned friend is arguing that it is a credit account could not be free. Similarly, my lord, they have frozen my bank account. The money which has come from the tax department, they have frozen that also, saying that this is direct proceeds of crime. Second, my lord, absolutely no bank statements are placed on record. My lord, what they did for freezing is they took the PAN card of every company and said freeze all the bank accounts. That is not the import, my lord, of this act, my lord. So complete arbitrariness. Apart from that, my lord, whirlpool will come into my aid, my lord. Even after that, the 2 to 6, my lord, can still entertain the petition.
Okay. That's all.
So, my lord, just to conclude, my lord, no prejudice will be caused to them. This is a issue which required consideration, my lord, a detailed consideration. They have the property with them. My lord is not releasing those properties right now. If the proceedings like stayed in other part of the country, the property still remains with them. Even after the attachment is done, they cannot confiscate because the law is confiscation can only happen once the trial concludes. So, my lord, this issue requires consideration. If my learned friend do not want to, my lord, file any reply to this and are ready to argue this, my lord, I have concluded. I will give a written submission on this aspect, my lord, so that it can be captured, my lord. If yes,
Lord, before my learned friend, for the AG submits, add in 2 minutes, my lord. 2 minutes.
You are appearing for
Lord, I am in 3 writ petitions.
Well, I
14,
he has
15,
said that
18.
Yesterday also, let all the matters be taken up.
No, one. Arijit, 1 minute. Just
because
2 minutes.
Otherwise, there will be a jumble of.
You will never allow anything to be jumbled.
We are doing item number 16. Let's conclude 16 first.
Lord, just do one submission. And this is, my lord, a jurisdictional issue which your lordships will consider. Number 1, by the freezing order, a large number of cash credit accounts amongst other accounts have been, my lord, frozen. Effect is, my lord, all these companies are going to become NPA any day and the businesses will be destroyed. Lordship, my lord, knows a cash 1 minute.
Number 16.
My lord, it is, my lord, please, just 1 minute. I just give the flavor of the matter and the unfairness of what you are
which matter you are having? Which serial
Four-
number?
14, 15, 18.
14, 15, 18.
Also have some cash credit. He's also got some.
my cards have been taken away.
No, car is fine, but cash credit also there. Cash credit.
Taken away. Bank account are
Joining issues.
My lord, just no. Cash credit is necessary. My lord, cash credit is I have a limit with the bank. Bank gives me, my lord, 100 rupee cash credit. And my lord, that's a limit. Now I draw 5 rupees and I have to repay 5 rupees with interest. But that 95 rupee limit which I have in my bank is, my lord, the bank's money. It's only my right to, my lord, draw on that for my business expense. It can never be my asset. It can't be frozen. This is the short point. My lord, other things my learned friend is arguing. I am here, my lord, in these matters only to persuade your lordship, my lord, that the cash credits have to be defrozen. He can't, my lord, attach my cash credit. It's not my asset. My lord, this is decided in at least 4 judgments.
Okay, let me hear.
I for the bank in those. Lord, after they finish, I'll come back and.
Lord, actually, I shall be adopted.
This is very important.
I am appearing in item number.
All companies are
I
going
will
to be
hear
defunct.
it. Yes.
I am appearing in item number 14 and 15. I shall be adopting the submission of the learned counsel for the ED. Before that, I am just making.
You are appearing for Union of India.
Yes, in 14 and 15.
Yes.
I am making a preliminary point. Admittedly, there was a show cause. And before issuance of show cause, there are detailed reasons that was not placed before your lordship. That warrants the issuance of a show cause.
Yes.
And it is well settled that against the show cause, there is no provision for maintaining a writ petition. He has to submit before the jurisdiction, take all these pleas which are being argued, that the adjudicating authority has no determination, jurisdiction to adjudicate. Number 1. Number 2, that your lordship will kindly appreciate that the Calcutta view of the division bench and the single bench has been accepted by the Telangana division bench and the Madras division bench. That adjudicating authority, being a single member, has jurisdiction to issue such things, and in the event this single member feels that there is complexity in adjudication, he can refer it to division bench. That I will be placing before your lordship, the Telangana view, latest one. Now, the notification of adjudicating authority has been issued, that is at page 385. Therefore, it is a question of jurisdiction. At the interlocutory stage, no final relief can be granted, either defreezing or anything. This is well settled. No interlocutory relief rising up to the final relief can be granted. Now, I shall be just placing before your lordship This RP Info Systems Limited, the division bench was followed by the Madras and the Telangana. They are holding that yes, single member adjudicating authority has jurisdiction to adjudicate under section 6, subsection 4. So many things have been said about section 6(1)(3). Now kindly come once in the list to section 6, subsection 4. If there is harmonious construction, the later provision shall prevail over the earlier provision. That is the settled law. Kindly come to section 6. Adjudicating authority, composition, powers, etc. As you also got it. Section 6.
Yes.
Section 6, subsection 4.
Yes.
The central government shall appoint a member to be the chairperson of the adjudicating authority, subject to the provisions of this Act.
Correct.
The jurisdiction of the adjudicating authority may be exercised by benches thereof. Then B, a bench may be constituted by the chairperson of the adjudicating authority with 1 or 2 members. Has the constitutional validity of this provision been challenged before your lordship? No.
No, that's why the bench may be constituted by the chairperson of the adjudicating authority with 1 or 2 members. So chairperson will be there along with either 1 member or 2 members. Kindly read this. B. Bench
Yes.
to be
The
constituted
bench may be constituted
by the chairperson
of the
either
adjudicating-
1 member or 2 member. It is not the bench should be 1 member.
But the chairperson has a jurisdiction or determination to appoint a single member at the adjudicating authority. That is not disputed anywhere.
Correct.
Therefore, the question which falls for determination here is whether the adjudicating authority has jurisdiction to adjudicate. Now, if he says that I have a jurisdiction, now that has to be invoked by submitting so cause there. There you have no jurisdiction.
Okay.
Why the writ court shall entertain all such fact finding and roving inquiry of this issue.
So if I will record your submission, yes, after the so-called reply, you will give proper opportunity of hearing and all the evidence, and you will not pass any prepared order for attachment before giving any opportunity, because now they have what they are submitting. After submitting the so-called reply, you will pass a prepared order without any evidence, without any hearing. So what will happen to that?
No, if that situation arises.
No, if you take the point of jurisdiction and point of maintainability, if the authority no point of maintainability, and he will pass appropriate order for attachment.
So that is applicable order. That is applicable order under this statute.
Okay.
Therefore, there is remedy if it is exhaustive.
Okay.
And it is a complete code. Therefore, he is not prevented from justifying his cause.
Okay.
If an illegal and arbitrary order is passed by the adjudicating authority, that the forum is not sealed.
Okay.
It is either before your lordship or by the appellate authority. Now comes the moot question of the Telangana view. This is by the Honorable Chief Justice and the Honorable Justice Anil Kumar Jukanti. This is writ appeal number 611 of 2023. This judgment is following Calcutta view and the Madras view and holding that a single member has jurisdiction. Will not kindly come. Last but copy acha copy ache. Copy ache. This just will not kindly come to last but 3 paragraphs. This starts from page 27.
Yes.
Page 27, para 23. Thus, powers under section 6 can be exercised by an adjudicating authority comprising single member. Therefore, the proposition that powers under section 8 of the PMLA can be exercised by the adjudicating authority comprising only from member in the field of law does not deserve acceptance, as the same would render provisions of section 6.5 and 6.7 of PMLA nugatory and ineffective. Then 24. Insofar as decision of such and such on which reliance has been placed It is noteworthy that the Supreme Court in aforesaid decisions dealt with the section such and such Electricity Act and held that commission was the option for adjudicating the disputes between the licensees and the generating companies or refer the same to arbitration. In the aforesaid context, the Supreme Court dealt with the issue whether the State Regulatory Commission constituted under Electricity Act, which necessarily performs the function of adjudication, is required to have one member who was or is holding a judicial office or is a person possessing a professional qualification with substantial experience in the practice of law. The aforesaid decision is of no assistance to the respondents. It is also permitted to note that the validity of section 6263A II and 65B and Preliminary Act was challenged before the Madras High Court. The division bench of Madras High Court in such and such passed this order, has upheld the validity of the aforesaid provision and has held that composition of adjudicating authority in the absence of judicial officer is not bad in law. Division bench of the Calcutta High Court is just now showing RP Info Systems has also held that the adjudicating authority can comprise of a single member bench. We are in agreement with the view taken by the division bench of Madras High Court and the Calcutta High Court. And this Calcutta High Court judgment of the division bench now I submitted by my learned friend is pending before the Supreme Court. No stay. Huh? No stay has been granted. Your lordship is to follow the Calcutta Coordinate Bench judgment or the division bench, and the other judgments are of persuasive value, not the binding precedents. Now, kindly once allow me to place my learned friend will satisfy your lordship. Section 6, subsection 5 and 6. Section 6. Section 6, subsection 5, I have read, and 7. If at any stage of the hearing of any case or matter it appears to the chairperson or a member that the case or matter is of such nature that it ought to be heard by a bench constituted of 2 members, the case or matter may be transferred by the chairperson as the case may be referred to him for transfer to such bench as the chairperson may deem fit. The chairperson or every member shall hold office as such for the term of such and such. Therefore, this subsection 7 is a continuation of subsection 5 and 6. Notwithstanding anything contained in subsection 5, the chairperson may transfer a member from one bench to another bench. Therefore, these provisions of allowing the single member as adjudicating authority, not even a judicial member, these are not set aside by any court by declaring it ultra vires. Therefore, their remedy, if any, lies before answering to the so cause and to avail the forum in the event it is decided against them and the forums are not closed, either it is returnable to your lordship or before the other appellate authority. These are the submissions.
Yes.
And subject to what Mr. Chakravarti for ED will submit. Kindly allow me to leave.
Yes.
I am appearing in item 14 and 15.
14 and 15 or 13, 14? 14, 15.
14 and 15. Okay, I know. Brother. Lord, may I leave?
Yes.
Copy আছে
আমার কাছে ট্যাবে আছে
আচ্ছা আমি নিয়ে নেব পরে
16, 17.
Yes.
Now, my lord, speaking for the Enforcement Directorate, since the Learned Counsel, Senior Counsel appearing in item number 14, 15 and 18 has also said that he is also adopting the issues on quorum non judice. He has added one point.
I have not finished adding.
As he said that he is also taking quorum non judice, but I will be answering on the issue of quorum non judice for all the 5 matters together. So whatever I will submit, your lordship can consider it to be submission on behalf of ED in all the 5 matters on the issue of quorum non judice. Now, my lord, coming first, sir, আপনি এদিকে চলে আসুন সুবিধা হবে এদিকে সরে স্যার ওদিকে চলে আসুন এদিকে Now, my lord, your lordship was reading.
First of all, you tell me, once the matter is pending before the Honorable Supreme Court, whether, okay, this court has passed an order, division bench has passed an order, Madras High Court has passed an order. But once the matter is pending before the Honorable Supreme Court on 30th January, it is coming up for hearing whether the single member can decide. So whether at this stage can this court go into the merit further?
My lord,
That is the only question first.
my lord, here, my lord,
Once the Supreme Court is having the session of the matter on the same
my
point.
lord, there are two options. My lord.
And what
Now,
is
let
the
me not go
what-
into these quarrels.
And what
Let
is
me find out a shortest possible way as an officer of this court at this stage on
Correct.
the issue of pendency of the bunch of matter on this issue before the Honorable Supreme.
correct?
Whether stay is there, not
That is
there,
different thing.
some matter there, some matter not there, I'm not going to. But what is the adjudication procedure? Your Lordship has already, I'm not trouble your Lordship with much. Lordship has seen section 6, section 8, section 11. Now, my lord, what is the stage of this particular case? This particular case, the show cause notice has been issued in September 2022. Your Lordship was looking, Lordship will kindly take volume 4, page 413
Of which writ application?
of serial number 16, the WPA 1387.
1387.
Yes.
Page,
Your Lordship was there only. Page 413.
Yes.
Now, my lord will kindly, this is the show cause notice.
Yes.
Kindly turn to 414.
Yes.
My lord, this was issued on 23rd of September 2025 at the bottom.
Correct.
My lord will kindly take paragraph 5.
Yes.
Prior to that, my lord will kindly come to 413 back. My lord, I'm sorry. I'm troubling your lordship. Para 4. On receipt of the show cause notice along with OA and RUD, the respondents are required to file their written replies on e-portal. The respondents are also required to submit the replies by email to registered adjudicating authority in both MS Word and PDF format on or before 3rd of November 2025. Right, my lord? Now, towards the end of this paragraph, your lordship will find, after that, we are to file our rejoinder by 10th of December. Then kindly see the last sentence. In case an opportunity of hearing is provided on 29th of January 2026 at 2:30 p.m. So this is notified. Date of hearing is notified on 23rd of September.
Yes.
Now, my lord will kindly turn the page and come to paragraph 5.
Yes.
It is also brought to the notice of the applicant and respondent that at least 7 days before the scheduled date of hearing, which is 22nd January 2026, for a meaningful discussion on the main issue in connection with the case, the following submissions are required to be sent to the email. Now, my lord, I was just asking the question yesterday because this document does not carry the further documents. What happened after the show cause was issued? But nothing happened. They failed the date of 3rd November, no reply. So we had no opportunity of any rejoinder by 10th of December. 29th January is the date of hearing fixed since 29th of September, 23rd of September. They came up before your lordship today and say that kindly stay it. 22nd January, they are to provide these documents. They have not. Instead, what they have done? Reply copy. On 24th of January, during this intermediate holidays of 23rd to 26th, 24th of January, they emailed their reply to the show cause notice. Now, the only intention is that if I file the reply on 24th, on 29th, ED will pray for time to file their rejoinder. Hearing cannot be done. Now, what is the content of the reply? But I am carrying reply of each of the respondent represented by my learned senior friend. Because he is representing in 2 petitions consisting of 13 and 4, 17 notices over there. In each of the reply, your lordship will find they have made it an interim reply. Why? Because they want to invoke section 11. that examination, cross-examination.
Correct.
Yes, they have the right. So the question that 29th is the only date, only one hearing, they will pass order is absurd. Today, this particular case, well, I'm not on quorum non-judice. Your Lordship asked me what should be done. I'm trying to find out a solution. But let the adjudication proceeding go on. Because I will be placing judgments, one judgment placed by my learned senior.
No, then again it will be.
I'm correct.
If today, this court will allow. I will accept your submission. This court will allow, okay. The court will extend the time. You already filed the reply. Or you want further reply, you can file the
But he will,
reply.
the A will
You can give the rejoinder or whatever it may
Yes,
be,
yes.
and the authority will proceed in accordance with law. If they wanted to invoke the provision of section 11, then the authority will give them. There is no problem at all. But suppose tomorrow the Supreme Court will hold that yes, the single member cannot issue these.
Where I am.
Then what will happen?
Where I am. I'm coming to that. I'm coming to that also. But what is the stage? The stage is of show cause notice. Show cause is under section 8, subsection 1.
Correct.
It does not say that it requires signature of 2 persons, rule even. But I will be arguing that rule cannot override the act. Well, I'm not going into that right now. Question of quorum, whether single member can or cannot. My lord has already seen Calcutta High Court Division Bench. My lord, I think Calcutta High Court Division Bench has been handed over to your lordship. The reported version is SCC online. I'm not reading it because your lordship has already seen that. Right. Now this was followed
by the Telangana and Madras High Court.
No. Prior to that, my lord. I'm coming, my lord. Kindly allow me some time. This is coordinate bench of this honorable court.
Yes.
My lord, kindly come to this judgment. This. By the first paragraph, second paragraph. The primary ground of challenge is that the adjudicating authority was quorum non-juris. Para 2 I am reading. Second page.
Yes.
It is contended that a single member who is only functioning member of the adjudicating authority, not a judicial member, not being a judicial member, issued the show cause notice. But identical fact, identical contentions. Para 6, particularly a single member is required to be a judicial member since the nature of function dispensed with by the said member is in nature of an adjudication. But identical submissions, identical, kindly come to para 8. Copy of an office order dated 22nd June 2022 indicating that the member who issued the impugned show cause notice was appointed merely as a member and not as chairperson. I'll answer this also. Though this judgment says that, but your lordship will have to take recourse to section 6, subsection 13. Kindly take subsection 13 on this point. In the event of the occurrence of any vacancy in the office of the chairperson by reason of his death, resignation or otherwise, the senior-most member shall act as the chairperson of the adjudicating authority until the date on which a new chairperson appointed in accordance with the provisions of this act to fill such vacancy enters upon his office. So, the show cause notice issued as chairperson within bracket acting is in accordance to section 6, subsection 13. The same plea was taken in this judgment also. But may I come back? Then paragraph 12, the Honorable Single Judge has relied upon the judgment passed by the Honorable Division Bench, and thereafter, kindly see the last sentence. Reference was also made to a judgment called named Maqbul Hussain versus State of Bombay in 1953 Act reported that was referred. Now, para 13, in the light of the said decision, the division bench of this court held that the proceeding before the adjudicating authority appointed under section 6 of PMLA and the declaration adjudication and confiscation of properties involved in money laundering by the adjudicating authority does not constitute the prosecution, nor the order of confiscation would constitute a punishment inflicted by the court or the judicial tribunal. It was further observed that there can be single member bench of the adjudicating authority and the appellate tribunal under the PMLA, and such single member bench need not mandatorily have to be a judicial member and can be an administrative member as well. The division bench went on to find that it is clear that the adjudicating authority, which comprises of a single member bench, is entitled to adjudicate the matter, and on any other interpretation would tantamount to distorting the language adopted in the statute, which is impermissible. Skipping section 613, which I was referring, is at page para 16. Then 17. The question which fall for consideration thus are whether the single member who is functioning as an adjudicating authority at present, in the absence of any specific designation to perform the function of the chairperson, in the absence of the chairperson, could assume jurisdiction as contemplated in section 613 of the PMLA, and whether the said member, not being a judicial member, could issue a show cause notice. Insofar as the first question is concerned, section 613 of PMLA is unambiguous in this language. The said provision clearly provides that in the event of any occurrence of vacancy in the office of the chairperson, as contemplated therein, as in the present case, the senior-most member shall act as the chairperson of the adjudicating authority until the date on which the new chairperson appointed in accordance with the provisions of the Act to fill such vacancy enter upon his office. Thus, there is no stipulation in the said provision that an ordinary member has necessarily to be designated as an acting chairperson of the adjudicating authority for the purpose of assuming jurisdiction under 613 of PMLA. In the event there was necessity for such separate designation, the provisions of 613 would be rendered meaningless and academic, since in such circumstance the member is actually designated as chairperson or an acting chairperson, leaving no scope of operation of section 613 of PMLA. Only in case where there is no specific designation of a member as a chairperson or an acting chairperson does the occasion of the ordinary member acting as a chairperson arise. Thus, the contention of the petitioner that there had to be a specific designation of the member as a chairperson does not hold good ground. In the present case, the person who issued the show cause notice was admittedly a member of the adjudicating authority and was the sole functioning member at the relevant point of time, since there was no other member or even any chairperson acting at that juncture. That is the same in the present case. Hence, by operation of section 613 of PMLA, the said ordinary member was well within his jurisdiction in issuing the show cause notice, since he is acting as chairperson under subsection 13. It is automatically deemed that he authorizes himself in the absence of any other member within the contemplation of section 6(5)(b) of PMLA. Insofar as the question of member being necessarily a judicial member in concern, the ratio laid down by the division bench in RP Infosystems Limited Supra is clear. No manner of doubt is left on even a cursory perusal of the said judgment that the division bench squarely observed that even a single member who is not a judicial member is equally entitled to pass an order under PMLA. Thus, faced with the dilemma of the following judgment of a learned single judge of the Telangana High Court and the division bench of this court, judicial propriety and the norms of precedent demand that the division bench of this court prevails in so far as this bench is concerned. Thus, going by the said ratio, the single member of the adjudicating authority who issued the show cause notice, as well as authorized within the contemplation of PMLA, even without being a judicial member and without being designated specifically by the central government to act as a chairperson, to issue the show cause notice by assuming charge under section 613 of the PMLA. In such view of the matter, I do not find any scope of interference with the show cause notice on the ground of lack of jurisdiction of the member of adjudicating authority. Yes. This is a coordinate bench. Now, my lord, I'm referring to, because my learned friend was referring to section 6, section 11, section 62. But I'm thankful that I need not to go into anything because I will just read this judgment of Honorable Madras High Court. Yes, yes. This is the matter after RP Infosys. This is the matter probably which is not before the Honorable Supreme Court. But kindly come to second page of this unreported judgment. Dilam to. Kindly. This division bench of the Honorable Madras High Court, para A. This writ petition is filed to declare that section 6.2, 6.3A2, 6.5B of the PMLA as unconstitutional for violating Article 14. But I am reading A. Now, my lord, I am skipping the entire fact of the case. Kindly come to the fourth page. My lord, the page number is at bottom. Page 4, C.
Yes.
It is at this stage, while keeping open its defense on merits to be taken up by the adjudicating authority, the violence of the provisions mentioned in para 1 above are challenged. It is the case of the petitioner that the adjudicating authority acts as a tribunal and it has trappings of a court deciding the rights of the parties. It cannot be without a judicial member, and thus the very constitution is illegal. The impugned provision also enables constitution of single bench by which there can be a bench without the legally qualified member, which is per se. Now, my lord, I'm again skipping a few submissions part because submissions will show that the submissions made from the my learned senior are identical. The judgments relied upon in the compilation referred here by the petitioner identical. Now, my lord, will kindly come to the issues framed by the Honorable Court. Page 14, para F. The points for consideration. We have considered the rival submissions made on either side and perused the materials records of the case. The following questions arise for considering in this writ petition. Number 1, whether the composition of adjudicating authority is bad in law, inasmuch as it is not manned by a judicial officer, person eligible to be appointed as judicial officer. B2, when the adjudicating authority is considered to be a single entity or institution, whether the power conferred on the chairman to constitute single or two-member bench, which can be even without a legal member, is illegal. Now, my lord, why the question is single stroke two-member? Because when it was placed before your lordship, 6.5B, it was found that either it will be two-member or three-member. Well, kindly take 6.5B for once again for my satisfaction. And this is a very interesting thing, my lord, because this is probably a sixth matter I am doing on the same provision. But the reading itself of this provision, kindly see. B, a bench may be constituted by the chairperson of the adjudicating authority with, so my lord, the bench will be with one or two members. So 6.5B clearly says bench will be with one member or two members. The submissions came from the bar. Is chairperson with one is not correct interpretation. Can you read with me again? A bench may be constituted by the chairperson of the adjudicating authority with one or two members. So the bench will be, my lord, single or double division. Bench will be with one member or two member. It is not chairperson with one member or chairperson with two members. Then, my lord, I'm putting it hypothetically. Then, my lord, if two benches are functioning, chairperson has to be both in the benches. If that is the interpretation, that chairperson has to constitute a bench by himself with one member or with two members, then every time the chairperson has to be in the bench. That cannot be a correct interpretation. It is a bench with one member or bench with 2 members. Why I say so? But I will read it with the rule 26.
Yes.
Now, my lord, rule 26, your lordship had the opportunity to see that signature. Kindly see.
Yes.
26.2. Every sheet of the order
Yes.
shall bear the signature of the chairperson
Correct.
and members constituting bench.
Every sheet of the order shall bear the signature of the chairperson.
And members. Members.
Correct.
Members constituting the bench.
Correct.
So even if chairperson is not in the bench, he will sign the order sheet. Suppose a bench is there without chairperson. Then also this 26.2 will applicable.
How a person who is not in the bench?
That is what I am saying. Cannot. Then cannot. Then every sheet of the order shall bear the signature of the chairperson and members constituting the bench.
Correct.
So if the order sheet has to be signed, then the chairman and members will be there. So there cannot even be a division bench. There will always be a triple bench, chairman and members.
Correct.
So there cannot be a bench consisting of 2 members even. If we go by the language of rule 26.2.
Every sheet of the order shall bear signature of the chairperson.
Correct.
So chairperson signature is must.
Correct. So we are assuming chairperson is in the bench, Miller.
Bench.
Correct.
Correct.
Then
and members.
Members, 2 members.
2 members.
So both have to sign.
Yes.
So every order sheet, my learned friend will have his turn once again. No difficulty. He has taken 2 days time. Now, my lord, the members, the adjudicating authority shall consist of a chairperson and 2 other members. 6.2.
Correct.
So if 26.2 is taken into its verbatim literal meaning, then every order sheet has to be signed by 3 of them. Correct? Whether in bench or not in bench. So whether in bench, not in bench, they will sign.
But the question is whether it is practically, and it is, it can be said it is in accordance with law.
According to me.
If bench consists of 1.
Correct.
Either member or chairman, judicial,
Anyone.
Correct. But order pass.
Why he will sign?
That's why. And in terms of 26.2, every person has to be signed. If all the person have signed who are not the member, whether it can be said it is in accordance with law.
That answer is given by the Madras High Court.
That's right. That's
Why?
So why
Because
you are keeping in suspense a movie?
No, I'm showing. But the relevant part where I am reading, I'm showing your lordship. That's my duty.
Sure.
So that is why the question 2 came that single or 2 member bench. Because 6.5b says bench with 1 or 2 members.
2 members.
Now question 1. The entire section 6, I am at column G. The entire section 6 is reproducted. I am not skipping that. Now kindly come to page 17.
Page
17.
Yes.
After the section 6 quotation. 7.1. It is also essential to note that originally section 6.1 of the Act envisaged more than one adjudicating authority to exercise jurisdiction, power and authority conferred under this Act. The said provision has been amended to make the adjudicating authority as a single entity, and the current provision is extracted in paragraph number 7, which establishes now a single adjudicating authority for the entire country. Then section 8 is reproduced. I am skipping this again. Kindly come to
7.1. It is also essential to note 6.1 envisage more than one adjudicating authority.
Well, earlier the provision was there could be an adjudicating authority in Calcutta, in Madras.
Yes,
Now it has been
That is Delhi only. It is not different.
No, that's why it's telling. It's telling. Earlier it was, now it is in Delhi. Sitting in Delhi. Yes. Yes, let's continue. You continue.
No, earlier that was the provision. Provision was amended. and it was made only one adjudicating authority for throughout the country.
Correct. No.
That
yes,
will sit at Delhi only.
correct.
The capital, the privilege, they will sit there only. Now, my lord, thereafter, now, my lord, kindly come to paragraph page 20.
Yes. 7.3.
7.3 after the quotation of section 8.
Yes.
The Honorable Supreme Court of India in Madras Bar Association considered the issue of any statute entrusting adjudicatory functions to tribunal in details. It held that the independence of judiciary and the doctrine of separation of powers are part of the basic structure of the Constitution. The state has powers to constitute tribunals. If a judicial function traditionally performed by courts is entrusted to a tribunal, the same should only be judicial tribunal. That would mean that the tribunal should have members who should have independence and security of tenure associated with judicial tribunals. There can also be technical members when it is essential to have technical expertise. Therefore, only judges and advocates can be considered for appointment as judicial members of the tribunal. The Supreme Court specifically considered the qualification of the judicial members and the technical members in the NCLT and LCLAT and laid down the qualification in the details thereto, holding that the provision in the Companies Act as ultra vires. The Honorable Supreme Court of India in the case of State of Gujarat was a Utility Users Welfare Association, considered the composition of State Electricity Commission and held that even though the State Electricity Commission had regulatory and advisory functions, it also had adjudicatory function to be performed. Once it has adjudicatory functions to be performed, it becomes a quasi-judicial tribunal. Having the trappings of a court, once any authority or tribunal has trappings of the court, then such authority should be manned only by a person who is or has been holding a judicial office, or of a person possessing qualification in law and has the requisite qualification to be appointed as a judge of the High Court or as a district court. Even the presence of the appellate tribunal would not obviate such a need. The Honorable Supreme Court of India in case of Associated Cement Companies case Supra had explained the meaning of judicial powers and functions and the distinction between administrative and judicial functions. The extraction I am skipping. Kindly come to next, 7.6. Apart from the above judgments, useful reference on the point as to the necessity of maintaining the standards as the higher courts and appointment of judicial members who have the qualification to function as judicial officers can be made to the judgment of the Honorable Supreme Court in the case of Madras Bar Association. In this matter, the Honorable Supreme Court of India has dealt with the constitutional validity of the National Tax Tribunal Act 2005. The law on the point is once again recapitulated and elucidated by the Honorable Supreme Court in Roger Matthew versus South Indian Bank Limited, wherein it was considered the constitutional validity of Part 14 of Finance Act 2014 and the tribunal, appellate tribunal and other authorities' qualification, experience and other conditions of service of members rules 2017. This court also considered the issue in the context of qualification of the members of the Intellectual Property Appellate Board constituted under the Trademarks Act in Samnath Basir versus Union of India. Thus, upon consideration of the above decisions, it would be clear that any law providing for the constitution of any authority would be legal if only it is manned by judges, judicial officers, or persons who were or eligible to be appointed as judicial officers. One, if it is a judicial tribunal created under Article 323A or 323B of the Constitution of India. B2, if it transfers any adjudicatory functions hitherto exercised by the courts in India. 3, if it adjudicates the rights of the parties, has the trappings of the court or tribunal. In the instant case, the adjudicating authority is constituted under Section 6 of PMLA. Admittedly, the said authority is not a tribunal constituted under Article 323A or 323B of the Constitution of India. It cannot also be said that any power which was being hitherto exercised by the courts are transferred to the authority. The submission made on behalf of the petitioner is that since a complaint is filed and the authority hears the aggrieved persons whose properties are attached, decides the lease, and as such discharges judicial function. In this context, it is essential to advert to the functions of the adjudicating authority. PMLA deals with the economic offense of money laundering. Therefore, it is not enough that the guilty is punished, but at the same time, focus is also on the recovery of the proceeds of the crime, which is laundered. Therefore, confiscation of such proceeds of crime or properties purchased out of such crimes becomes essential. Until the ultimate confiscation to be made after the finding of the guilt in the trial, Section 5 of PMLA authorizes the director or any other officer not below the rank of the deputy director to pass an order of provisional attachment of any property which shall be valid for a period of 180 days. Immediately after an order of attachment is passed, the said order, along with material gathered in support of the decision, has to be forwarded to the adjudicating authority. Thereafter, within a period of 30 days from the provisional attachment, a complaint stating the facts of the attachment shall also be filed before the adjudicating authority. Upon receipt of the complaint under subsection 5 of section 5, the adjudicating authority, if it has reasons to believe that a person has committed an offence under section 3 or is in possession of proceeds of crime, will serve a notice of not less than 30 days calling upon him to indicate the sources of income, earning of assets, out of which by means of which he has acquired the property attached, and show cause as to why all or any of such properties should not be declared to be the properties involved in money laundering and to be confiscated to the central government. After considering the reply and hearing the aggrieved persons as well as officer who made the provisional attachment, the adjudicating authority has to record a finding whether the properties are involved in money laundering. If the adjudicating authority decides that the property involved in money laundering, then an order confirming the provisional attachment is made. Such attachment shall be till the pendency of the proceeding before the special court, and a final order of confiscation or release, as the case may be, will be passed by the special court. Thus, it can be seen that the primary function of the adjudicating authority is to form an initial opinion as to the existence of the reasons to believe that an offense, that whether the property is involved in the offense of money laundering, and thereafter to make the order of attachment absolute until the disposal of the case by the special court, which is a court of sessions. Similar function is exercised in respect of retention, freezing of any property if the investigating authority vice the director or any other officer under the Act after seizure and search under section 17 of the Act. This is the present case. Forward any record or property, or when they freeze any record or property upon such person, so upon search of persons under section 18, if any record or property is seized, shall be forwarded to the adjudicating authority within a period of 30 days with a prayer for requesting for retention of such records or properties. Upon receipt of the above request, adjudicating authority, again, if it has reasons to believe that the same are related to the commission of offense of money laundering or proceeds of crime, will pass similar orders extending the retention until the trial. So, my lord, the trial is still pending. It's a retention.
Trial started.
Trial has started. We have filed prosecution complaint. Cognizance could not be yet taken.
No, the charge sheet filed.
No. Thus, on a closer scrutiny, it can be seen. But whatever order is passed by adjudicating authority, it will come to the merge with the trial. Thus, on a closer scrutiny, it can be seen that the function of the adjudicating authority is that of the original authority exercising the administrative functions under the Act. That is, formation of an opinion as to reason to believe and making the orders absolute after satisfying as to the correctness of his opinion after hearing the parties. It can be seen that the adjudicating authority itself is in a place as a check and balance, so that the power is not exercised solely by the investigating officer. But if I may say, this is a filter. This is an opportunity to the person that before going to the court, you come before him and satisfy that these are your legally procured properties. To ensure fairness, the adjudicating authority is required to comply with the principles of natural justice, and the director or the other officer making the order of provisional attachment or searching the person is required to make an application putting forth such materials gathered in his investigation. The entire purpose is to form a proper and fair opinion. It is right that even in an administrative action, principles of natural justice are to be followed. The administrative authority conducts a statutory hearing, and in that process, it only deals with the administrative case. The inquiry is limited to confirmation of prima facie opinion or reason to believe. The same does not manifest into a lease. Similarly, it does not also conclusively decide as to whether any property or thing is part of proceeds of crime, part of or proceeds of crime, or out of any involvement in money laundering. It is ultimately the special court which decides the rights of the parties. The officer making the provisional attachment and the party is heard only in compliance of principles of natural justice and ensuring fairness in its own inquiry in confirming of its opinion, and it is not deciding any lease between the officer making the provisional attachment and the person whose property is attached. The adjudicating authority is vested with the power to issue summons and production of documents, etc. under Section 11. My lord, reproduced, I am skipping. So now comes Section 11. 7.16, next page, my lord. It can be seen that in order to aid the adjudicating authority in the process of its formation of its opinion and of making of an ad interim attachment, the powers of discovery and inspection, enforcement of attendance of any person, compelling the production of records, receiving evidence on affidavits.
That is the 11.
My lord,
That is Section 11 provides.
yes, now I need to read. My lord, I'm reading. Ultimately, it is for the purpose of dealing with the administrative case, and that by itself will not in any manner alter the adjudicating authority as the tribunal or the court. As a matter of fact, Section 11.3 clearly states that the proceeding shall be deemed to be a judicial proceeding within the meaning of Section 193 and 228 IPC only. When 193 and 228 IPC, your lordship knows that disobedience of a summon amounts to punishment like that only. Thus, it is concerned with ensuring truth in statements made before the adjudicating authority. We have already extracted paragraph 8 of the judgment of the Honorable Supreme Court in the case of Associated Cement Company Limited. We are of the opinion that the same squarely covers the power and functions of the adjudicating authority under Section 8 of PMLA. Thus, we do not find that the adjudicating authority is a judicial or quasi-judicial tribunal deciding the rights of the parties, or that it has the trappings of a court or tribunal. In the absence of the same, we are of the view that the principles enunciated by the Honorable Supreme Court of India, that the tribunal or authority exercising judicial functions should be manned by judicial officers, cannot be extrapolated to the adjudicating authority under PMLA. Just because more and more judicial color is given to the procedure to be followed, that by itself will not alter the nature of power exercised by the adjudicating authority. As rightly contended by the learned ASGI, such adjudicating authority or competent authorities exercising such similar powers are constituted in many other legislation, such as Customs Act 1962, Section 122, Income Tax Act 1961, Section 6, Benami Transaction Prohibition Act 1988, Section 8, Tamil Nadu Protection of Interest of Depositors in Financial Establishment Act 1997, Section 3, etc. These authorities are there to ensure administrative fairness and prevalence of natural justice in the ad interim decisions which are made pending final decisions by the concerned court or tribunals, and they are manned mostly by the departmental officers and not by the judicial officers. The term adjudicating authority by itself or the detailed procedure laid down for hearing will not alter the nature of action. The provisional attachment originates from the officer concerned, and after the process metamorphosing into an ad interim attachment, even though the aggrieved person is also heard in the process. In the scheme of PMLA, it transforms the issue into a lease only from the stage of appeal to the appellate tribunal. Thus, the adjudicating authority remains the original authority which makes the decision. The right to fair hearing reference is given below. Accordingly, we answered the question number 1 that the constitution of adjudicating authority as such by section 6 is not illegal for want of judicial officer or person qualified to be appointed as judicial officers or who were judicial officers. Question 2. After the amendment to section 6, we did Act 21 of 2009. Now only a single adjudicating authority is envisaged. We have already held that the functions of the adjudicating authority is that of the original authority, making an ad interim order of attachment, and the conduct of hearing is to ensure fairness. In this context, if the parties are heard by a quorum less than all the 3 members of the authority, including single member bench, who can be a non-law member, it will not run offensive or in any manner affect the functioning of the authority. Such a provision cannot be termed as manifestly arbitrary. The second limb of the argument made in this regard is that when section 6.1 creates a single adjudicating authority, 6.2 mandates that it shall consist of chairman and 2 other members, and of the 3 persons, 1 should be from the field of law, the second should be in the field of administration, and the 3rd member should be in the field of finance or accountancy. As such, it is the contention of the learned counsel for the petitioner that in the teeth of section 6.2, 6.5, providing that the jurisdiction shall be exercised by benches and the bench may be constituted by the chairperson with 1 or 2 members as he deemed fit, are self-contradictory and inherently incompatible to each other. The provisions of a statute have to be read harmoniously. A careful reading of section 6 would make it clear that the statute creates 1 adjudicating authority with chairperson and 2 members. All the 3 of them have to be from the 3 different fields of expertise. The provision only envisages that in a given case that the expertise of the persons in these fields, namely law, administration, and finance accountancy, would be relevant in forming an opinion. The chairperson is given the discretion as to whether in a given case the authority would make its decision in a full quorum or in benches, including single member bench, would decide the matter. Such discretion does not make the provision incongruous or self-contradictory. Well, this is the question fallen from your lordship, that what are the notification which we could. So their lordship has held that this discretion given to the chairperson is not self-contradictory or incongruous. Even in the context of judicial tribunal, when similar provisions under the Administrative Tribunals Act 1985, that is section 5.2, prescribing a bench of judicial member and an administrative member, and section 5.6, granting powers of the chairman to authorize single member bench, came for consideration. The Honorable Supreme Court in the case of Mahabal Ram versus Indian Council of Agricultural Research held that the provisions have to be read harmoniously. Later, when the constitutional validity of the said provision was challenged in L. Chandra Kumar versus Union of India, the constitutional validity of section 5.6 was upheld in view of the proviso contained therein, that if at any stage of the case it appears to the single member or the chairman that the case has to be heard by a bench of 2 members, then the same shall be transferred. But an identical provision. The same view was reiterated in All India Institute of Medical Science versus Sanjeev Chaturvedi. A similar proviso exists in section 6.7 of PMLA also. Thus, it is for the chairman and the members of the adjudicating authority to exercise their power as single member bench or 2 member bench or full bench, by keeping in mind the purpose of section 6.2 and depending on the question and intricacies involved in the particular case. The chairman or the members of the bench hearing the matter can refer the matter to the bench of 2 or 3 member benches. Therefore, we do not find any constitutional infirmity on this score alone. When I'm not reading the other part, J.
Thank you.
Sikar, Vijay Madanlal's Parina Sabhu. So, my lord, the result, the writ petitions stand dismissed. Now, my lord, so mostly these 3 judgments cover the issue of quorum non juris.
Yes.
Now, my lord, the judgment cited by and on behalf of the petitioner. But the first judgment cited is of the coordinate bench at page 65 of volume 1.
65 of
volume 1. Writ petition.
Writ petition volume 1.
Volume 1.
65.
65.
Yes.
It measures Atibo economic zone.
Yes.
Right, my lord? Now, my lord, kindly come to page 69. My second paragraph I am reading. The facts remains that the show cause notice was issued on November 2, 2023 against the present writ petitioner. Before that, on June 22, 2023, the chairman of the adjudicating authority under the said act was superannuated. It is a fact not in dispute that on the said date of superannuation of the chairman, the adjudicating authority was functioning with the chairman only and without any other member as enumerated in section 6(2) of the act. Thereafter, upon retirement of the sole existing member of the adjudicating authority of the chairman, the other person, namely P.K. Upadhyay, was appointed on the self-same day, that is 22 June 2023 as member. My lord, what I try to show before your lordship, last sentence of this para, fact remains that at the relevant point of time, statutory adjudicating authority as per section 6(2) of the said act was not functioning. Right, my lord? Last sentence of this page.
However, the ipso facto does not.
Well, fact remains, last sentence, fact remains that at the relevant point of time, statutory adjudicating authority as per section 6(2) of the said act was not functioning. Right? Now, my lord, kindly come to the next page. Last paragraph. In the meantime, operation or further operation of the show cause notice issued by the person appointed as sole member of adjudicating authority shall be stayed. Well, this is an interim order. My lord, I have not yet finished. I have not yet finished. I can't remember that I have ever opened my mouth.
Please.
Well, Lord, kindly take his compilation.
Which one?
3 compilations.
All 3.
Yes. Well,
Compilation you are offering.
the first one. First one having 15 judgments cited. Yes, well, I will go by the index only. I will not trouble your lordship much.
Yes.
My lord, Eastern Institute of Integrated is the first judgment.
Yes.
My lord, this is relevant is para 19, subsection 4. It's a interim order.
Para 19.
Subsection 4 at page 5.
Yes.
It's an interim order.
Yes.
It was an interim order. Since it was done so 5 shall exclude the period of it was interim order, period of attachment. 5(1) shall exclude the period spent during the pendency of the case. In the result, the writ petition is allowed in part. This was the first order, what was by them. And what was the directions? Can you see from 19(1)? In the above facts and circumstances, it is directed that respondent number 1 shall take appropriate steps with the concerned authorities of the central government for appointment of a judicial member of the adjudicating authority urgently within a period of 3 months and not later than that. On appointment of the judicial member, the chairman of the adjudicating authority shall constitute the bench consisting of a judicial member, keeping in view the observations made above, having regard to the nature of the lease and the anxiety expressed by the petitioner university. Soon after the constituted, the bench shall then issue notice upon the petitioner university.
So there was no bench.
There was no bench. It was stayed this period of attachment, my lord, because it has a shelf life. That was excluded. Then, my lord will kindly come to The next judgment cited was Gujarat Enviro Protection, serial number 6. They have cited page 33, para 4, to avoid that by way of an additional
Page
affidavit.
33.
33, my lord, running page 33.
Yes.
They have showed paragraph 4
Yes.
to avoid that by way of an additional affidavit, ED has said that now my adjudicating authority is complete.
Where?
Well, they said that. Now, paragraph 4 records that ED filed an additional affidavit.
Yes.
Now, kindly see what ED has stated. Para 2. The respondents have already filed an affidavit in reply in the above referred matter, wherein the appointment of judicial member Sri G.C. Misra in the adjudicating authority PMLA was pointed out. However, with a view to bring the subsequent development on record, the deponent files present affidavit. Next paragraph says that 2 other members have been appointed on the specific date. It nowhere says by ED an acceptance that until it was appointed, adjudicating authority was not complete. It is not that correct. Now kindly come to the next judgment they have cited with respect to Vijay Madan Lal Chaudhary, which starts from there, page number 36. Relevant pages have been given, but rightly given, because otherwise it would have been much more bulky. But I will show only. Kindly come to page 39, para 246.
Yes.
Well, towards the bottom, the expression. The expression proceedings, therefore, need not be given a narrow meaning only to limit to a proceeding before the court or before the adjudicating authority as is contended, but must be understood consensually. Does that record of statement, my lord, deemed to be judicial proceeding? Then next page, my lord, needless to underscore that the authorities referred to in section 48 of the Act are distinct from the adjudicating authority referred to in section 6 of the 2002 Act. The adjudicating authority referred to in section 6 is entrusted with the task of adjudicating the matters in issue for confirmation of the provisional attachment order issued under section 5 of the 2002 Act, passed by the authority referred to in section 48 of the Act. The confirmation of provisional attachment order is done by the adjudicating authority under section 8 of 2002 Act, and if confirmed, the property in question is ordered to be confiscated and then it would vest. So, my lord, the same principle which Honorable Madras High Court followed has been referred by the Honorable Supreme Court in Vijay Madan Lal Chaudhary. That function is just that much. Again, my lord may come to page 42, para 316 of the same judgment.
Page
342. Para 316 of the same judgment.
Page which page?
42. Running page 42.
Yes. 316.
316. My lord, towards the middle, not only. Towards the middle, not only.
Okay.
Not only that, in terms of section 17(4) of 2002 Act, the authority seizing the record or property is obliged to submit an application before the adjudicating authority within a period of 30 days therefrom for the retention of the said record, and adjudicating authority to in turn gives opportunity to be heard by issuing show cause notice to the person concerned before passing order of retention of record or property as the case may be under the 2002 Act and the rules framed therefore. The authorities carrying out such procedure is also made accountable by providing for punishment under section 62 of the 2002 Act for vexatious search and giving false information. All these inbuilt safeguards prevent arbitrary exercise of misuse of power by the authorities appointed under the 2002 Act. My lord, with deepest respect, Vijay Madan Lal Chaudhary, nowhere the Honorable Supreme Court, the larger bench, has decided whether adjudicating authority can be a single bench, or it has to be a division bench, or it has to be a 3-member bench. It has nowhere decided in Vijay Madan Lal Chaudhary, with deepest respect. But the next judgment cited in the case of Darsh Mineral, page 59. No, it is with respect to the attachment. But the last one is again it is starting from page 167, Rajesh Kumar Agarwal by Honorable High Court, Delhi. Well, this is
Yes.
well, the same thing at page 185, your lordship will find. Page 185, para 82.
82.
Right. So what are the functions? And my lord, ultimately in this case, it was found these are the functions of the adjudicating authority. Well, the other judgments relied on in the petition, I am not referring one by one again, are on the issue that when the matter is pending before the Honorable Supreme Court, or when it is there was no chairperson or three-member bench, there shall be stay. As rightly stated by my learned friend, yes, there are numerous orders he relied upon where stay has been granted in the proceeding. I have cited before your lordship three division bench judgments of Calcutta High Court, Madras High Court, and Telangana High Court, which are final in nature. I have cited one single bench judgment of the coordinate bench, which is final in nature. The interim order cited by my learned friend of the coordinate bench on this issue, my lord, I will be citing two judgments only of this honorable court only, my lord. This is in the case of Piyush Kanti Chaudhary by the Honorable Justice Bhaskar Bhattacharya. My lord will kindly come to directly para 7. Therefore, the only question that arises for determination in this application is simply because in an application for grant of special leave, the Supreme Court has stayed the operation of an order passed by the division bench of this court, declaring a statutory provision as ultra vires the Constitution of India as an interim measure, imposing further condition in those cases whether a citizen who is not a party to the previous litigation can be deprived of the benefit of the doctrine of precedent in resisting the action of the state on the ground that it could not invoke the ultra vires provision of the statute against him. Before entertaining such question, we propose to take notice of the actual order of stay passed by the Honorable by the Apex Court. It appears from the order dated 20 March 1998 that the order of the division bench of the High Court was stayed, subject to the order of status quo regarding possession on spot should be maintained by both the parties. It further appears from the subsequent order dated 16 December 1999 that another bench in a different matter, being special leave to appeal civil number such and such, passed an interim order directing that status quo regarding possession of the spot should be maintained by both sides in connection with the members of the petitioner Sangha who were before the High Court in the writ petition, out of which the said proceeding arose. By further order dated such and such. Well, I'm not reading the whole matter. Kindly come to the para 10. After hearing the learned counsel for the parties and after going through the aforesaid provision, we find that the Supreme Court by those interim orders has no doubt stayed the operation of the order of the division bench of this court by directing the parties to maintain status quo and at the same time even restrain the state from inducting third parties on the lands which were the subject matter before the Apex Court. Such interim order is binding upon the parties to the proceeding, but the law is equally well settled that by mere passing of an interim order staying the operation of a judgment with certain further conditions, the existence of the said judgment is not wiped out. And at the same time, for such interim orders, inter partes, the authority of a decision as a precedent is never undermined. Unless a decision is set aside by the superior court, the said decision remains binding as a precedent, though may not be binding upon the parties to the proceeding where the Supreme Court has granted interim order. No matter what I say,
Yes.
With respect to the division bench of the Calcutta High Court, my lord, admittedly there is no stay even.
Yes.
So it is a binding on us. Madras High Court division bench is a binding on us. Telangana High Court division bench is a binding on us. But the same principle is reiterated by a coordinate bench.
Yes.
My lord, kindly come to page 2. There was another judgment order, my lord. I have not brought that because it is referred here. More or less, my lord, I am reading from the top. More or less similar issue fell for consideration before this court in WPS such and such, in the case of such and such, wherein this court held that in the absence of specific exclusion of section 5, it would be improper to read and implicate exclusion thereof. The operative part of the said decision is extracted. But that was the order. The effect of the order of stay in a pending appeal before the Honorable Apex Court fell for consideration before coordinate bench in the case of Piyush Kanti Chaudhary, which I read before your lordship. In paragraph 13 of the said report, the coordinate bench held that the effect of the order of stay in a pending appeal before the Apex Court does not amount to any declaration of law, but it only binding upon the parties to the said proceedings, and at the same time, such interim order does not destroy the binding effect of the judgment of the High Court as a precedent, because while granting the interim order, the Apex Court had no occasion to lay down any proposition of law inconsistent with the one declared by the High Court, which is impugned. In view of the decision in the case of Piyush Kanti Chaudhary Supra, this court is not inclined to accept submission of an advocate appearing for the state that the decision of the Honorable Division Bench in S.K. Chakraborty cannot be said to be binding precedent upon the court. The Honorable Division, then comes this. So the principle is same.
Yes.
Unless, even if there is stay, and in my case, my lord, there is no stay even.
Okay.
My lord, my learned friend gives emphasis by saying that in respect to the Sikkim High Court case, the ED is before the Honorable Supreme Court and could not obtain any stay. But the same thing goes in respect to RP Infosys also.
Okay.
The RP Infosys, there is no stay. Now, my lord, I have
Only 5 minutes.
my lord,
Yes, yes, yes.
now, my lord,
Any further remains?
my lord, the order sheets provided of the Honorable Supreme Court. My lord, the order sheet with respect to RP Infosystem shows SLP diary number 37116. The latter order sheet, which talks about 5 cases together, it does not reflect that. Still, I'm not disbelieving the words of my learned friend from the bar. If he says it is tagged together, I take it as to be tagged together. But that is pending. So yes. But the rule, so far as rule is concerned, section 26(2), where my learned senior ASG appearing for the Union of India has already made that submission. That rule cannot override this section. The section itself is very clear. The judgments as on date are clear on the issue, on the propositions provided. Now, the last thing I would like to submit before your lordship, that from the date chart I have shown to your lordship from page 413 and 414, and if your lordship wants, I can give that.
Yes, yes, yes.
The lordship will find that the only intention is to drag the proceeding. So my humble submission before your lordship, it's a long drawn process. All our interim reply, examination, cross-examination, rejoinder are in force. Your lordship, for the sake of interest of justice, will allow it to be continued. And we will use our affidavit in opposition on the issues, if raised before your lordship, on the question of legality, illegality, on such seizure, freezing of properties, including bank account. Because I have only addressed your lordship on the issue of quorum non judice, whether it is maintainable or not, whether the proceeding can go on at the interim stage.
Yes. Only as a wire medium, Lord, which some high courts have also found out The court has said let the proceeding continue, but the tribunal will not pass a final order because that is whole issue. This is one way. Punjab has going consistently on this matter, saying that let the proceeding continue before the. But I don't think so. They should have a problem. We can continue the proceeding. Final orders cannot be passed, my lord. That will be subject to the outcome of the Supreme Court.
And I have objected any interim order. I have objected to any interim order.
That is one. My lord, that is one. My lord, two things, my lord. The judgment of this court, my lord, which I have cited there at Evo, my lord, of 2024 is the last judgment, which even takes care of pay perform, which my learned friend has read. My lord, the judgment of Karvi, my lord, so that Ativo relies on pay, they at that point of time relied on pay perform. Page 65 of the compilation, my lord, takes into account pay perform as well as the division bench of the court. My lord, Eastern, which is pending in the Supreme Court, which is a batch, my lord, that is not an interim order. At that point of time of Eastern also, there was a show cause notice issued by a single member where directions were given. Well, those directions are in challenge whether they should now appoint or not to appoint. That has been in that. Well, there is today a notification where they have issued a notification appointing a judicial officer. Today, my lord, they cannot now hide it and say that let it be. We will not even wait for my own notification, which is pending. And Rule 26, my lord, is not been referred or taken into consideration. That order sheet has to be signed by all, my lord, which is there. And that is challenged in Parina Swarup, my lord. So their argument that the rule cannot supersede the act, it was challenged by the ED in Parina Swarup. The rule today stands, my lord. And once the rule is there, my lord, and they cannot read, my lord. Section 6, my lord, is word is with chairman. It is not alone, my lord. They are reading it differently. That is why. And these are judicial proceedings, my lord. No harm will be caused to them, my lord. That if the proceedings, my lord, are stayed or, my lord, the final orders are not passed.
Yes.
My lord, may one more thing, my lord. Just my learned friend said that Vijay Madan Lal Chaudhary, my lord, does not take into account 3 members. My lord, I have referred a paragraph of Vijay Madan Lal at page 41, para number 312.
Page
41 of my petition. Sorry, my compilation, sorry. First compilation.
First compilation.
Yes, my lord.
Page
41.
Yes.
My lord, para 312.
Correct.
Categorically records that the adjudicating authority, the material which is sent, my lord, may see in between further.
Yes.
Such recording reason along with the material is required to be forwarded to 3-member adjudicating authority.
Yes.
Headed by a person.
And I said that it does not decide that whether a single bench can be there or not.
One. My lord, may just see Eastern, my lord, page 1 of the judgment. There is a show cause notice. My learned friend says an interim order. There is no that time at that point of time there was no bench. My lord, may see Eastern, which is pending in Supreme Court. First paragraph seeks to set aside show cause notice. Correct. It was not in, my lord, ere somebody came in. And my lord, this is a final judgment. The writ is allowed, my lord. One. Then, my lord, may just see Uday. My learned friend said that we never gave a concession that quorum is complete because all 3 members are there. So that is the exact concession given. My lord, may just see page number 201 of the compilation. And Lord, I also rely on 4 judgments which are today. They have not taken this court order to either the division bench or to the Supreme Court. That order is today also standing. My lord, may have page number 201.
Yes.
Sorry, page 200. Sorry, para 6. Their statement, my lord. How they say adjudicating authority is complete. Today, when the petition came up for hearing, learned advocate for the respondent number 1 submit to point out from an additional affidavit in reply filed by Assistant Director of Enforcement Revenue of Finance that the adjudicating authority was thereafter duly composed and constituted. The member are already appointed and section 6 composition is complied. This is their categorical statement. The section 6 today stand complied because all members are there. And because of this, my lord, it was disposed of. My lord, my learned friend also referred to, my lord, the judgment of Karvi, my lord, of Telangana High Court. My lord, that is also pending in Supreme Court. My lord, that page number, my lord, I'll just, in my compilation, my lord, can note it. My lord, all this issue.
Karvi
is admitting. It is pending. It's not admitting.
Karvi is pending. I am admitting.
It's admitting.
Pay perform is not pending.
No, my lord.
Madras High Court is not there in Supreme Court.
No, it is there, my lord. Pay perform, my lord, pay perform is relied by the, my lord, by this court, my lord. paper, my lord, some people don't challenge it, my lord, they don't want to go on.
But it is not pending.
But there is the issue which is pending.
It may be pending. Paper
And, my lord,
is not
not this Delhi High Court, my lord. Just one thing, my lord. Every High Court is saying, let the proceeding can continue. We can await, my lord, the hearing in the Supreme Court on 30th, and the tribunal is hearing it
This is
tomorrow.
coming in reply.
Every High Court is saying, let it be subject to the Supreme Court. Supreme Court is hearing. Otherwise, my lord, what will happen, my lord, may see? If the Supreme Court decides the issue, as my lord is saying, my lord, if it is decided in my favor, everything has to turn back. And my lord, what is the prejudice? They have the property. Proceeding, I am not wanting
Whether
to
the
stall.
Madras High Court is in before the Supreme
No.
Court?
No, my lord. That is what I am saying.
Madras is
My lord, this is a case. My lord, why they are dragging? I tell your lordship, I have not
Only
opened my mouth
only
on
I ask
merits.
whether that is not.
Why they want to
My lord,
drag
paper
it?
form also relies on RP, relies on J. Sekhar. All of them, my lord. J. Sekhar is stayed by the Supreme Court. But actually, as I said, my lord, everything evolved from J. Sekhar.
Okay.
J. Sekhar is the one, my lord, which is stayed in Supreme Court. ED took a stay themselves on the judgment itself. So, my lord, my humble request is, my lord, at the worst case, if my lord may feel that there is an attempt to stall the proceeding, which is their argument, the final order can be awaited. Let the proceeding continue. No problem, Lord. We do not intend to do it.
Then my lord will keep
But-
this matter after 30th of
No
January.
problem.
My lord will keep this matter after before your lordship after 30th of January, when we will see the outcome from the Supreme Court
No
also.
problem, my lord.
If your lordship so desires. But my only prayer that let the proceeding continue.
Yes.
There is a proceeding of consortium of banks, 6,200 crores of money has been siphoned. Well,
Let the final order may not be passed. Let the proceeding.
kindly don't allow them to drag it more. Since September they are sleeping.
So what will remains in the writ petition if they will continue and the final order may
No,
not
no,
pass?
no. My lord, what I am saying, my lord, today we are on 20th. My lord, as my learned friend has referred to the order of the Supreme Court, that matter is fixed next on 30 of January.
Hmm.
So my lord,
Today we are on 28.
Yes.
today we are on
Tomorrow
20th.
is a hearing in the A. And
So my lord, allow us some time.
that's what.
So my lord, allow us some time to file our affidavit in opposition on the merits, because they are on merits on the Caesar. As my learned senior advocate friend was also saying. So Caesar, whether it is correct or not, we'll use our affidavit if we are not to entertain this writ petition. Otherwise, this is a subject matter before the authority. They can always say it before the adjudicating authority that Caesar or freezing of my CC account is wrong in law. Adjudic, why they are afraid? Why they are apprehended?
Authority for release.
Very well.
Wait for any order.
Very well. Then the apprehension is that adjudicating authority is not going to hear their word. This is why they have not filed their reply in time. They have filed it lately on
Okay.
24th.
Milord,
So that is my submission.
Lordship,
Kindly not allow this stalling process any further.
Lordship has heard, Milord, 16 and 17. I am 14, 15 and 18.
For 14, 15, I am for the bank.
I need, Milord,
You want to
15
say
minutes
anything
of
more
your,
than me?
20 minutes of
Just
your
wait.
Lordship's time. Now or 2 o'clock?
2 o'clock other matters are there.
Continue.
Continue.
Please continue.
Milord, I'll try to be even shorter. Milord, kindly take the PMLA Act once, Milord. Hey, Milord, kindly, where is Bishop?
Only to clarify, trial has not started. No, the cognizance is not.
And I have said that cognizance stage is pending.
Whatever, my lord may reserve an order, my lord may state it tomorrow. Otherwise, my lord, this will become instructions. That's the only problem.
That's why I want to hear Mr.
But before Mr. Chaudhary starts,
Case is going on, sir.
No,
Case is
before
going on, sir.
14, 18, 14, 15, 18, before they start, your lordship
No, no,
has
14, 15, 18.
another jurisdiction today. Your lordship has another determination, in fact, the jurisdiction of courtroom number 5, my lord. But there are certain very two important matters which are coming up, which was scheduled at 3 o'clock. My lord, they were
Scheduled at
3 o'clock today, before that court. My lord, these are the two order sheets, my lord, if your lordship can kindly, because the interim orders are there till today.
only interim order. I will
My lord,
take
the
care of.
interim orders need to be extended.
No,
my
I
lord,
will
if your
take care
lordship-
of. No problem. I will take care of.
Well, my lord, just then calls for the file.
Keep it come at 2:30 or 3 o'clock.
I'll come at 3 o'clock, very well.
Come at
But
3
I've notified the state.
Yes.
Great.
Come at 3 o'clock. I will. If the extension of the interim order of the other code of determination, I will take.
But can we just pass on the information to the officer so the records are called? Very good. Whichever way, whichever way you, yes, that's what I wanted to show.
We have filed a report, it's a cyber case offense.
My interim order is still. My interim order is still today.
Okay, come at 3, come at 3, come at 3. Yes, yes, Mr. Chaudhary. Yes, Mr. Chaudhary. How much time will take?
Milord, 15 minutes maximum. I'll make it 10, Milord. Very quick. Milord, please have a look at. In fact, I should not need 10 minutes on a basic issue, Milord.
Take lunch.
I'll-
No, no.
Let me just indicate the point. Section 17, my lord, sees where director or any officer not below the rank of deputy director.
Section 17.
17. I'll make it very quick, Lord.
Yeah.
I
In
feel
which
embarrassed.
matter you are appearing? Entry number?
14, 15, 18. One point, Milord, I'll just argue.
Yes.
Milord, 17.1 is where director or such and such, on the basis of information is possessed reason to believe. Believe that the reason for such belief is recorded in writing that any person. Now, my lord, please see 2. I is any person has committed an act which constitutes money laundering. 2 is in possession of any proceeds of crime involved in money laundering. So he is in possession of proceeds of crime. And now, my lord, see 4 is in possession of any property related to crime. So possession of proceeds of crime and possession of property related to crime.
Correct.
So, my lord, then what can the ED do? My lord, please omit A, B, my lord, please see C. Seize any record or property found as a result of such search. So ED has the power to seize.
Correct.
Now, my lord, just one page. What have they, my lord? Frozen. Marco, what have they frozen? My lord, please look at page 325.
Which read?
Ishan Met Plus, which is
item number?
15. Lord, this would be, your lordship has the papers of the other matter.
Other matter I am having.
I don't actually have.
No, if you yellow matter. Item number 15. 15.
15, my lord.
Item number 15.
Page 325, which is volume 3. I'll just show one document and then I'll make the argument. 2 documents, in fact. Out of 9, 5. Total 9, 4. 5 are current accounts. Now, let me make the point while the file reaches. What is frozen are bank accounts. And out of these 9 bank accounts which are frozen, 4, my lord, are cash credit accounts. I am, my lord, submitting this. Cash credit account is not my property. Number 1. It's, my lord, what is there, the limit in the cash credit is not funds. It's limit in the bank account, which the bank has allowed me the privilege of drawing upon for the purpose of expenditure. Now, what the balance in the cash credit is, my lord, not my property. It can also not be, my lord, property, my lord, which comes under section 17. If your lordship looks at section 17 again, my lord, once. My lord, for jurisdiction to be exercised, there has to be reason to believe that any person is in possession of proceeds of crime.
Correct.
This is State Bank of India's money. It's a nationalized bank's money. It can't be proceeds of crime. Bank will give me the money when I draw my cash credit. It's now, my lord, bank's money.
No, the bank will give the cash credit subject to you maintain certain amount in the account of the bank.
No.
Why? Without maintaining the account, how the bank can give a cash credit amount to you?
This cash credit, my lord.
Yes, cash credit. Suppose you are having the cash credit of 4 lakhs.
4 lakhs.
Correct. So bank will fix a minimum of 3 lakhs or 6 lakhs.
6
you have
lakhs,
to maintain
4 lakhs, whatever.
You have to maintain that amount in your credit. And if it is
No, my lord.
Just a minute. You have to maintain, and if you not maintain that amount for the certain period, it will be interest will be charged, and within a 1 month or 45 days, you have to revert the amount to the bank. If it is not reverted, then the proceedings will be started. As far as my knowledge, I don't know.
No, Milord, that is
Subject to the banks.
Milord, that is not exactly the cash credit. Milord, please have a, this is a decided issue. May I just hand up, Milord? And then I'll show your lordship. Aro do. I down now. No. Milord, please have a look at.
Mr. Chaudhary, why you are not raising all the issue before the
Milord, it's a jurisdictional issue.
jurisdiction?
It's a jurisdictional
different
issue.
thing. That I will decide.
Milord, I just want that. Milord, when if your lordship decides this one question, effect is, I'm not asking for Milord.
Automatically, if this court find jurisdictional issue, find in your favor, automatically all will be straight.
No, I am not on that, Milord. I adopt my learned friend.
Correct, that's why I'm telling.
But Milord, I am not really on that. We, Milord, are not directly, Milord, connected. There was some business transaction and we are also relatives. There have been business transactions for 40 years with Milord, the principal accused, Mr. Sureka. 40 years and we are also relatives. Now, what has happened is, Milord, ED has frozen all bank accounts of these companies. Net effect is these companies will go defunct in 2 days. Milord, business has completely stopped. We have obligations of repayment to people, to customers, to the banks. Business is over. Now, my, Milord, submission is that a cash credit account cannot be frozen because it is not, Milord, property of, Milord, the petitioner. Milord, please have a look at the judgment.
Yes.
I am not on the other, Milord, 5, Milord, accounts. The current accounts you can keep frozen. But if the cash credit is, Milord, defrozen, I can do my business. I can draw money.
Yes.
Milord, please see, Milord. Paragraph. Milord, I feel totally guilty at 145 to cite judgments. If your lord, any time your lordship chooses, I'll come back.
Today, that's it. Today, because
Even at 4:30, I can come back. 5, I can come back. I feel totally
when
guilty.
the order, because tomorrow is your last date. That is the one of the problem. Tomorrow is the last date.
We can take a date tomorrow.
It's an important question. These companies are going defunct because of actions of ED which are on the face of it without jurisdiction. Milord, please have a look at paragraph 3, just one sentence on that page.
It took only
Oh, Rijit
5
Chukka.
months time to realize.
No, you can't.
That reply
See,
could not be given in
I
September.
totally
Could not be come before the court in
I
September.
respect ED. I respect them.
So,
They're doing good for the country. But
5 months.
I
And today
respect
they
them,
come and
but
say-
you cannot do something which is beyond your powers and is ruining a man's business. It's in violation of Article 19 and 21. Milord, please see this. Petitioner was aggrieved by an order of provisional attachment of cash credit account maintained by the appellant with its banker. Legal question involved in the writ petition was whether an order of provisional attachment can be made to a cash credit account. In fact, the learned single bench has noted all the decisions which were cited by the learned advocate for the appellant and has held that the cash credit facility is not a debt and therefore it cannot be made attachable and that the writ court is bound by the precedent. Operative portion of the order, Milord, reads thus. Then, Milord, paragraph 4.
Yes.
And paragraph 6, Milord, in the light of the above conclusion, the respondents are directed to lift the order of provisional attachment of cash credit account within 10 days. And why so, Milord? Reasons, Milord, your lordship would find in the judgment of the single bench. Milord, I must, Milord, lordship would forgive me, but my understanding of cash credit is this. When a cash credit account, Milord, a cash credit limit is sanctioned in my favor, Vishnu Chaudhary, cash credit, 4 lakhs.
Correct.
Now, from today, I don't have to pay interest. In the course of my business, out of this 4 lakhs, I may take 50,000 tomorrow. So then I pay interest on this 50,000. 3.5 lakhs is with the bank. It's not my money. It's the bank's money. Bank hasn't given me money. Money doesn't come into the bank account. Money is the bank's. It's the fund of the bank.
The account holder is nothing to do regarding the fund of the bank.
It's bank's money.
Yes.
Only bank, when the bank sanctions cash credit to me, bank gives me a license, my lord, to take out 4 lakhs. When I take out 4 lakhs, I pay interest on 4 lakhs. Till I take out 4 lakhs, it's, my lord, with the bank, a bank's property. So, my lord, if it's the bank's property, that's why, my lord, in execution, you can never attach a cash credit. Order 21 doesn't permit attachment of cash credit. Income tax rules don't permit attachment of cash credit.
The bank has not made any application for
The bank is not. I'll tell you, Lordship, why. What is happening is, bank has the money. Bank has not allocated 4 lakhs into this account. So bank is not prejudiced. It is a notional only when, my lord, there is an order by the PMLA authorities for the bank to pay into this account. It is only then that the bank will, my lord, create trouble. Till then, the bank is happy. But fact of the matter is, what is happening is, I'm not being able to do business. Now, if, my lord, let's look at a situation where, my lord, I decide, my lord, to make 100 kgs of steel, 100 MTs of steel. I need raw material. I need to buy, my lord, iron. When I go to buy iron, how will I pay for the iron? I'll pay by, my lord, issuing a check on my cash credit. Till now, money was with the bank. When I issue that advice, money will go to, my lord, my supplier. I'll get the, my lord, raw material. I'll, my lord, sell and pay. I'll, my lord, sell. My lord, proceeds will again go into that same account.
Okay.
So, my lord, now, my lord, please see another judgment. The Gujarat High Court. Para 2, 3 and 6. Same thing.
2, 3.
2, 2, 3, 6. We have, Lord, please read para 2. We started with today's board on a very sad note. The subject matter of challenge in the present writ application is to the order of provisional attachment of a cash credit account running in the name of the writ applicant maintained with Axis Bank at Vapi. Law, 3 lines down. Law as regards provisional attachment of a cash credit account is no longer res integra. Way back in 2016, in the case of Canaria Granito versus Assistant Commissioner, coordinate bench took the view cash credit account cannot be provisionally attached. Cash credit account in the case on hand could be said to have been opened. Please read para 3. Said to have been opened to enable the writ applicant to borrow the money from the bank for the purpose of its business. Any money, therefore, that the bank may make available to the SSC would necessarily be in the nature of a loan or a cash credit facility. In either case, it would be in the nature of borrowing by the writ applicant from the bank. In such circumstances, the bank and the writ applicant therefore do not have the debtor-creditor relationship.
Yes.
And it was condemned. Last 3 lines, condemning the action on the part of the department in provisionally attaching cash credit. Please see, para 6. Law is well settled. Cash credit account of SSC cannot be provisionally attached. Excise of powers under GST. Same concept. I've got 3 other judgments on this point.
Okay.
Where
is the provisional attachment?
Yes. Page 325. Bokashna. It is the only one. No. 325, 326. Lordship will see all account numbers. Not all of them are cash credit. 325 is, my lord, cash credit.
Yes, 325.
My lord, we've made a chart. My lord, please see the chart, my lord. My lord, 325, 326, 327. My lord, not all of them are cash credit. My submission is only on cash credit. My lord, and the cash credit numbers in the writ petitions, I have put in a chart I have, my lord, given the writ petition number, I've given the date of the freezing order, I've given
There
the
is no
account
page number.
Yes, my lord.
There is a page number.
And I'll just write the page number in hand in my lord's, in this and hand up to your lordship. Now, my lord, no, please. Now, only just one last sentence, my lord. Why it is without, totally without jurisdiction. Back to section 17. ED can exercise power
Yes.
under, my lord, sub 17(1)(2).
Yes.
If it is in possession of proceeds or crime.
Correct.
Or 4, is in possession of property related to crime. My lord, the money in my cash credit.
Bank will
So,
be
my lord,
bank will also be the accused in the special.
yes, and all nationalized banks have proceeds of crime as per ED. This is how illogical it is.
This is at the cost of the health of.
My lord, we have not yet disclosed our logic. He is showing cash credit account. My lord, I have a right to answer.
And you have.
Just let
You are the ED. So only in that case, can you exercise right to seize record or property. So here, because the preconditions can never be met in a cash trade, totally without jurisdiction. I am only asking for, my lord, the cash credits to be deleted, and I adopt my learned friend's submissions in the other matter. I wanted to argue, but then I think he's argued everything. So I shouldn't, my lord, make same arguments twice. And he argued very well.
Thank you.
Grateful.
Yes. Cash credit. Yes, cash credit.
No, my lord, so far as the section 17 action is concerned, kindly take section 17(1)(a). দাদা এখন তো মামলা নেই দুটোর আগে
দেখ কটা বাজে
বসো না
I have a 2 p.m.
wait
fix.
wait
Milord,
and please have some hour for us also, some minutes for moments please. May I kindly take section 17(1)(a), where it is not practicable to seize such records of property, the officer authorized under subsection 1 may make an order to freeze such property. Here it is an order of freezing.
এটা তো তোকে ফুলফিল করতে হবে ফ্রিজ করতে গেলে
উঠতেই তো কেন তুমি সবসময় উঠতেই তো
Yes.
Now the question is
17A.
17(1)(a).
1A.
1A. But I'm just giving bullet points of my argument. Number 1. Number 2, whether it is right or wrong. What I have frozen, whether it is his property or bank's property, whether there is any money belonging to him or to the bank, the subject matter of adjudication under the show cause notice issued in September. So I reserve my right to make any comment on this in my affidavit in opposition.
Okay, excellent. আমি চলি
Number 2, he must show, he has to show that he will not go to the adjudicating authority on this point. The reason for that. Section 24 and 23, 23 and 24 of the PMLA talks about presumption and burden of proof with respect to documents and property. It's a reverse burden. It's not a case that I have to prove. It is for him to show. That is why in 8(1), your lordship has found that he will call to disclose his source on everything. My lord, the entire reason to believe given out the original application will show why particularly these 4 or 4 cash credit account has been frozen. Why? Because we have to trace the money trail.
Correct. As per your submission,
Money
the
trail.
so-called is filed, the authority issue a so-called notice, they get the chance to file a reply, you will file the reply, the authority will adjudicate whether the amount is of the party or the bank, then he will pass appropriate order.
Correct. Number 1. Number 2, this is followed by appeal before tribunal. That is followed by appeal before this honorable court in a division bench.
Correct.
So my lord, this is also the position of law that when appellate jurisdiction lies before the division bench, that issue should not be entertained in Article 226.
Thank you.
We can take a date tomorrow.
Proceeding is tomorrow, so that my lord can pass it. That can be.
Well, I have made my submissions.
ED will not give any concession.
But we are giving him time.
You will file, you will find the order today itself.
We have given them time.
My lord,
September, we have made mention. That is January 29.
My lord, under constraining circumstances, my lord, I'm seeking your lordship's indulgence, my lord, to seek leave to file this matter, my lord.
Just a minute.
My lord.
ইডি থেকে বেরোতে দে এখন জজ সাহেবকে
কাগজ বসাচ্ছে
तो फाइल में टैग कर देना. Lord, may I am keeping this.
Yes, yes.
May I just make one submission, Lord? Item 18 in your lordship's list, Lord, the list mentions file not there. Lord, we have a writ petition and the supplementary affidavit with us, Lord, if your lordship.
Give. So this is up to
18.
no item number 13 to
18.
13 to 18.
14 to 18, my lord.
14 to 18.
Yes. No,
14, 15, 16, 17, 18.
Yes. File action. You तो list दे दिए.
My lord, under constraining circumstances, I am mentioning this matter for leave of your lordship. The only thing is that the MSME authorities, they have passed an award behind my back. No copies were served. The execution proceedings are carrying on when I have raised an objection that an order of attachment as well as for filing of affidavit has been given. If I do not submit that, my lord.
When is the date for filing affidavits?
On Monday, my lord.
So what can be done?
Let your lordship.
Yeah, this is no.
Tomorrow, your lordship, can you take up the matter, my lord?
Extension of interim order. What is it? What is it?
Well, for 12.
Ah,
But that is not have been taken.
today it will not be taken.
Only on order will expire on 3rd February. If my order is matter for any other date.
Push for the other side.
Well, I got the reply yesterday
Yes,
evening.
because of the interval, 4 days vacation.
So let this matter taken or not on 4th period, 4th period. At any time.
The specifics matter.
Yes, especially if it's back at 12. The order of 7 January records it. There will be specific for this, for this day at 12.
अरे सबको फाइल के साथ भेजा नहीं
Is there disappearing is actually.
फाइल में भेज दो ऑफिस but I could not but you will find the odd then March only. What is the urgency?
Okay,
I will extend the and I fix the March.
Very well, my lord. Very well.
Item number 8.
Yes, item 8.
So the matter is fixed today as item number 8 at specially fixed matter at 12 noon. But due to paucity of time, the matter could not be taken up for hearing. Police counsel for the petitioner submitted. Interim order is still till 3rd of February 2026 and paid for extension of interim order. In view of the circumstances mentioned above, let the matter give the date. Let the matter appear on give the date. Diary আছে কি? देखो February last में या कोई देखो 12 बजे कोई फिक्स है खाली है या 3 बजे देखो तो 2 बजे मार्च में होगा लास्ट या February लास्ट में तो ये बुक भी दे तो मेरे चैम्बर में मार्च आप मार्च लास्ट मार्च देखिए
The other matter, I think one is for
8
I think
9
this has been fixed for 8 days.
No, March, that will be March.
9th March at 12 noon. Interim order is extended till 9th March to 9th March 2026 or until further order, whichever is there. Yes.
By the laws order of 3rd December,
Ah.
order directing the respondents to allow me to continue my stall.
Hmm.
They have not been doing so. So it
That they have filed a complaint.
Order has been extended and I am not able to operate sumptuously.
What can be done? Where is your contempt?
Time passed.
What you are filing?
Opposition.
Affidavit of opposition and affidavit in reply filed by the parties be kept with the record.
No, the parties, if they are not, because order has not been complied with. That's
Oh.
the reason why.
Where is the contempt? Contempt is also there.
There is the list. Contempt is also there in the list.
Record. The counsel for the petition submitted the petition also filed an application, content application,
Direction of the address is the order
content
of
application, as the respondents are not complying with the interim order passed by this court. Let the what is the contempt number?
CPA double C of
Let the contempt application being CPA number
double
2033 of 2026
25
be placed on 4th February 2026 under the heading application.
Vacating interim order is also filed.
Yes.
Oh.
The vacating order is same as.
Next. Call.
Supplementary list.
Supplementary call.
Yes. Not a very short matter, Malad. This matter involves Malad permission. They had sought for permission to sit in for a demonstration. Malad, these persons are Malad.
Where is your application?
The application is there at page number 16, the first application. 16, 17 and 18. 18 was the one that was sent by email, the screenshot of the email.
Which one number? ADSL 1.
Yes, where is the rejection order?
Rejection was there at page number 21, without no reasons being assigned whatsoever in a cryptic and cyclostyle manner.
Yes, who is appearing for the state?
And I'm appearing for the state.
Yes.
Milord, there are a few points, Milord, I would like to point out. Milord,
Yes.
first is, Milord, the applications which has been made before the government is by a association. I do not know, Milord, whether the association is registered or not, but by an association, and the petitioner is a person concerned who says that I am the secretary. Milord, we do not know whether he at all is the secretary or whatever the situation is. Milord, the second is, Milord, the prayer is for a continuous demonstration from 28th January to 11th of February, Milord. And the area which has been asked for is in front of Vidyasagar statue, Milord, which is in the College Street. Milord, before addressing to that issue, Milord, I will request Milords to kindly take up page 19, which is a continuation of their application.
That was an alternative prayer.
Yes.
Yes, yes. But I'm just placing what they have prayed. They say, with reference to our organization's previous letter, vide such and such, we would like to inform you that our organization is ready in every way for a day-night sit-in demonstration program from 28th January 2026 to 11th and such and such. But we, as a part of the administration, are ready to cooperate with the administration in every way. Next paragraph is, in this regard, you are informed that if you arrange an opportunity to meet the Honorable Chief Minister of West Bengal or the Honorable Chief Secretary Government of West Bengal, or before on or before 30th January 2026, directly, as well as submitting a deputation in her hand on the solution to our long-standing deprivations, demands, and provide a written commitment to our organization about this matter, then we are also willing to withdraw our sit-in protest program. So, Milord, in actual reality is they want to continue for an indefinite sit-in program, Milord. So until and unless this happens, this is from their letter. Now, Milord, the difficulty what we are facing is, first of all, Milord, the same organization, the same people, they, with our permission, already held a protest movement, Milord, at Ramlila Maidan from 19th January to 21st January.
19th January?
To 21st January. The same people, they came, approached us, we permitted them. They held that program, Milord.
Even prior to that, we held a demonstration.
No, I am just talking about the recent one, which is 19th January, 21st January. Second is, Milord, the particular area concerned is a 163 covered zone, and this 163 covered zone is from 2018 onwards. Milord, what is the problem is, the juncture cover, it is just the stone throw away from Presidency University and the University of Calcutta, and other books fairs and other places are there, Milord. Bookshops are there, academic places are there. So at that point of time, Milord, I have been verbally told, Milord, I don't have that document, but the students had approached the Kolkata police, and thereafter this 163 was instituted to ensure 163 was instituted to ensure, Milord, that there is no political organization
Which
there.
order 163?
Milord, the recent one, Milord knows that 163 has to be renewed regularly. The recent one is of the 21st of December, Milord. If Milord gives us the opportunity, we will show all previous orders as well. Previous orders? Previous gulo dekhate pabo?
Yes, then
we will show all previous orders, Milord. There is no difficulty for that. Milord, another problem is, Milord, on 2nd of February, the Madhyamik Parikha is starting. Milord, for the Madhyamik Pariksha, Milord, there are directions by the Pollution Control Board as well as from the boards. The police also passes necessary directions that no loudspeaker can be used 3 days prior to the Madhyamik Pariksha. Milord, 2nd February is Madhyamik Parikha, 12th February is higher secondary examination, 17th February is ICSC, 17th February is CBSE as well.
And my lord, there are documents, my lord, which says with same thing, my lord, which I was just submitting. So my lord, it is not possible to allow that particular place, and that too for an indefinite period, for a long time, to use microphones with 100 people protest there. Ramlila Maidan, my lord, they had approached us, we had permitted them.
No.
I can show the permission copy.
We have not sought for Ramlila Maidan.
No, previously, which was 19th from 21st. We allowed them, they did it. There was no difficulty, we cooperated. They also cooperated. I am not saying they did any mischief. They also cooperated. We extended all support. They did the protest in Ramlila Maidan.
Yes.
So our bona fide. We had sought for a permission at Hajra mode. They said that we are not going to give Hajra mode. We gave.
I don't have that document. I don't know what he is submitting.
Yes. So
that is not there in the pleading, my lord. So sorry, I am not. Something beyond the pleading, my lord, we are not in a position to reply.
Here also, they had sought permission before Nomanto, that is Munditala bus stand. That is also 163 covered place. So it was this High Court which had intervened and gave us permission. We continued our protest for 3 days and we continued the same. There was no complaint.
These are not there in the pleadings. I am not on instruction to reply all this. I am sorry, my lord, as if this would have been attached, my lord, I would have replied. This is the Pollution Control Board order so that there is a restriction for 3 days, my lord. And my lord, this is the order which we had given them, which we have given them, my lord, so that they are allowed to hold the protest movement from protest meeting, my lord, 19th January to 21st January. They accepted it and did it in Ramlila Maidan.
What order you have given? 2022.
Lord, I'm sorry.
2022 order.
Lord, this is there. This order is not revoked. Every year this order is not issued, my lord. This order is there in force, and which is my lord will see the first page, which is 19th January. There is a circulation. This order is there, my lord. It is just circulated on 19th January 2026 to all the concerned parties, my lord. The Kolkata Police Commissioner falls at the second serial, the first page, my lord.
Yes.
And my lord, there is another document I have handed over to the Lordship.
What is this?
That is the permission we had granted them to hold on 19 January to 21st January at Ramlila Maidan, and they have held it peacefully. They have held it, my lord. I am not.
Yes.
There is no allegation, my lord. They have held it, my lord.
Ramlila Maidan was an alternative that was provided to them. They had accepted it. Now, previously they had sought a place near Nobanno, that is the state secretary. That is also 163 covered place. With the intervention in the court, we continued our protest. There was no complaint whatsoever on behalf of the state or any other authority. Subsequently,
so you take instruction where you will allow to permit, you will permit to continue the demonstration. Okay.
That is an area,
College state I will not allow. That is a examination and the 163 is applicable.
Lord, Ramlila Maidan will
you pay pressurize on the college state. I am dismissing your writ application. If you are ready to, if you are ready to, you make a further application to any other alternative. They will take a decision.
Your lordship direct, because since the program is announced on 20, all the participants.
You announced, but what the authority has not allowed you, and you wanted to hold the demonstration in the 163 area. How it can that the college street, all the good colleges are there, examination is going to be started. Who will be responsible? And Lord Speaker, you want to use the Lord Speaker?
But may I then say this, put it in a metro channel, that is saying.
Or you come to in the month of second week of April after the examination is over?
This organization, they are deprived since now.
What the organizer? You file a writ application. Why you demonstration? You will get the all benefit by the demonstration.
Well, these are their democratic rights,
Democratic right means what? Every 10 days you will hold the agenda before the office and on the road, and hold the traffic, and public will be harassed.
There was no complaint whatsoever in any of this demonstration.
Maybe, but what purpose would, once you have hold the demonstration from 19 to 21, they have not heard what purpose would be so further 15 days?
Well, kindly sees,
have you filed any writ application taking your right?
Kindly sees one thing. Kindly comes to page number 19 for once. Our intention is
every third day there is was a demonstration.
Our intention is, definitely sad status, sorry status.
What satisfaction? So come to the court. Why you're not coming to the court with the writ application? You are the advocate. Why you're not advising your association come to the court? If you are having a legal right, you will get the legal right from the court. By sitting on the road and street and harassing the general public, holding the this all the traffic.
Kindly see page number 19 for a moment.
Yes, I have seen.
Organization doesn't have the intention to hold demonstration. If their grievances are being redressed, they want to meet the chief minister or the chief secretary and hand over.
What is your grievance?
But the grievance kindly takes up. Page number 3, para 3, A, B, C, these are all the points. This person, persons associated with civil defense and disaster management. They have nothing. They have no medical benefit, no insurance, nothing.
So how the authority go and file a writ petition? Holding the demonstration you will get. If you are entitled, you go. Yes, I have seen. You are asking for all the benefits. Then if the benefits have not been given to you, you go to the court. 226 available to you.
226, your lordship, other than that, this persons also have a democratic right to protest.
Okay, you tell me what is your suggestion, because I will not.
My suggestion, if it could be escalated, a metro channel.
So you apply up for the.
Difficulty is that 28 the program, all our participants are here in Kolkata.
What can be done?
If this, let them take instructions. We are agreeable if we have been granted metro channel in this planet.
Yes.
There's no schools and nothing nearby.
Milord, our suggestion, Milord, which I'm speaking on instruction, Milord, is that they have already done it in Ramlila Maidan. It is a tested place.
They may have been done it, but you cannot restrain. You cannot do.
No, we are suggesting Ramlila Maidan.
That's why I'm asking you. He is giving
this
the
is the instruction, Ramlila Maidan.
Ramlila Maidan, where is the Ramlila Maidan? You already.
Backside.
No, Ramlila, Milord, it is not that they are doing it for the first time. Many people have done it. Why they accepted it in the first occasion? They should have come to the court then. They have accepted it. They have did it from 19th to 21st.
We had also previously with the intervention of the honorable court, we had done it in front of Navanno. That is
That is not there in this writ petition. It can also be before the Prime Minister's house, but not
for any alternative. After the rejection, you not prayed for any alternative also.
Because we wanted to hold it in that place because there is no problem in holding those there. But we will not.
Where you know the college street, what is the position of the college street?
The loudspeakers on.
Maybe.
But the metro channel, that is what I'm humbly disappointed.
Milord, it is equally traffic oriented area. It will create a problem.
And second thing, I'll come to your prayer portion.
Yes.
No, your application. You want to hold this under secretary organized, kindly we grant the permission to demonstration. Loudspeaker will be conducted, demonstration program, and stage will be erected. If the stage will be erected, then you have to take permission from the municipality and the fire service.
Yes.
If a permanent stage, because 15 days it is a permanent stage.
Yes. Licenses are.
Earlier, a coordinate bench of this honorable court.
I am not going to any bench. If you are asking for the 15 days, you are asking for the loudspeaker, and you are asking for the what about the erection of the stage? The erection of the stage, you have to take the permission from the authority. The court cannot shut eye.
But we will then not erect a stage. We will then not erect a stage.
Milord, let them come with a proper application before the authorities, Milord.
By a letter dated 22nd of January 2026, comma.
May I just say one thing?
Yes.
Let us come with the alternative. We are saying metro channel. Since there is a difficulty, the participants.
That's why I am passing on order, giving a liberty to give the alternate.
Absolutely, palpable. The same will be getting rejected. Lordship,
Milord, I am sorry, Milord. I have
pass a direction to the defect. It will be solved here and now.
Milord, I have to contradict, Milord, my learned friend's submission, Milord.
Can create multiple litigation. If we can come back, with this thing, alternative.
Come tomorrow.
But may just have a talk with them and come back after our matter is over.
My lord, it is better, my lord, it is kept tomorrow. We have to also seek permission from the authorities.
Password, go, we'll see to that. Yes, next. All the list.
नहीं नहीं एगुलो নিয়ে নিন।
That's why.
So we these matters, my lord, I am appearing for this state respondent, my lord.
State has finally arrived.
So lordship, I fault, my lord, I am in copy of this.
Third time beyond time, but anyway.
So I hand over the copy of the affidavit, my lord.
Yes.
There's an IST and an SST, state standard time.
So kindly allow.
Waived.
We already filed my.
Waived.
So kindly explain.
IST, SST waived or not? If it is waived, then I will dispose of.
No, he's given the reply within a week, Miller. That was my lord's direction.
Learned counsel appearing for the estate has filed affidavit in opposition after serving the copy to learned counsel for the petitioner. Counsel for the petitioner prays for time to file reply. Let affidavit in reply be filed within 2 weeks.
2 weeks, my lord. 2 weeks.
In 2 weeks. Then I don't know specific. Then it will go March. Let the matter of March में देखो एक डेट दे दो स्पेशली फिक्स तीन 2 बजे का देखो कोई है
It may be April.
12 बजे है कितना कौन सी तारीख है 10th March at 12 noon.
Grateful, my lord.
Fixed matter.
Grateful, my lord.
Obliged, lordship. 10th March 12.
Excess की time बोले?
Yes, next.
State standard time.
State standard time. Well, this is my lord. I am challenging an order. I'm challenging an order by which
Before my senior friend Lord starts, Lord
6, na? 6 and 7. Okay.
I'm in item number 6.
Starts, Lord. Only one thing, Lord. We have also filed 2 writ petitions on the more or less same cause of action, assailing, my lord, the election and its entire process.
Election
This
of?
matter has nothing to do with election, my lord.
Pharmacy council.
No, lordship, one.
This matter has nothing to do with election, my lord. This is regarding
number 7.
members' nomination.
I challenge the lordship.
Yes, every time the matter comes up,
Lordship,
somebody
I challenge the election matter.
let them try their luck separately,
The
my
writ
lord.
petition item number 7, lordship. There is an interim order, lordship. And the coordinated bench, lordship, already provide the interim order and mention that on last order that any step taken in the furtherance to the election shall abide by the result of the writ petition, lordship. So election matter is challenged, and the item number 6 is also connected, lordship. That because, lordship, the petitioner of the item number 7 in my writ petition, I pray for remove.
Let all the matters be taken up separately. Otherwise,
item number 6.
Item number 6 you are appearing.
Yes.
You are appearing?
No, my lord.
I
Cannot
have 2
appear.
other writ petitions. If the lordship Lord considers, Lord, then I can be, my petitions can be tagged together.
Lord,
That's my only.
who are the parties? I'm
What is your
I am representing the pharmacy council.
what
We
you
have
prayed for in the writ petition?
Lord, in the writ petition for that. In the writ petition, Lord, I have challenged, Lord, in one of the writ petition, my challenge is that my objection has not been considered, and without that, Lord, no further progress can be made in furtherance of that election. That is one. The other one is challenging, Lord, the irregularities in the election process.
Lord,
These
we-
are the 2 writ petitions.
Sir, we do not know anything about the writ petitions. Well, we are the councils. Well, let
Lord, we have filed, we have served.
well, let them take
I
their chance
understand,
on a
Lord,
regular
he
basis,
might
my
not
lord.
have instruction. I understand he might not have instruction
This
today.
is a separate matter
Lord,
going on.
yes, I'm saying, Lord, I have filed 2 writ petitions separately on these 2 prayers. If my lord feels, my lord will.
Now, have you challenged the notification of 28 July?
No.
28/7, I am challenged.
My
Yes,
challenge
challenge.
is with respect to the election process, one, and irregularities, and the other is I have
challenge করেছি।
objections which ought to have been considered prior to the final declaration of the result.
That has not been done. These are my lord, my two challenges. If your lordship feels my lord, my writ petition can be tagged, or my lord, I can
Once
come back separately.
again your writ petition will come, then affidavit,
Yes, my lord.
then it will again,
As
it
your
will be
lordship.
tried.
Then
It will be taken.
What modus operandi, what he is telling?
My lord, may I tell you one? So far, item number 6 is concerned. There, my lord, the only grievance is that.
Item number 6 they have not placed.
Nominated member. He said that since the earlier nomination was done or about, my lord, the information.
Item number 6, my lord, I am appealing.
So
Lordship,
and my lord,
may I
he
place my
said in
matter?
the petition that my term would be ended in on 26th of February 2026.
Correct.
He has not challenged my lord the selection process. He said that the formation of council after the election and said that my nomination, earlier nomination in the earlier council, it should be 5 years as per the rules. Now, in the midst of this, the selection was there or election already held. So my nomination, that is one day I would enjoy 5 years. In the meantime, it has been ended. So according to the item number 6, the petitioner there, he said that only thing that my term would be ended on 26th February 2020 or 22nd February 2020. He has not challenged my anything.
Lord, today, my lord, I am not bothering your lordship. Lord, third, I am told, my lord, is the returnable date. Lord, in that case, my lord, may this be, my lord, taken up, Lord, on third. Lord, may I supply the numbers, my lord?
It is there not.
Returnable date. Returnable date is 3rd of February. Different matter. These two separate
Lordship,
matters.
Monday morning you mentioned we'll see to that.
Yes.
My lord,
I am the applicant
next
of the
up,
can.
this is my lord, I have been, my lord, I am challenging the, my lord,
Well, before that, may I file my opposition? My lord?
You are appearing for whom?
everything filed, everything. He is seeking addition of party, my lord. May I just place my matter first, my lord?
Just a minute. You are for the writ petition.
I am for the writ petition.
I am for the West
Lordship,
Bengal.
I am the applicant of can 3 lordship.
His
I am
can
the
has not
applicant
been
of the
served.
can 3
There are
lordship.
there are two addition of party application. There are two addition of party
And
application.
at the same time, I have the petitioner of item number 7 lordship also.
Item number 7, I am not concerned.
Well,
Item
number
number 7,
kindly
the
takes
petitioner
up.
also the petition respondent also.
Kindly takes up.
So main
Section-
respondent is appearing. You are for the.
My lord, I am for the West Bengal Pharmacy Council, my lord, respondent number 3.
Okay. And Mr. Sen?
State. My lord, kindly takes up the Act, Pharmacy Act.
Yes.
It's annexed from page 17 onwards.
Yes.
Act may be called Pharmacy Act. There are several sections. Under this Pharmacy Act, my lord, council has been formed. Kindly comes to section 3, page 18, Constitution and composition of the Central Council. H is 1 member to represent each state, and thereafter, lordship is there.
Section 3.
Section 3.
Yes. 6 members.
6 members. 1
is a teacher.
Yes. Now kindly comes to State Council.
Yes. Where is the State Council?
Section 19. Page 26.
Yes.
Except where the joint state council is constituted in accordance with an agreement made under section 20. Here there is no agreement, there is no joint state council, there is only state council. State government shall constitute a state council consisting of the following members, namely A. 6 members elected from amongst themselves by the registered pharmacist of the state. 5 members of whom at least 4 shall be persons possessing the prescribed degree or diploma in pharmacy or pharmaceutical chemistry or registered pharmacist nominated by the state government. 1 member elected from amongst themselves by the members of the medical council or such and such, the chief executive officer, such and such. So therefore, 5 members of whom at least 4 shall be persons. I am amongst these 5 members. So these are the nominated members. B. 5 members of whom at least 4
Shall be a persons possessing prescribed degree or
there
diploma.
in such a pharmacy or pharmaceutical, or 5 registered pharmacists nominated by the state government. I am amongst this. Now kindly comes to
Or either this 5
yes,
or this
or 5 registered pharmacists nominated by the state government.
Correct.
I am amongst those 5. Now kindly comes to the terms of office, page 29. Section 25.
Yes.
23 is president and vice president, not concerned. If required, I'll place. Term of office and casual vacancy.
Yes.
Subject to the provisions of this section, a nominated or elected member, I am a nominated member, other than nominated president, shall hold office for a term of 5 years from the date of his nomination or election, or until his successor has been duly nominated or elected, whichever is longer. It's very important, whichever is longer. Thereafter, a nominated and elected member may at time resign. 3 is nominated or elected member shall be deemed to have vacated his seat if he is absent without any excuse. These are not the cases here. The relevant part is 25(1), 5 years, and whichever is longer. Now, my lord, I was nominated for the last time at page 41 onwards. Kindly comes to page 43. This is the last nomination. This was
What is your name? Devashish.
Devashish.
Okay.
Lordship is there at page 43? Yes. On expiry of the term of West Bengal, such and such, I am not troubling. I was nominated in 2021. So simply it will go till February 2026.
5 years.
Yes. Or longer, whenever it is being done. Now, my lord, I am continuing to be a nominated member from 2012.
No, the
12
last
plus
extension was 2021.
12. Last is 21. We are
February
concerned about last. Yes. Now, my lord, in the meantime, president was not there. There were communications by which the president was supposed to be nominated and all these things. Not concerned. Kindly now comes to the impugned action. Page 53. I am challenging this. This may be set aside. This is dated 28th July 2025.
Yes.
On expiry of the term of West Bengal, such and such, governor is pleased to reconstitute. So therefore, the secretary or whoever is the concerned is proceeding on an erroneous basis that the term has expired. So first line goes,
On expiry of the
vitiating the entire process,
on expiry of the term.
which has not expired,
Correct.
which will be expiring in 2026 February, to constitute a such and such in pursuant with section 19B, C, DD and such by nominating the following officials. Here, my lord, my name is not there. So therefore, in any case, this notification is erroneous in view of the fact that it proceeds on the basis that the term has expired, ex facie. That is my case before lordship. Therefore, I have challenged this and I am enjoying an interim order. My contention is that simpliciter, this is liable to be set aside. Now, what happened is simultaneously is
So you are continuing.
yes, because of the interim order, the council is functioning. All the their contention is the council is not functioning, but I'll show from documents. Council has said that it is functioning, and I am continuing. Now, my lord, what happened? Page 54 is another notification by which the 6 elected members were also nominated on the same day. I am not concerned about this. So therefore, my contention is that
No, this 54 is the notification.
yes, of elected members. 6.
Acha, elected. Okay.
A, 19A.
Okay, okay.
I am 19B.
Okay, okay.
Now, my lord, kindly sees they were elected, and kindly sees, my lord, there was an attempt to reconstitute. Now, my lord, kindly takes up Can 2, which learned friend has filed. There he has annexed the rules in respect of elected members. I am not concerned, but still, since it has been annexed and it has been strenuously argued, so that is why I am showing this.
Can 2.
Can 2. Why I am saying so? Because Can 2 has been preferred by someone who contends that the council is not functioning, but the council doesn't say so. First is the affidavit of council, kindly sees. Affidavit in opposition of the council.
Council is 1 and 2.
Council is, yes, 3. This is affidavit in the back sheet of
the writ application.
No, my lord,
Affidavit.
to the writ application. Yes, that's that one.
Yes, which paragraph you are referring?
Page 4, paragraph H.
H.
Page 4, paragraph H.
Yes.
That although at present the council is functioning with the existing member of the council, but since the general election has already been completed, therefore it is need of the hour to give effect to the results of the election and to allow the freshly elected members to function. So council admits that it is functioning, but council says that the elected members should also be taken into account, which in respect of which I am not concerned. Now, in this background, kindly takes up Can 2. I have a reply. Can 2 contention is that the council is not functioning. It is being said that the
Can
2 is, yes, Can 2.
Can 2 है वहाँ पे देखिए.
Can 2 अच्छा.
Can 2.
Can 2 আছে? May I hand over my?
Here only the Can 1 is there. No
Can
2.
2 আছে. Copy the copy. May I hand over the copy? এটা স্যার Can 2টা খুঁজতে এটা আমি জাস্ট দেখি.
Yes.
Now, my lord, the contention is that main paragraphs would be at page paragraph 18. Since it has been, my lord, submitted, so therefore I am compelled to show this to your lordship. Page 11.
Yes.
He contends that your applicant states that for the non-functioning of the council or important day-to-day work of the council has been in complete standstill. Conditions like work for duplicate renewal, duplicate registration, these are the works according to him which are not being done, although the council says council is functioning. Duplicate renewal, duplicate registration, online renewal system, damage.
So now what is your contention?
Now contention is that kindly comes to page 57. I will show that these, with regard to these, the registrar is the authority who will do all these things, and the registrar is doing. Council has nothing to do. Page 56. 57. He has annexed. He has annexed the rules for election of the members, including the president, vice president, such and such. In that, kindly comes to page 62. I will just show what they are trying to do. Though it doesn't concern, but still, since it is on record and they are so much vociferous, it's my duty to show.
Yes.
Page 62.
Yes.
Election such and such, as soon as may be possible after completion of the election, upon election, এটা কি লেখা আছে?
Completion of the
election, এটা কি? Under sections A and C, under clauses A and C of
section 19.
Section 19, and after appointments under clauses such and such of the days have been made and notified in the Calcutta Gazette. So there has to be a Gazette notification. Now, my lord, ever reply to that. Kindly takes up the reply filed today. Yes. Now the reply to the council. But this is
The can.
no to the writ petition.
Reply filed by you.
Yes. Today.
Reply আছে দেবা? Didn't reply. No, petitioner. Reply of the petitioner.
Reply of the petitioner to the affidavit in opposition of the council.
Applicant.
এক্ষুনি ফাইল করেছি। This পাতলা এটা দেবেন না আমাকে। Now, after this 28th, second one, an attempt was made for reconstitution. Kindly, that notice is page 7.
Where?
This is to inform you that
Your reply.
in my reply.
Yes.
Kindly takes note of the date. 4th August. A meeting is being sought to be held for reconstitution. May I? For the elected members.
Yes.
For election of president and such. Now, next page is the notice which the council says that on that particular day, the work of the council will not be held. However, please note that the office of the such and such council will function as usual on and from 7th August 2020, which they are doing. This is again to show that the council is functioning. Now, kindly comes to page 9. Very important. This is with the reference to our earlier 6th August. 4th August was the notice. Now 6th August. This is with reference to our earlier communication regarding the meeting scheduled to be held on 6th August at 2 p.m. at the office of the council such and such under rule. I am skipping over as published by such and such for election of the president and vice president. It is discovered that in spite of due communication and reminder about the Gazette publication dated 4/2/2025 and such forwarded by the such and such nomination, the necessary notification in the Calcutta Gazette has not been published by the concerned department. So therefore, till 6th August 2025, there was no Gazette. Now kindly turns. This is the Gazette. Kindly see the date. Kindly see the date.
Yes.
July. So Gazette in the back date. Well, I have never seen, so therefore I wanted to show it to your lordship. In August, they say there are several reminders, the Gazettes have not been published, so therefore the meeting was postponed. But now they come up with the Gazette, which is there in the official, which has been supplied. Gazette is 28 July 2025.
Yes.
Though it doesn't concern me, but parcels.
Elected members.
Yes, elected member. But still, I wanted to show this to your lordship.
Okay.
My contention before ebar Tripurata dekha. Now, my lord, yes. Similar, my lord, situation arose in Tripura in respect of the member. In respect of the member nominated under section 7, the same act, 7 is the nomination of the state government to central council, where the tenure is also 5 years. Here also what happened, prior to the expiry of 5 years, it was terminated. May I just read the first paragraph and thereafter, Mr. Such and such, learned counsel appearing for such and such, learned counsel, by means of filing the writ petition, the petitioner has prayed for following relief: issue of rule upon such and such, directing like. They were challenged. Now, Miller kindly comes to, yes, paragraph 6 onwards. This is under the same act. Paragraph 3. Briefly stated, the petitioner is a nominated member appointed under section 3H of the Pharmacy Act, IM 19A. He has been nominated as a state member of the Primary Council of India, for short PCI, by notification dated such and such, issued by the respondent number 2 during the secure tenure, during his secure tenure, by impugned order dated 29/7/2022, issued by the respondent number 2, Professor such and such has been officially nominated as a member of the Primary Council of such and such under section 3H of the Act, replacing the petitioner. Challenging the impugned order dated such and such, the petitioner submitted representation before the authority, but tilted representation. Now kindly comes to the finding of the court and what the court has done. Paragraph 8. On conjoint reading of subsections 1, 2, 3, 4 of section 7 of the Act, it manifests that the term of the nominated member shall not be less than 5 years. And it may be extended beyond 5 years till new member is nominated or elected. Casual vacancy will arise if the nominated member resigns and his seat becomes vacant. Casual vacancy shall also arise if nominated member is found absent on 3 consecutive meetings of the council without any excuse. The word sufficient in opinion of the council means that cannot that if such member gives any excuses or assigns and reasons for such absence, this central council shall decide the merit of such excuse, and if the council finds no merit, rejects the same, then the seat of such member shall be deemed to be vacant. These are not the cases here. Again, the seat of nominated member shall be deemed to be vacant if he is elected in another section. In view of the above discussions, it cannot be said that the state government has an absolute authority to cancel nomination once one member is nominated as a state member to PCI due to contingencies integrated in section such and such. It is thus held that the power of cancellation of nominated member to PCI is to be exercised keeping in mind the limitations of the contingencies encrypted under section such and such. In furtherance thereof, if there is any allegations against the nominated member, here there is no allegation, prompting the state to cancel, withdraw his nomination, in that case, such nominated member shall have a right to get an opportunity to being heard, which is totally absent in the instant case. Same here, accordingly, impugned order cancelling the nomination of the petitioner as nominated member under such and such, issued by such and such, stand cancel. Consequently, the appointment of respondent number 6 as nominated member to present is also quashed. So therefore, I am praying that.
So, if okay, you as per your contention,
Page
your tenure is till February 2026.
So page 53
Correct.
is illegal.
Correct.
Quashed.
Now the page 53.
Yes.
Page 53. So who are the other nominated member?
Page 53.
Because they are the earlier nominated member.
No. Different nominated member.
What about the along with you, who are the nominated members?
My lord, along with me. The other
What about
nominated.
them?
Yes, there are
They are
common
not
nominations
challenged.
also.
They have challenged. They are not challenged.
They have not challenged.
They are not
They have
challenged.
not challenged.
So they are agreed with. Only you are.
I am agreed.
Agreed because you are telling that before the time period is over, they have conducted the election and you have been nominated.
No. In this case, there is no election. In my case, there is no election.
Nominates.
It proceeds on the basis on expiry of the term,
Correct.
which is erroneous.
Expiry.
Simpliciter. Page 53.
Correct. Page 53 is to be read with page 43.
Page 43.
43.
Yes.
43 is your nomination.
Yes.
2001. So 5 years or longer periods. So what will happen if suppose 53 is quashed?
Yes.
So what will happen? Because
State may again
because the other nominated members are not here.
But if page 53 is quashed, My lord, then
Then what will
state
be
government can again make a nomination after 1 month. If the state government is of the view that I am not the nominated
So,
member.
Today,
My lord, I am the nominee.
Lordship,
I am the
today the
Lordship,
council is functioning.
Yes, functioning.
Who is appearing there? Who is attending this nominated
We
member?
are, we are attending.
no one.
We
No
are
one.
attending. They may say no one. He's also say he may also. Council doesn't say so. We are attending. The quorum is there. Everything is being done.
There is not a single document produced stating that all the normal functions.
Why should I produce a document? I can show the act itself.
I am the nominated member number 3. My name is in serial number 3 of this 28/7/2025.
Agnik.
Yes, Agnik.
Agnik Chaudhary.
Yes, my lord.
Who is for the council? May I? What is the situation of the council now?
But I'll just not point out.
But now it will be taken next day, tomorrow.
Yes, but what has happened is the last effective election of this council was held in 2013. After that, Lord, no election was held. And there were internal issues. Ultimately, the matter came to court, and under direction of the division bench, Lord, the election was held. The results were published. The elected members, Lord, were declared. Now, Lord, the problem is the tenure of a nominated member is coterminous with the tenure of the council. Because, Lord, once the fresh election is held,
the council goes.
The council goes. So, Lord, the nominee can't survive. He also perishes with the tenure of the council. So, Lord, this is my stand. And Lord, I am fortified by 1 or 2 judgments which I'll show. This is the short point.
Yeah, counsel for the petition concluded his argument. Learned counsel for the council has argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter appear tomorrow under the same heading.
Okay.
Now, as urgent motion.
The interim order is till today.
Within 5 matters. Interim order is extended.
Interim order is till today, my lord.
Is extended till the next date of hearing. Urgent motion within 5 matters.
Lordship has been pleased to extend the interim order.
Till tomorrow it will, then we'll see what will happen. If I will dictate here and then otherwise we'll see. Can I check? Oh, court number 5. Number 5.
Yes, my lord. Only one matter. So, my lord, there are 2 cans which are there. We are in principle pressing for can 3. But we were saying that the interim order which was there passed by.
Can 2, you are moving can 2.
Can 3.
Can 3, you are having a copy?
Yes, my lord. We have. My interim order is there till today. Oh, sorry.
My lord, I have instructions to appear on behalf of the state. I have some submissions to make after my learned friend finishes.
What you have prayed for extension of time?
Yes,
interim
we
order.
prayed because today, my lord, it was fixed for hearing at 3 o'clock and the interim order was there till today. So, my lord, we were beseeching since the court is not sitting, my lord, there's every chance and every apprehension that possibly some.
What is the interim order?
My lord, no coercive action against the petitioners.
Kindly seize the
My
order,
lord,
my
the
lord.
order which is there in page 8.
Order dated?
My lord, order dated
31st 31st December.
31st December. Yes, my lord, we did court till on 31st December. It's just not Thailand that I asked for. My lord, page 8 at page 9. Paragraph number 5 and paragraph number 6. Paragraph number 5 is of utmost importance. Second. 5 is, however, considering that there are issues of fundamental rights, sufficient opportunity should be granted to the writ petitioners to pursue their case and necessary opportunity should be granted to withdraw the earlier interlocutory application. Thus, should be heard out. In the meantime, the learned advocate for the state shall obtain instructions as to the number of cases in which the writ petitioners are wanted. The matter is listed before the regular bench 1 week after vacation. If certain cases are instituted till date, no course of action to be taken till 8th February, 8th January. Then, my lord, comes the next date, my lord, which is on page 10. Now, my lord, with greatest respect, your lordship would come back to page 8 one more time. At page 8, your lordship would see that the state was ably represented on day 1. So the state is completely heard out when this interim order has been passed. Now, my lord, your lordship's pleasure would be to see page 10. In page 10, your lordship would also see this order dated 8/1. This is before the regular court. Now, the matter is fixed on 14 January 2026, marked at 3 p.m. And the interim order, my lord, is extended till 28 January or until further orders. Right, my lord, on 14 January, my lord, order to that. I'll give you 1 minute.
14 not taken, it is taken on 16.
Right. Yes, my lord. Oh, your lordship has it. Right. 16th, when the matter is taken up. Now, my lord, on 16th, my lord, the state furnishes an information. Information regarding 2 matters pending against the petitioner's hearing. My lord, we say that we seek to give an objection to the information that was given. My lord, the reason why we gave the objection is envisaged in Can 2. It's a detailed objection that we've given to the report that was submitted. Now, my lord, along with Can 2, that's the reason why we filed a separate Can, my lord, for that. Can 2, my lord, is an objection, an indication as to how, my lord, the report that was submitted by the police, my lord, was absolutely bad in law.
Why?
Why, my lord? Your lordship would have a look at the report, which is there in Can 2.
Yes. No, it is there. Original is there. 14
January.
14
January. But the report is bad in law because, my lord, I'll tell your lordship, the parties in the writ are envisaged as the Directors General of Police, the Commissioner of Police, the Commissioner of Cyber, the Deputy Commissioner of Cyber, the Newtown IO, the Bidhannagar IO, and Barakpur IO. There are various IOs which were indicated as parties. But the report that was given, my lord, to start with, there are many other points which are envisaged, was given by one of the investigating officers of a particular designated police station. This report did not envisage somebody from the top to indicate as to what are the matters which are pending. Somebody who has, my lord, has the courage of proceedings throughout West Bengal. So one particular police station coming up and saying that we have registered only 2, but does not subserve the purpose for which the writ was filed. But other points have also been taken in Can 2.
Okay. Yes, what is the objection?
Just one last thing, can I say?
Extension of time.
Yes. We were saying that, my lord, just that submission, then, my lord, I'll leave the A to him. The thing that I was indicating, my lord, that let the interim order be extended for a period of 3 weeks or 4 weeks. My lord, with the liberty to mention to them, to us also. We, my lord, because these matters are fixed matters, my lord. And the court has to decide as to when it can take up because these are heavy matters.
The court has
It's already-
fixed it today. Because of her lordship's difficulty, she could not be here. That's why.
So what I propose to do?
Let it be there till
I am
Friday.
extending for 10 days.
Yes, my lord.
Then in the meantime,
My lord, let it be till Monday. Because by that time, definitely, my lord, Justice Ghosh will be there. Let them mention it.
No, why should we?
Why should they not? My lord, if I may now
Yes.
submit.
Okay, today we are on 28.
Yes,
20.
Correct. 28, I am extending till 5th of February. In the meantime, the parties are liberty to mention the matter and
Most of them, most of them.
The concept for the
3 weeks
listed in the supplementary list.
A client down like this is not expected.
Counsel for the petition
Don't you know
submitted
anything?
order is still today and date for extension of interim. Counsel for the state has raised objection and submits it. The interim order cannot be extended and the state has already furnished the details of the cases pending against the petitioner by a communication dated by a report dated 14th of January 2026. Consider the submission made by the council for the parties. Full stop. As full stop. The interim order is extended till 5th of February.
May I just suggest something? Subject to what your lordship or subject to what they will say, my lord. Gives us 10 days because the monthly list will start, my lord.
Well, it hardly matters.
Say,
They
my lord,
can mention
have
tomorrow.
not- my lord, it is not.
Well,
my lord,
this is only,
there's no
my lord,
vacation by-
then I have objections. Kindly permits me to,
Objections, my lord.
no, kindly permits me to submit them.
Give me
Come,
10 days time.
Judge will be there on Monday or tomorrow, I don't know, then
Yes, let them mention.
interim order is
This is
extended till
Thursday.
5th of February 2026 or until further order, whichever is earlier. The parties are at liberty to mention before the appropriate court. I will get them.
I'm deep. Deep.
ठीक है जी? No, no.
Can
Can
it also
three is
be
disposed
recorded,
of.
my lord, that can 2 has been served upon them?
Can 3 is disposed of.
Can 3 is
Can
disposed
3
of.
is
Can 3 is
disposed of.
disposed of and can 2 has been served upon them.
The petitioner already served the copy of the can application to
Where's
the
the affidavit?
Which they do not
Affidavit of
object.
service. There's no affidavit. Deep.
छोड़ दो, कुछ लिखो मत तो ओरिजिनल ओके नहीं जाता तो आया नहीं है, छोड़ दो, ओरिजिनल साइड कॉल करो. He has not come, what we can. If it not come, then not
Original side.
Yes. Yes, what is the instruction?
But I have given them, my lord, certain alternatives, my lord.
They suggested Y channel, my lord. I have spoken with my officers. I had handed over, my lord, a document of 21st January.
Earlier it
They
was-
primarily, the application is that they want to hold it somewhere near the Vidyasagar statue, my lord. My lord, I have identified, my lord, as per the order of 163, the College Square is an exception. So they can do it in College Square, my lord, and they have also.
College Square they have given.
No, they can.
It's adjacent to that place.
Adjacent to that place, my lord, there are two orders passed by the coordinate bench allowing College Square. With certain restrictions, my lord will kindly issue those restrictions.
My lord, we have no problem with College Square. Copy देना. Copy देना.
Order it. এটা কোন order? Copy order আছে? যেকোনো একটা order দিন। Milord, will kindly allow them that what is there, Milord. And those, Milord, was while passing that order, Milord, the coordinate bench kept it in mind that it is a weekend so that there is no disturbance.
No, they are 15 days.
Milord, that, Milord, it will be very difficult for them as well as for the neighborhood, for the people.
Continue till
It is.
15.
Milord, day and night and continuous 15 days, Milord, will become very hectic, and that has never been allowed in Calcutta.
Day and night.
Yes, my lord, continuous.
It has never been allowed.
How the facilities will be provided over there?
Excellent.
The corporation has to provide the facilities also.
Well, there is not a single scrap of paper before the corporation.
Then
No application, no request,
that's what I'm
nothing.
asking. You have not made any application.
No, not a party.
My lord, 10 days, my lord, that is.
Milord, this is, Milord will not
My lord,
allow
10
that.
days.
Milord, 3 days, Milord.
The day, why your night you have?
My lord, what can I say, my lord? These are
It is
associations.
correct, but what about the
My lord,
facilities?
we have reduced 5 days, my lord. We will make.
Okay, no problem. What about the facilities?
My lord,
With regard to the light and the other.
Yes.
My lord, we will make application. My lord, kindly, my lord, mentions that we will make necessary applications with regard to that.
Milord, then that will be subject to those applications.
That's I'm telling. The petitioner has filed the petitioner. Who is the petitioner here?
My lord, Prosenjit Boshak.
The petitioner being the president of
Secretary. Yes.
Being the secretary of Disaster Management and Civil Defense Fighters Association, West Bengal, no? West Bengal Disaster Management Association. made a request to the Chief Secretary and the Joint Commissioner of Police on 22nd of January 2026, requesting for grant of necessary permission to conduct demonstration program and a demonstration program to organize uh, program from 28 January 2026 to 11th of February 2026 continuously by using loudspeaker and erecting stage. Full stop. The request of the petitioner, full stop. Subsequently, on 24th of January 2026, the petitioners have revised their prayer and requested the Joint Commissioner of Police to arrange an opportunity to meet the Honorable Chief Minister of the West Bengal or the Honorable Chief Secretary of the Government of West Bengal on or before 30th January 2026 directly for submitting their representation with regard to the long pending demands of the association. And if the administration will allow to meet the Chief Secretary or the Honorable Chief Minister or the Chief Secretary, the petitioner will withdraw the protest as requested by a letter dated 21st of January 2026. On when it was communicated on 26 January 2026 by a WhatsApp message, the request of the petitioner
email, WhatsApp. Email.
By an email, the request of the petitioner to hold protest was rejected, and accordingly, the petitioner has filed the present application. Counsel for the petitioner submitted that the petitioner is having old grievances which has not been fulfilled, which has not been taken into consideration by the state authorities, and as such, they intending to hold the demonstration day and night sit in peaceful day and night in front of Vidyasagar statue, College Street, Calcutta, University, Kolkata. Police. The counsel for the state has raised objection and submits that the College Street by an order dated 21st of January 2026, the College Street from MG Road crossing to Medical College and Hospital within bracket College Street and Surya Sen Street crossing has been declared under section 160
63
has been is coming under the purview of subsection 2 of section 163 of the BNSS 2023, and as such it is fully so. He further submit that the College Street is a congested area, and from 28th of February 2026, Madhyamik, CBSE and ICSE examination is also been started, and if the petitioners will allow to hold the demonstration on the said place, the school students and other offices and hospitals will be affected. Then counsel for the petitioner.
Also that they have already held a
The
protest.
counsel for the state has further submitted that on 19 January 2021, 2026 and 21st, and from 19 January 2026 to 21st of January 2026, comma, the petitioners were already hold the demonstration at Ramlila Maidan. Ramlila Maidan. And now within 10 days, again the petitioners are intending to hold the demonstration for day and night. Thus, it is not possible for the state to grant permission from every time to the petitioner to hold demonstration.
So that was an alternative provided in place of Hajra mode that we had applied for that 19 to 21.
Yes.
We had applied for Hajra mode, that is an alternative.
And they had accepted the alternative.
Now, as the authorities have rejected the request for holding the demonstration at the college street, and the college street is also coming under section 163 of the BNSS, comma, the petitioner has proposed to hold the day and night sit in peaceful demonstration at College Square at the road facing Bankim Chand Chatterjee Road from 28 January 2026 to
28 is today, man, on and from tomorrow, my lord.
from 29 January 2026 to
till 8th February.
till 8th of February 2026. Full stop.
But our request is it should be till 1st February, because from 2nd onwards the examinations and everything will be there.
Learned Counsel for the state raised the objection and submit that the permission, if the petitioner will apply for the same, the permission can be granted, but not till 8th of February, not till 8th of February. It can be granted till 1st of February 2026. As from 2nd February 2026, the Madhyamik, CBSE and ICSE exam is going to be started.
And it shouldn't be day-night, my lord. It should be a limited, my lord, as had been given
If
priorly.
submitted, the petitioners are intending to hold the demonstration day and night, which will also affect the nearby and the public of the nearby
And
area.
to that effect, a legal submission is the day and night issue is pending in an appeal before the Honorable the Chief Justice. It has yet not been decided.
Now, Counsel for the Parents Submit, they have applied for the holding the demonstration day and night, but the said issue is pending before the Honorable Division Bench of this court. Had the learned counsel for the respective parties perused the application, comma, and the document relied by the parties. Though the rejection order does not reflect any reason why the request of the petitioner for grant permission to hold the demonstration from 28th of January 2026 to 11th of February 2026 is not assigned. But at the time of hearing of the present application, comma, the learned counsel appearing for the state has shown the order wherein it reviews that the college state is coming under, is been declared under 163 of the BNSS, and the college and the Madhyamik, CBSE and ICSE exam is also going to be started from 2nd February 2026. In view of the above, the petitioner is given liberty to apply for holding the sit in demonstration from 29th of January 2026 to 8th of February 2026 before the competent authority immediately, and on receipt of this application, comma, the concerned authority shall allow the petitioner to hold the sit in demonstration continuous day and night within the college square at the ring road facing Bankim Chand Chatterjee Street on and from 29th of June 2020 and 29th of January 2026 to 8th of February 2026. Full stop. The number of participants shall not be more than 50.
No, my lord, we had mentioned that.
We have not mentioned anything.
Application, it says more than 100, my lord, but will not allow more than 50.
100.
The number of participants in the sit and demonstration shall not be more than 70%. Shall not be more than 70%. But Loudspeaker you will not use.
Loudspeaker and stage, my lord, cannot be there.
But till 30 we can use. Till
Police.
30 we can use. Other than that, we will be
As
using a box.
the petitioners are allowed only one loudspeaker and my microphone.
Lord, if their loudspeakers are allowed, the people around will face tremendous difficulty.
Till 30th, there is no.
But the students are there, I will not allow.
But then sound box will be using sound box.
Let them talk among themselves, my lord. Let's not put any sound box.
Repeat and get it in 70 only. Full stop. The speeches capable of inciting violence, proactive speeches and abusive language will not be permitted. Full stop. Name of the volunteer should be furnished by the petitioners to the concerned authority by tomorrow 11 a.m. Volunteer's name.
Yes, yes. Tomorrow, today, if the order is there in the server tonight itself, tonight only will be.
By today, on or before at 8 p.m. 8 p.m. Full stop. The participants in the said program shall act in a manner to ensure that there is no damage to the public property, assault, or on any government servant or any transgression of the law. The participants shall act in a manner to ensure that no inconvenience whatsoever shall be caused to the public at large. No obstruction is to be created to free flow of traffic, free access to any thoroughfare of or building, ambulance, fire brigade, or persons entitled thereto. The participants of the program should be dispersed immediately after the specified date on conclusion of the program. All existing rules in the work should be strictly adhered. The police authority of the concerned police the concerned officer in charge of the police station shall make necessary arrangement so that the petitioner shall not violate any law and the peace of the said area cannot be disturbed.
But only one thing will react to the sound. Since tomorrow the program is starting, we intend to use loudspeaker only for tomorrow, and other than that, we will be using the boxes, but only for tomorrow.
The petitioners were allowed to loudspeaker. This court is not inclined to allow the petitioner to use any loudspeaker due to the reason that from 2nd of February 2026, the board examination is going to be started. Only at the time of tomorrow, when you will start?
From 10 a.m.
Only from tomorrow, only tomorrow at 10 a.m. to 12 noon, the loudspeaker will be allowed.
Till the afternoon, we can.
And 10 a.m. to?
But then we will be able to use only
4 p.m.
Boxes we can use.
4 p.m. 4 p.m. ठीक है?
I'm deeply obliged.
Next.
While under grave urgency, may I speak?
नहीं लाइब्रेरी में कुछ नहीं रहता.
Seniors. We have 22 mentioned what matter, my lord.
Yes.
My lord, that matter of the bank, my lord, where the other side has completed the publisher casual mining, my lord. That bank matter. It was fixed on 22nd, my lord, but for your lordship couldn't take on that day original side matter. Well, fix any day. According to your lordship's bank matter.
While you're under compelling. Serious. Let them come serious. Let no complete.
But any day, according to your lordship, today it's appearing item 150. I can't notice.
Yes.
But any day your lordship fix the matter.
Give the diary to him. He will check the date and he will give the date when it is to be fixed. लिस्ट आई है इसमें नहीं है though the matter is listed as serial number 128 of the today's list, but the learned counsel for the plaintiff, you are for the plaintiff petitioner, counsel for the petitioner has mentioned the matter and submits that by an order dated, submit that the learned counsel for the respective parties already concluded their argument. Only the petitioner has to give reply. And by an order dated 16th of January 2026, this court had fixed the matter on 22nd of January at 3 p.m. But the matter could not be taken up for hearing. Accordingly, placed for fixing another date. In view of the submission made by the counsel for the petition, let the matter appear on 24th March at 3 p.m. Next.
May I be permitted to mention the embarrassment is item 1, but just to keep it for next week, we'll give a suggested order. My learned friends have given us a letter according to the form, the apology. So because there are 2 3 p.m. matters, then basically we want us, at least from our point of view, we want an order. We won't ask for the damages. There should be some sort of, otherwise for justified 20 years of litigation.
Yeah, you got an order?
So we can come back.
As per the submission made by the counsel for the parties, let the matter appear on 9th.
Any day.
9th February. Under the same.
Great.
My lord, under grave urgency, your lordship, I'm mentioning for upgradation, my lord. This is the urgency is that, my lord, item number 142 of today's list, my lord. So, my lord, my 50 years old company is under liquidation before the learned NCLT.
150, 142.
Yes, my lord, item 142, your lordship.
143.
No, my lord, item 142, my lord. Item 142. My lord, actually, my more than 50 years old company is under liquidation process before the learned NCLT. My lord, subsequently, my lord, this auction notice are also published, and my lord, we participated in that. Since my lord, it is MSME, so I am authorized to purchase my own company, my lord, in that process. But in the meantime, my lord, I've been declared as a willful defaulter. Actually, in this respondent, my lord, which I am saying, my lord, it is absolutely in violation of the law. This is just a 10 minutes case, my lord. Otherwise, my company will be purchased by anyone else. And
so, what you want?
My lord, upgradation, just my lord, in the to be mentioned, if your lordship may kindly keep it, my lord. Well, highly grateful. Highly grateful.
My lord, item number 29 of my lord's list today. My lord,
yes.
I'm mentioning of a notice to the other side, my lord. The interim order is expiring today, my lord, and
who is for the other side? 29.
Appearing, my lord. For the defendants, my lord.
Yes.
The interim order is
my lord, the interim order is expiring, my lord, today.
Record and order. Though the matter is listed as item number 29 of the today's list, due to which but the matter could not be taken up for hearing due to paucity of time. Counsel for the petitioner submit that the interim order is still today and wait for extension of interim order. In view of the submission made by the counsel for the petitioner, the interim order is extended till 25th of February 2026 or until further order, whichever is sent, let the matter remain in the.
Let the matter remain in the list.
my lord, can the matter be posted after 2 weeks, my lord? I'm in some personal difficulty for 3rd week of February, my lord. Any date would be, I'll be grateful.
Let the matter appear on 25th, na? Let the matter appear on
25th of February.
5th of February.
Grateful.
But the interim order, my lord, kindly extends till a few days thereafter.
कब दिया और interim order कब तक है? No, then let the matter appear on 25th. Come on then.
The interim order, my lord, in case my lord is not here, by any chance, my lord, there will be in difficulty. My lord, a few days, my lord.
Interim order is till 27. This is the matter on 20. Yes, next.
Deeply
Grateful, my lord.
But under compelling circumstances, my lord, I am
Yes.
mentioning WPO number 16 of 2026. My lord, I am in possession of, my lord, the plot of land given by the board of, my lord, the Port Trust. Now, my lord, the Port Trust, without evicting me, has issued a tender, my lord, for development of that particular premises.
Yes.
Third people now.
Land will be developed.
Yes, but my lord, third people are coming and, my lord, forcefully evicting me. My lord, eviction is a power under the Act. No,
What
no,
is the suit?
no, my lord. Eviction is a power under the Act, my lord. Eviction of Authorized Occupants Act. My lord, I'm just saying, my lord, till that point is decided. My lord, this matter was to appear yesterday, my lord. It has not come. This is a fresh matter appearing for the first time. Kindly keeps it, my lord, any day convenient to my lord's this, my lord.
Why before this court?
Residuary
In
matter.
the Public Premises Act?
My lord,
If
this
it
is
is a
not a
public
matter from the Public Premises Act. This is a matter challenging the issuance of tender by the Port Trust of that particular premises, which I am occupying.
So what do you want?
I am, lord, any day convenient to my lord's kind list.
See my diary and put the date.
No, lord, any day, your lordship, any day. I'm not asking for a time, but lord, any day.
Yes.
Grateful, lord.
Call the list.
My lord, in this matter, I am appearing on behalf of the respondent, my lord. My lord, I have a preliminary objection with regard to the jurisdiction of this matter, my lord. So, my lord, may I be permitted to make submissions, my lord, in this regard?
What is the jurisdiction?
My lord, kindly cease. My lord, here the petitioner challenges this notice, my lord, which is at page 77.
Page
77 of the writ petition. My lord, kindly cease. This notice has been issued under the suspicion that the account in question is a fraud account, and the petitioner has been asked to make their representation with regard to this notice, focus notice. Issued under this notice has been issued by the bank under the RBI guidelines, my lord. My lord, this notice is 22nd October 2026. This notice is basically under challenge. This notice has been issued by the bank from Chandigarh. Bank has already filed original application for recovery of the money in Chandigarh DRT.
These
So,
are on merit.
not on merits, my lord. So, according to me, even if there is any cause of action, whether part or integral part, that is before, my lord, in the Chandigarh or in Punjab and Haryana High Court, before Chandigarh, maybe before Punjab and Haryana High Court, and not before Calcutta High Court. My lord, kindly sees what averment they have made, my lord. Page 56, my lord, kindly sees.
Para 56.
Sorry, para 56, page 26. Page 26, para 56.
Page?
Page 26, my lord.
Yes.
My lord, write the communication dated 22nd October 2024 issued by the respondent number 2 in his alleged capacity as the assistant general manager of the respondent number 1, purporting to be a notice under the master circular dated 15 July 2024, which was received by the petitioner at his address at Kolkata, and said respondent has threatened to take measure against the petitioner who is a resident of Kolkata. As such, this honorable court has jurisdiction to entertain the present application. So, my lord, their contention is that petitioner is a resident of the Kolkata, and this so-called notice was received by the petitioner in Kolkata. Now, my lord, in this regard, whether a person who is a resident of Kolkata and have received a notice in Kolkata, for that reason, whether the Calcutta High Court can have jurisdiction or not. My lord, my lord, this question came up before our honorable High Court, my lord. আমি তোমাকে একটা কপি দিচ্ছি হ্যাঁ আছে তোমার কাছে আছে তোমার কাছে My lord, may kindly have this copy. This is obviously report in CWN, but I have not collected from that. I have taken photographs from the book which were in library because I could not even get it from the SCC online. Oh, sorry. My lord, the question came up here. An order issued by the Bihar control order. Person got affected in Calcutta.
He said the Calcutta High Court is having jurisdiction. This is the division bench of our Honorable High Court is passing this order, my lord. This question, my lord, the division bench of our High Court has held not only integral part, what is the integral part? Because cause of action is not defined in Article 226, my lord. The term cause of action is not defined there, my lord. In fact, Article 226, my lord, kindly sees the amendment to Article 226, my lord. Once may I point out, my lord. My lord, I'm reading the clause 2 of Article 226. The power conferred by clause 1 to issue directions, orders, or writs to any government, authority, or person may also be exercised by any high court exercising jurisdiction in relation to the territories within which the cause of action, wholly or in part, arises for the exercise of such power, notwithstanding that the seat of such government or authority or residence of such person is not within those territories. Now, my lord, kindly sees this judgment of our Honorable High Court says the cause of or to be an integral part, it should be very proximate. I have received a notice and I have suffered.
What is the relation between you and the petitioner?
Petition is a guarantor to the loan, my lord.
Guarantor to the loan.
Guarantor.
Who has taken the loan?
My lord, the company has taken the loan. Petitioner was guarantor. And my lord, our DRT case is also there. We have obtained a decree in the Chandigarh DRT before. We have obtained a decree and we have put it in execution.
Where the loan was granted? Here?
Chandigarh.
Chandigarh. Where the loan amount was transferred?
Chandigarh.
Where from the amount was paid?
Chandigarh.
No transaction from Calcutta?
No.
You sure?
Well, I'll answer this, my lord. But the only thing is that, my lord, your lordship has seen what I have challenged. I have challenged the propriety of the notice. That it is beyond jurisdiction, not in terms of the RBI circular. Now the pleading is the effect of this notice is upon me at Calcutta. That is the part of the cause of action which I have pleaded, my lord. But my learned friend has relied upon this judgment. I'll distinguish this judgment here and now, but kindly look at, my lord, 2014 9 SCC 329. We are covered by 226 sub-article 2. It was a Nawal Kishore Sharma.
Nawal Kishore, I will come to that. I will also come to that. Nawal Kishore Sharma.
Kindly come to paragraph 9.
Nawal Kishore Sharma, an employee received the termination letter.
That's it.
Termination letter.
Whatever
this
it
is the
is.
termination letter in the state of Bihar.
And
that is a fact.
That
is a fact in Nawal Kishore.
Notice purporting to declare my account as fraud. The judgments say, my lord, if I am going to suffer an adverse effect, and that is my cause of action. I have no other cause of action. I am not concerned with the
My lord is well aware. There is plenty of judgments saying that issuance of so-cause notice is not prejudicial.
That is a different point.
A person is not prejudiced by a so-cause notice.
Sir, kindly come to
So question of suffering adverse or effect doesn't arise, madam.
Paragraph. Which paragraph?
Yes, my lord, your lordship will kindly come to paragraph 12. First, my lord, Kusum ingots is quoted. Paragraph 12, your lordship will see. This court elaborately discussed clause 2 of article 226, particularly the meaning of the word cause of action with reference to section 20 subsection C and 141 of the Code of Civil Procedure. Although in view of section 141 of the Code of Civil Procedure, provisions thereof would not apply to writ proceedings, phraseology using 20C of CPC and clause 2 of article being in pari materia, the decisions of this court rendered on interpretation of 20C shall apply to writ proceedings also. Before proceeding, it may be pointed out that entire bundle of facts pleaded does not constitute a cause of action as what is necessary to be proved before the petitioner can obtain a decree is the material fact. Expression material fact is also known as the integral fact. Keeping in view the expression used in clause 2 of article 226, indisputably, even if a small fraction of cause of action accrues within the jurisdiction of the court will have jurisdiction in the matter. In view of then, my lord, paragraph 29 is quoted. In view of clause 2 of article 226, now, if a part of cause of action arises outside jurisdiction of the High Court, it would have jurisdiction to issue a writ. The decision in Khajur has thus no application. Then, my lord, kindly see paragraph 13. In Union of India versus Adani, this court held in order to confer jurisdiction on a high court to enter it must disclose that integral facts clear in support of the cause of action do constitute the cause so as to empower the court to decide the dispute. And the entire or a part of it arose within jurisdiction. What is my cause here? My cause is this particular notice being bad. And this notice has been received here. That is an integral part of the cause of action, my lord. I have no other cause of action here.
May I be permitted? My lord, I will distinguish this obviously, my lord. May I be permitted? Because I was about to place one judgment. I have already placed one judgment, my lord. May I read out from that?
Each and every fact pleaded by the respondent in their application does not ipso facto lead to the conclusion that those facts give rise to cause of action within the court's territorial, unless those facts are such which have a nexus or relevance with the lease involved in the case. So the loan, sanction, transfer, these have no nexus here, my lord. Then, my lord, your lordship will kindly see, my lord, paragraph 17, which is quoted. Then your lordship will kindly see paragraph 14 and 15 again. Also, my lord, paragraph 9 has been quoted of Rajendran, which says that it's a small part of the cause of action which is important. And the cause of action must be, my lord, have nexus. The fact which I am pleading as constituting the cause of action must have a nexus with the original cause of action, nothing else. This is to be. But if your lordship now this judgment, which my learned friend has,
I'm coming, my lord. Let me place it in my humble way, my lord. My learned friend is so desperate to hijack my.
Yes.
If this matter, my lord, if my learned friend has to argue, then I will also cite some other judgment.
Obvious.
Lordship will take it up some other day, my lord, and we'll have since he is raising.
What is the Socus notice?
Yes, but I'll tell you very briefly why I am challenging it. Only one line.
Yes.
But your lordship will see.
Declaring fraud.
Yeah, no,
Not declaring fraud, asking him to represent, asking him to say,
yes. So you first
submit objection.
Lordship will finally come to the circular which I have annexed. Who has issued the notice and who under the circular can issue a notice? Now, kindly come to page 82.
AGM.
Which is, yes, kindly see page 82, which is the clause relating to this show cause notice.
I may also come on that, my lord, but
2.1.1.1 issuance of a detailed show cause notice to the persons, entities and its promoters, whole time and executive director against whom allegation of fraud is being examined. But I do not fall into any of this. Lordship will see in respect of persons, there is 6, note number 6. Kindly see who are the persons. Who include third party service providers, professionals such as architects, valuers, chartered accountants, advocates. They are the third party service providers. And promoters, whole time executive directors. I am only a guarantor. First of all, I do not fall. Then, my lord, your lordship will kindly see who can issue this. Kindly turns to next page, page 83. 2.1.3. Special Committee of the Board for Monitoring and Follow-up of Cases of Fraud. Bank shall constitute a committee of the board to be known as Special Committee of the Board for Monitoring and Follow-up Cases of Fraud with minimum of 3 members of the board consisting of whole-time director and minimum of 2 independent directors, non-executive directors. Committee shall be headed by one of the independent directors and non-executive. So this committee can issue the notice. Kindly have a look, my lord, at page 77, who has issued the notice. Neither an independent director nor executive director. Kindly see, Assistant General Manager, Fraud Monitoring Cell. This committee has not issued the notice. Committee of the board to be known as Special Committee of the Board for Monitoring and Follow-up Cases of Fraud. This is the board which can issue a notice, board comprising of whole-time director and 2 independent directors. So, my lord, this is on the face of it bad. And, my lord, one last point, I say, my lord, your lordship will see chapter 3 at page 84. Bank cannot suddenly issue a notice of fraud. There has to be marking of the account as a red flagged account.
Correct.
Based on red flagging of the account, then there has to be an internal audit or an external audit. And then, my lord, the show cause notice has to come. This is, my lord, your lordship will kindly see 3.1.
Third line, a red flagged account is one where suspicion of fraudulent activity is thrown up by the presence of one or more EWS indicators, alerting, triggering deeper investigation. Then 3.1.4 shall review the status of red flagged account. After review, my lord, then the question of comes, my lord, your lordship will see chapter 4. Credit facility, loan account classified as red flagged account and reporting of fraud. 4.1, in case of credit facility loan account classified as red flagged account, bank shall use external audit, internal audit as per the for further investigation. So that is the prelude. You cannot suddenly issue a show cause notice. So,
yes.
My lord, may I have my answers with regard to the merit, because my learned friend has submitted on merit.
When?
Any day, your lordship.
As prior to that, my lord, kindly allow me to submit on this preliminary aspect on the with regard to the mental
Yes,
ability.
yes, no problem. When you will submit?
My lord, any day subject to any day your lordship finds.
For the
Kindly give me a short protection till that time, my lord. Otherwise, I will have to.
My lord may hear it tomorrow, my lord. Yes. My lord may hear it tomorrow. Because if my lord
the
so
court
pleases,
time,
if my lord so
I
pleases,
can't command
I am
that.
ready.
On the face of it, is
I am ready to make my submissions.
For the respondent, raise the point of maintainability. Raise the point of maintainability. Let the matter appear day after tomorrow.
My lord is fixing any time, or my lord is fixing any time particular?
4:45.
Actually, Fridays are normally 3:30 days. That's why.
But only thing is that, my lord, I will have to answer there. My lordship will kindly give me a short.
Come. That's why fixed day after tomorrow.
Very well. I am only raising an issue of jurisdiction at this stage. Nothing more, my lord.
I am also on that, my lord.
Yes. This matter, my lord, your lordship has heard. This is at Order 7, Rule 11 in the partition suit. My short note is already there with your lordship. Kindly have a look, my lord. I have only.
Acha. Company.
Yes. And limitation also.
430.
Yes, 400. This is the. Oh, Diachilo, na? But I'll just hand over an extra copy if it is not in your lordship file. They had raised 3 points, my lord, barred by limitation. Then it is barred by the Companies Act and no cause of action. So, my lord, with regard to limitation, I had said mixed question of law and fact. Then, my lord, limitation I have also shown from paragraph 29 of the plaint and paragraph 30 of the plaint that I have never accepted in my plaint the deed of so-called settlement. I have said my pleading is, my lord, your lordship will see page 2. I have quoted paragraph 29 of the plaint, which is not at all binding upon the plaintiff.
Yes.
So, my lord, they are saying 2012 is your cause of action. Why should 2012 be my cause of action? You have to read the entire plaint, and my letter I have asked for accounts of the entire business. So, my lord, I have said that the parties are still joint, and I am now asking for separation of status. So, therefore, that is, my lord, the point of limitation.
Okay.
Then, my lord, next page, your lordship will see I have dealt with the cases cited by them. Page 4, I have dealt with the point of bar of Companies Act, 430 of the Companies Act, where I said that once in a partition suit, first the title to the shares have to be decided.
Then go to
whether it is 1/3 or whether it does not, it belongs to them. So question of title cannot be decided in, my lord, the NCLT. I have cited, my lord, 2028 SCC and 2019 they have cited. Then, my lord, non-disclosure of cause of action, my lord, where I have claiming, my lord, partition. My lord, there how can they say that there is no? These are my short submissions, my lord.
Yes.
So, my lord, I am in reply. Now, if your lordship, my lord, recalls, point is twofold. One is limitation and one is, my lord, jurisdiction. To that, my lord, the answer given by the plaintiff is that the limitation has to be from the knowledge and not otherwise. But over here, if you see, my lord, the cause of action pleaded in the plaintiff has gone to the extent of saying that whatever action has been contemplated, it was in the year 2012. Not only this, he also says that there is a settlement which is not binding upon him, which has taken place in the year 2014-15. So he himself gives this fact to the court before the court, saying that he has sufficient knowledge about the contemplation or the acts conducted by the parties, for which he is aggrieved and for which he has come before this court, my lord, seeking, my lord, prayers before your lordship. Now, kindly, before, my lord, I move on, my lord, to distinguish the judgments, kindly have a look at the prayers for once, my lord. Your lordship will find this is not a simpliciter, my lord, partition suit.
Of the CS suit.
Of CS, my lord, at page 35. The plaintiff is annexed, my lord.
Page 35.
Page 35, my lord, the prayer starts.
Yes.
My lord, your lordship will find that prayer A is dependent on prayer B, C, D, and E. Because they are seeking a declaration that the alteration of the shareholding pattern are without authority and not binding. These alterations, as sought for, my lord, in prayer B, C, and D, has been done in the year 2012, and that is their specific case. So, my lord, I have, my lord, taken a point that it is not something of constructive notice, my lord, as it was shown by my learned friend before your lordship. It is simpliciter, my lord, a cause of action which is covered under Article 58 of the Limitation Act. And
in the partition suit, whether
Yes.
it is applicable.
I'm sorry.
The partition suit, it is applicable.
That is
Partition
also
suit.
that is also a question, because in a partition suit, parties, my lord, approach the court on the basis of an antecedent title. Over here, that is the reason why, my lord, I have submitted before your lordship that this is not a simpliciter partition suit. The plaintiff has divested its prayers, and for that, what he has pleaded, his cause of action, will show that rather the whole cause of action is barred by limitation, because introduction of Article 58 in the 1963 Act considers that right to sue first accrues, and he is seeking a declaration. So automatically, if he is seeking a declaration to such effect, it has to be the first right of cause of action, his first infringement of the right. And your lordship recalls, my lord, we have shown judgments to that effect.
Correct.
Now, coming back to the judgments which has been placed before your lordship, my lord, by the plaintiff. Now, the first judgment your lordship will find, this is 2020, volume 8, SCC, page 79. Aruna Oswald. Has my lord got it, my lord?
Just a minute.
So Aruna Oswald, if your lordship sees, 2020, volume 8, SCC, page 79.
Yes.
Now, I have three distinguishing, my lord, fact over here. One is completely different, my lord, facts as compared to the facts, my lord, pleaded in this plate. My lord, over here, there's no question of deciding the title. He says that it was, my lord, a joint company. Thereafter, my lord, from the joint company or from the joint corpus, my lord, several other companies were there. 2012, he admits to the fact that there was a settlement for which, my lord, three brothers have settled amongst themselves. And thereafter, my lord, certain acts and contemplations were done between the partners, between the parties or the brothers. But compared, my lord, in Aruna Oswald, here was a question raised before the court as to the title, my lord, of the plaintiff. So that is the reason why the court has said that no, NCLT or the company law, board cannot decide the question of title. So therefore, you have to approach the honorable court to decide the title.
Correct.
So this is a distinguishing fact and feature over here. The second aspect is here, your lordship will find, kindly takes my lord, they have relied upon paragraph
21.
21.
7.
No, 24.
I think 24, 25.
Yes, 24, 25.
Yes. So 24 and 25, your lordship will find that there's an interpretation of the 241 and 242 of the Companies Act is given.
Yes.
But if your lordship kindly takes me, lord, a little higher up of the judgment, kindly see 6.6, para 6.6 of this judgment.
Yes.
The main dispute raised as to the inheritance of the estate. Here there is no question of inheritance. Lord, we say, or we have not denied that the plaintiff is not does not have a right to inherit. We say that whatever cause of action you have pleaded is simply barred because you are actually canvassing the point of operation and mismanagement. And that has to be decided by NCLT. There's no question of deciding title over here. Because of the reasons, my lord, what has been pleaded in the cause of action, as well as the prayers from B, C, and D. Now, coming back to this, my lord, the main dispute raised as to the inheritance of the estate of the deceased is a civil dispute and could not be said to be an act of oppression and mismanagement. Such a dispute could not be adjudicated in a company petition filed during the civil court's pendency. Thus, the company petition deserves to be dismissed. So, this is the main sum and substance, my lord, on the basis of which this judgment, my lord, proceeds. So, therefore, on these facts, this judgment is not applicable, my lord, and it's not helpful at all, my lord, for the plaintiffs. Now, my lord, kindly takes, my lord, the second judgment, which is, my lord, 2021, volume 17, SCC, page 100.
Yes.
Now, this has been, my lord, shown so as to corroborate the point of, my lord, limitation. They have relied upon paragraph 4, 8, and 14.
Yes.
And it takes, my lord, paragraph 4, 8, and 14. Then, my lord, I will try to distinguish it again. Paragraph 4 says, my lord, in brief, the claim of the plaintiffs in the aforesaid suit was that the person to whom they claim to have succeeded died in the year 1946, leading to some of his heirs filing a suit for administration of the estate left behind him. The said suit being such and such was filed in the original site. By a judgment dated such and such, the High Court appointed a receiver and took over possession and management of the properties. According to the plaintiffs, certain sales to the Agricultural Lands Tribunal and mutation in the revenue records were effected. Hereafter, without the knowledge and behind the back of the heirs and sale and legal representatives, and that the plaintiffs came to know about the same when they made an inspection of the records available with the court receiver. Therefore, the suit was filed primarily for setting aside an order passed by the Agricultural Lands Tribunal in tenancy case under section such and such, and for setting aside for a sale certificate issued under section 32M. So this is simply stated, my lord, a sale took place. There was a proceeding before a tribunal challenging that this proceeding was filed. Now kindly takes, my lord, paragraph 8. Insofar as the rejection of the plaint on the ground of limitation is concerned, it is needless to emphasize that limitation is a mixed question of fact and law. It is the case of the appellant plaintiff that only after making inspection of the records in connection with the suit land available in the office of the defendant number 3, that they came across the correspondence and documents relating to the transaction, and that the proceedings before ALT were collusive, fraudulent, and null and void. The appellant plaintiffs have even questioned the authority of the court receiver to represent them in the tenancy proceedings. Now, paragraph 14. But a defendant in a suit cannot pick up a few questions here, there, from the plaint and content that the plaintiffs have kindly marks it. The plaintiffs had constructive notice of the proceedings and that therefore limitation started running from the date of constructive notice. In fact, the plea of constructive notice is raised by the respondent after asserting positively that the plaintiffs had real knowledge as well as the actual notice of the proceedings in case the plea of constructive notice appears to be a subsequent invention. So this is the sum and substance of this judgment, because the judgment proceeds on the basis that the point of limitation was taken on the ground that sale took place, and under section 3 of the Transfer of Property Act, you had constructive notice. Now kindly have a look at section 3, Milord, of the Transfer of Property Act.
Yes.
A person said to have notice. Under section 3, the interpretation clause, just after actionable claim, your lordship will find a person said to have notice.
Yes.
A person said to have notice of a fact when he actually knows that fact, or when, but for willful abstination from an enquiry or such which he ought to have made, or gross negligence, he would have known it. Then there is an explanation. So basically, Milord, this is in respect of, Milord, registered documents. Say, for an example, Milord, a registered document is, Milord, executed. Milord, there I had, Milord, knowledge. There should be a constructive notice. It is constructed as a notice, Milord, given to the other party who is otherwise, Milord, prejudiced by the execution of that document. Over here, your lordship will find there is no question of constructive notice. Constructive notice is something else. And over here, the plaintiff himself says that there were, Milord, the change in the shareholding pattern, and your lordship will kindly also see, Milord, there's a notice issued by the learned advocate, which is annexed at running page 46, annexure C.
Yes.
This has been written in the year 2022, and they're trying to take advantage of this letter, saying that no, this letter is basically the starting point of cause of action, because I have raised a letter in 2022, I have filed the suit in 2023, so it is within the point of limitation. But kindly have a look, Milord, the contents of the letter at page 48. The second paragraph, that from the year 2008 onwards, you, the addressee number 1 and 3, in collusion and connivance with the addressee number 2 and 4, fraudulently transfer such and such shares of my clients amounting to several crores without the knowledge and consent. So this is one allegation. The next allegation is at page 49. Kindly see the second last paragraph. That with the object to resolve the dispute as aforesaid, a family meeting of the successors of the deceased Radhesham Gupta was held, and one of the brothers-in-law, namely Saurabh Jalan, expressed his willingness to take charge to act as mediator for the purpose of family settlement. And my client, kindly marks this, and my client on good faith has agreed to allow the said Saurabh Jalan to act as a mediator, and ultimately he had sent an email on 25th November 2012, where from it appears that the said Saurabh Jalan has not dealt with all the properties and companies belonging to the deceased Radhesham Gupta and his family, and has not acted impartiality. So basically, let us take, Milord, whatever they are saying is true. This mediation or this settlement has taken place in the year 2012, and that is admitted.
My reference should read the entirety, my lord.
No, I am taking their allegations. I am taking their allegations.
One document results in partition.
I am taking their allegations. So basically, my lord, 2012, he himself admits to the fact that yes, I am aware of the settlement because I have been served by an email, and that is exactly what is pleaded. But he says that that settlement is not binding upon him.
Yes.
And that is the reason why he has sought for a
that's the
declaration.
paragraph 29 of the plain.
Yes, paragraph 29 of the plain. So therefore, my lord, his starting point of cause of action is 2012 and not 2022 or thereafter.
Okay.
The next, my lord, judgment is, my lord, 2015 volume 8 SCC, page 331.
Yes. 9 and 11.
9 and 11 on the point of knowledge. My lord, I am relying on paragraph 5 of this judgment, the last portion. It is only if the avertments in the plaint ex facie do not disclose a cause of action or a reading thereof, the suit appears to be barred under any law, the plaint can be rejected. In all other situations, the claims will have to be adjudicated in the course of trial. So here is a plaint where it is absolutely evident that the cause of action, if any, has arisen, my lord, in 2012, where he himself admits to the fact. So therefore, simpliciter, it has to be rejected because Article 58 will apply because there are no other articles which my learned friend has shown before your lordship. There are no other articles applying, my lord, to the cause of action that has been pleaded by the plaintiff, and none has been shown before your lordship. Article 58 says the right to sue first accrues. It may be, my lord, a series of cause of action, but that does not mean that those series of cause of action will save the plaintiff, my lord, from the point of limitation.
Okay.
For this, my lord, this is paragraph 9 is, my lord, the finality which has been attained in this judgment. Over here, it is 3 years from the date of knowledge as claimed by the plaintiff, your lordship will find. But this will probably not apply to the facts of the case. Over here, something else has happened. And over here, absolutely. The next and the final judgment, which...
No, if he's telling that the 2012 is not binding,
right,
and he has issued the notice on 2022.
Right.
So whether it cannot be a matter of trial, whether this 2012 is to be taken into consideration on the evidence, whether it is binding upon the plaintiff or not.
I understand, my lord, if the plaintiff or the plaint proceeded on the basis that when the settlement took place in 2012, they were unaware of the contents.
Unaware, because he is telling that it is not the case they are unaware. They admitted that they are having the knowledge.
Yes.
Correct.
Yes.
It has not been taken, it has not been given effect to, and that agreement is not binding upon the plaintiff. That's why he is stating that on 2022 he issued the notice for partition and filed the suit.
Very well.
So this 2012 is binding upon the plaintiff or not? What they have raised the question in paragraph 29 of the plaint. It's not a matter of trial whether it is binding or not.
My lord, to this, my lord, the answer which, my lord, I can give is, if my learned friend, my lord, had taken into consideration that with a pleading, substantial pleadings to that effect that, look, what has been done in 2012 is incomplete because these were the properties or these were the shareholding pattern. This has not been done in accordance with the settlement, or the settlement does not take into consideration the other portions of the company.
Correct.
Then obviously would have been a justified case, my lord. But what has been pleaded over here is contrary to what is, my lord, now being projected before your lordship. The plaint proceeds on the basis Simplicitor proceeds on the basis that, look, from the joint corpus, several other companies were created or incorporated. There has been acts and conducts of the defendants which is oppressive and in the sense mismanaged. This has been going on since 2012. In 2012, there is also a settlement which is not binding upon me. Kindly takes me lot the plaint for once, Milord.
Correct. Kindly come to page 29.
Yes.
The defendant number 1 and 2 is seeking to deny the plaintiff's lawful share in the joint companies, properties, business and assets in frivolous and baseless ground, contending that the defendant number 8 to 15 are
Juristic entities and cannot be subject matter of joint properties and cannot be subject to partition.
Correct.
The defendant number 1 and 2 are also illegally contending that the independent right, title and interest of their family members, some of such companies, business, properties and assets which are in fact jointly owned by the plaintiff and the defendant number 1 and 2. In addition thereto, kindly marks this, in addition thereto, the defendant number 1 and 2 are taking shelter of an advice of a mediator, namely Saurav Jalan, which has communicated to the parties
by way of email,
which has communicated to the parties by way of an email dated 24th November 2012, which is not at all binding upon the plaintiff. Where is the prayer?
Next line, please.
Thus, the question of acting in terms of such email by the plaintiff does not and cannot arise. Very well. So he is contending a document which is in existence. He is not denying to that effect.
No.
What he is denying is that document is not complete.
Correct.
Now, if that document is not complete, the only right the plaintiff has is to come before the court and seek for a delivery up and cancellation or a declaration to such effect. Because that is, my lord, what the plaintiff is trying to project before your lordship, that by the help of this document, his right is being prejudiced. So if he projects that before the court, he has to take a proper, my lord, praise in the plaint. That is not there. Now kindly takes, my lord, the praise. A decree of, at page 35, running page 35.
Yes.
A decree of declaration that the plaintiff, the defendant number 1 and defendant number 2 are the joint owners of the company's business, assets, property as mentioned in annexure such and such.
Correct.
A decree of declaration declaring that the alteration in respect of the shareholding pattern and also the directorial pattern and composition of the defendant number 8 to 15 are without authority and not binding upon the plaintiff. So this is with regard to shareholding and directorial pattern. A decree of declaration that irrespective of shareholding and directorial pattern and or composition of the defendant number 8 to 15, the properties, business and assets of such companies and firm, including those of such and such, are joint amongst the plaintiff, the defendant number 1 and the defendant number 2. So he himself says and admits that yes, there is a settlement, but I'm still trying. A decree of mandatory injunction be passed directing the defendants to restore the original shareholding pattern and directorial pattern and the composition in respect of the defendant number 8 to 15. So there is no declaration, my lord, sought for by the plaintiff, seeking, my lord, to declare that family settlement null and void.
No, that's why, if it is not, if he has not prayed for the settlement,
right?
But once he has given and made an averment, it is not binding. So if it is not binding, it will be a one issue. It will be a one issue whether it is binding. If it is binding, automatically should the court.
Very well. Very well. If your lordship is with me on this aspect, that if it will be an issue, then that is exactly, my lord, touching the cause of action of the plaintiff.
Correct.
Now, if it touches the cause of action of the plaintiff, so therefore he himself says that this email has been received by the plaintiff in 2012.
Correct.
So that is his starting point of cause of action.
No, that's why it's if the court find during the issue, yes, that document is binding and he had the knowledge, then the suit automatically go with regard to the binding, so he has not come forward within the time and limitation gone. If the court find during the issue, no, that is not binding. That is not binding. So if it is not binding, he can come at time because it's a partisan suit. That is to be kept in the mind. It is a partisan suit. So he has made a request on 2022. See, it is not binding. You come and partition the suit. Then the court will quote for the decree. Preliminary. What is your answer?
But
on?
yes, the plaintiff has himself invited this honorable court to make an issue that
that's
whether this document is
or
binding or not.
Binding or not.
So he himself wants a adjudication on that.
Correct. So once one thing is been invited in the pleadings,
right?
So whether that can be decided under Order 7 Rule 11.
My lord, may I say this, my lord? Your lordship is now adjudicating, my lord, a point of demurrer on the face and
Point
the
of
pleadings,
demurrer
what
on
is
two
before your
points,
lordship.
on two issues.
Right.
One is with regard to limitation.
Right.
Correct.
Right.
Second is with regard to the jurisdiction.
Right.
These are the two.
Right.
So jurisdiction, if
that's a separate aspect, my lord, because yes,
because once it is come that yes, he is entitled, when the decree, then it will be. Now this issue is with regard to this paragraph 29 only. So your submission is that admittedly they had the knowledge in 2012 itself.
Yes.
Correct. 2012 itself, and they have admitted in paragraph 29, yes, 24 November 2020, this compromise and the email was sent, they had the knowledge. Now he is telling that it is not binding. So whether the 2012 when he came, so he could have been challenged that document within the 3 years. 3 years. So he has not challenged, so barred by limitation.
my lord, I am taking the cause of action as a whole. Because obviously, my lord, there is no second opinion on the proposition which Mr. Sen has, my lord, proposed that no pick and choose, my lord, can be
That's
allowed. Your lordship has to see the avertments as a whole. Now, when your lordship is scrutinizing, my lord, the pleadings or my lord, the avertments in the plain, your lordship will find that there is also paragraph 21, which says that until it is the specific case of the plaintiff, may I just read it out for your lordship?
Until 2011, there was no dispute.
Right. So if it is his case that until 2011 there is no dispute, now all these contemplation done by the parties of alterations of the shareholding pattern as well as the directorial pattern has happened after 2011, and there is a settlement in 2012. So your lordship has to take it as a whole. Now the moment your lordship is taking as a whole, and my lord, article 58 is stating, my lord, so basically it is the starting point of cause of action.
Okay.
The first point. So the first point is, let us, my lord, there can be a benefit of doubt, my lord, when these, my lord, alterations took place or when there is a knowledge. But with regard to the, my lord, settlement process, it is a specific case that your lordship cannot, my lord, bifurcate the settlement with regard to the, your lordship has to take it as a whole, as I, my lord, now the moment the plaintiff says that yes, there is a settlement, and in terms of the settlement, I am saying that these alterations have been done, admitted position as pleaded in the plaint. Now that cause of action or that knowledge is crystal clear from the pleadings that has arisen in 2012. If it has arisen in 2012, there's no question of mixed question of law and fact.
Okay.
It is admitted by the plaintiff. It's I missed my leader today. He was here.
Okay.
We have disturbed your lordship enough on this order 7 rule 11. I think.
So you file the return notes? No.
No.
You'll file or not?
May I just file it?
Hearing concluded, Solicitor Counsel for the plaintiff has filed the return notes of argument. Let the same be kept with the record. Counsel for the defendant prays for time to file return. Let the return notes of argument be filed within 1 week.
1 week.
List the matter on 6th February 2026 under the heading to be mentioned only for filing written notes of argument by the defendant.
All right.
Great.